Court officer? Court officer?
Hello. I couldn't hear it, my lord. My lord. 2015 My lord, serial number 34 and 35. 34 and 35.
Yes.
He has not served the copy. I'm a cavator in this case. They have not served the copies on me on serial number 34. And 35, he did not serve the copies on IA, my lord. I had filed an objection. I need Monday kindly be listed, my lord.
Please wait. Let them come first.
I might be there.
Page wise, okay. 2016.
But I am for the connected. I am for the petitioner in the connected matter. The previous
2016 matter, why do you want time now? Last time it was adjourned, no? So second time, let us see, wait.
41, my lord. My lord, 41, my lord, needs some time to file objection. Petitioner counsel is present.
Next week, man.
10 days.
Date may be given, man.
10 days. Time. Much.
List.
Page number 12, page number 44 to 49. Page number 13, page number 15, page number 1,
Where's the plaint? 31.
father died in 1968. At all, and what really the mother started to have been for partition in 1968. As a matter of fact, social property, Asian property was purchased with mother of the plaintiff, defendant lady, 1950.
How can you reject the plaint? How can you reject the plaint?
By the granddaughter, the granddaughter is not eligible.
That will be dismissed on merits. You're saying the property is that of the grandmother.
My mother purchased 1963, not mother of the apprentice area.
So where is the question of section 6 being applicable if the property is acquired by a female?
So therefore, it's not maintainable. For partition, not maintainable.
That will be dismissed, but
Other property has been divided.
how can I reject the plaint on that ground? That is a matter on merits. For me to reject the plaint on under order 7 rule 11,
From the limitation. Fit out.
if
The partition over. As on the date of death of the father. Whatever the property that stand in the name of the mother of the plaintiff area. Stands in the mother, the name of the mother of the defendant area.
stepmother,
Stepmother,
1963. Suppose she is able to establish that the stepmother had no source of income. And the grandfather was the person who purchased the property in her name, then where do you stand?
It was the name of the grandfather. He had owned the property. Then we may have owned the property here of.
The merits, ಅದೆಲ್ಲ merits ಮೇಲೆ plaint reject ಮಾಡೋಣ ನಾನು ಏನ್ ground? ನೀವ್ ಹೇಳ್ತಿರೋದೆಲ್ಲ merits ಮೇಲೆ.
Limitation that they have not challenged the partition of 2000. It's a digital partition.
From the plaint, if they admit that there's a partition and they should have challenged it.
Page 37. Eight. Sri Munivirappa died in the state on 22/10/1960 without settling scheduled property. Submitted that certificate on 29/9/2000. Once she was the Muniyamma, she wanted to partition KP property. Didn't challenge ಮಾಡಿಲ್ಲ ಅವರು.
ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು ಅವ್ರು ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ they claim that they have acquired a right by birth or the moment the father died, they have succeeded to a share. Where is the question of them challenging the partition?
Not mother. Not mother.
Everything that you are arguing, Ravi, is on the merits of the claim. I should read the plaint on its face and say that there's no cause of action. On what basis can I say there's no cause of action?
Munivirappa told on the southern side of Schedule A property to one female. In the 1950s, on 39 to 1960, this property was again told by Vimaya, second by Munivirappa, this is the admitted position, then either as on the date of purchase of property, that is 1950, or 1968, the day on which the grandfather died, or in respect of the mother of the plaintiff's blood, the right would have been accrued to the mother of the plaintiff's hearing as on the date of death of the father, that is 1968. That is also, it has not been filed again. There is an addition, that there is a partition.
They are saying that's a partition amongst only the sons, we have been excluded. Why should they challenge it? They are saying that I will share the moment my grandfather died or my mother died. They will establish that. Why should they challenge a part?
Then under 90% being challenged, then this will be not vacant.
It is not a registered partition deed.
It is a registered.
No, where have you said it's registered partition deed? Exhibit D now. Where is?
They have produced the documents. They have produced.
Where have you said it's registered in the plaint?
Reflection of that, character.
Where?
Character of my reflection.
No, not in your writ petition. In the plaint, where have they said it's registered?
Yeah, page 36. Female members, apart from the children and grandchildren, first wife, without this share with the members of first wife. In many of the laws of female members, for the second wife, that should obviously participating in the group market and E.
Issue notice. There shall be. Council is permitted to take out notice on respondents 1 to 4 through the council who appears for them in the trial court. Notice to respondent to petition is also directed to take out notice on respondents 5 to 9 through the council who appear for them in the trial court. Relist on 2009 suit ivaga for after how many years? At this stage trial ಶುರು ಆಗೋಗಿದ್ಯಾ? ಮತ್ತೆ ಈಗ ಪ್ಲೇಂಟ್ ಟೆನ್ನಿಸ್ ಏಜ್ ಒಪ್ಕೊಳ್ತೀನಿ ಬಟ್ ನಾಟ್ ಆಫ್ಟರ್ 15 years. ಬೇಡ ಅಲ್ಲ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ ಅಷ್ಟೆಲ್ಲ ತಗೊಂಡ್ ಬನ್ನಿ ಆಮೇಲೆ ನೋಡೋಣ. ಬೇಡ ನಾನು ಆಮೇಲೆ ಕೊಡ್ತೀನಿ ಅವ್ರು ಬಂದಾದ್ಮೇಲೆ ಅಲೋನೆ ಮಾಡ್ತೀನಿ ಅವ್ರನ್ನ ಕೇಳ್ಬಿಟ್ಟು ಅವತ್ತು ಕರ್ಕೊಳ್ಳಿ ರೀಲಿಸ್ಟ್.
Petitioner matters.
ಯಾವಾಗ? Stated that the court fee has been paid. Office to clarify. ಏನ್ ಚಂದ್ರಶೇಖರ್?
As per the government proceedings, they're relying on seeking for developer sites. If they're eligible, we'll consider pass approval.
ಇಲ್ಲ if they are eligible ಅಂದ್ರೆ ಏನು?
Sir, guidelines ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರಲ್ಲಿ. If they fulfill that terms, we'll consider it.
ಇಲ್ಲ why do you say that they are not eligible? Guidelines, ಏನ್ guidelines?
That judgment could be there.
ಏನಿದೆ ಗೈಡ್ಲೈನ್ಸ್?
Page 10,781 developer land ಕೊಡಿ lay of cash compensation ಅಷ್ಟೇ. Page 42 ಇಂದ ಶುರು ಆಗ್ತದೆ.
ಐತಿ ಯಾವ ಗೈಡ್ಲೈನ್ ನಾವು ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡ್ಬೇಕು?
Page 44 ಇಂದ 45.
They are the notified khatedars. On what ground will you say that they are ineligible? Guideline ಮೇಲೆ.
No, I'm not saying that if they're eligible, we'll consider because.
ಅಂದ್ರೆ if ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ತಿರ್ಗಾ ಅಲ್ಲಿ ಇದಾಗತ್ತೆ.
No, because they are the claiming the right from other persons. That is, we'll examine and if they are eligible, we'll consider. That's only my submission. They are not notified.
Is there any rival claimants to this?
No, because I do not know, sir. This first fresh matter.
I'll have it next week, get instructions, because ಅಲ್ಲಿ ಒಂದ್ಸಲ ಅವ್ರಿಗೆ ಬಿಟ್ರೆ ಅಲ್ಲಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ತರ ಆಗತ್ತೆ.
There was a dispute between her and the BD. At that point of time, my lord, if her property was expired.
What is annexure F4?
Annexure F, my lord, after some time, my lord, they are the schedule. My lord, the rest is my property. Now, my lord, what they do is they make a statement before this all, before that my property is not acquired. Surreptitiously, my lord, they change the schedule and my lord give site numbers 3172 and 73, my lord, to my site.
ನೀವಿದ್ದೀರಾ?
BDA.
Government is.
1, 2 and 6, my lord, BDA.
AGA to take notice for
Respond number 3, my lord.
respond number
3.
3.
R for
1, 2 and 6, my lord, is the BD.
Shri Pawan Kumar Ji to take notice for R1, R2 and R6. ಯಾರು ತಗೋಬೇಕು notice?
M.S. Subramani.
Okay, so and so to take notice for R4. Issue notice to R5.
In addition to notice, my lord, I will be.
Council is also permitted to take out notice on R5 personally. You serve ಮಾಡಿದ ತಕ್ಷಣ I'll take it up. As soon as you serve.
Fresh matters is there.
ನೀವು ಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಆಮೇಲೆ. Weeks time is going to do it.
They'll appear for petition. There are weeks time to come to the
Weeks time.
Challenging, doubt after the trial court. There are, tenants that will in the court, along with the institution. The specified value of the food is not mentioned.
You are, can't hear you properly, turn.
No, I'm challenging the rejection of my application for jurisdictional issues at the trial court. The trial court didn't have the jurisdiction because the subject matter is of a commercial suit, and the specified value was not disclosed by the plaintiff in the suit. The suit is not only for the injunction, my lord.
Where is the plaint?
Plaint is at, if you can see the prayer, my lord. Prayer is at page 46.
It's a suit for injunction.
In the clause D, your lord said. The prayer clause says rendition of account. And it also says, the paragraph 31 say that the plaintiff will revise the prayer itself after rendition of the clause of the account for the damages.
The suit is essentially for an injunction regarding a trademark dispute.
Yes, my lord. It is essentially an injunction suit, but if you see the paragraph 31, that says that plaintiff craves the leave of this court, 31, my lord, to crave this court to amend and alter the present pleadings and prayers for relief and pray for damages after rendition of accounts. So it is like an injunction suit. It has been shown as if it is an injunction suit, but it is not an injunction suit. It will eventually lead to damages. That's my first objection to this, my lord. Second objection, my lord, which I have is that specified value and the valuation of the Karnataka Court Act, both are different things, which has been decided in
What report said?
In this court in Ganga Dharappa Munindra Kumar matter, my lords. I can pass on the mail. Please.
Okay.
If your lordship can go to page number 8, paragraph 11. What is contemplated in the act is determination of a specified value to determine the jurisdiction of commercial courts and not the value of the suit as contemplated under the Karnataka Court Fees and Suit Valuation Act. In other words, the specified value is for determining the jurisdiction of the court and not for the payment of the court fee. The payment of court fee will have to be done in accordance with the Karnataka Court Fee and Suit Valuation Act.
What has he said regarding valuation here?
Nothing in law. If you go to page number 45 of their suit, they simply say that the plaintiff submits that for the purpose of court fee, the jurisdiction of the above suit is valued as per Karnataka Court Fees and Suit Valuation Act at 1,000 rupees. And accordingly, court fee of 100 rupees was paid. And this judgment of Ganga Dharappa was further relied, your lordship.
Take me to the provision regarding under the commercial acts which require
Lord,
a specific value to be stated.
my lord. In the judgment which I have just passed on, my lord, the provisions are summarized from yes, my lord. So the commercial suit means intellectual property suits. There is no dispute about it. Then the jurisdiction of the court say, section 6 of the Commercial Court Act, that this commercial court shall have jurisdiction to all suits and applications relating to a commercial dispute of a specified value. Now, this specified value, your lordship, is defined. It has to be determined as per section 12. We say fair market value.
What is the trial court done here?
According to me, lordship, the turnover of the plaintiff is 29,000 lakh rupees. It is at page number 39. So since the turnover admittedly by the plaintiff is 29,000 lakh Indian rupees, valuation cannot be 100,000 rupees.
Where is this notification of the City Civil Court? 26/6/2008.
My lord, I have not attached it. But in all the judgment, in all the orders of the trial court, the similar kind of order has been passed mostly, which I have seen.
Let me have a look at this notification.
Notification, I'm not.
Because the trial court has taken the view that any of this notification, it is a designated court. So the question of jurisdiction would come up afterwards.
Your lordship, but
Not a case of the commercial courts being applicable. They're saying it's a designated court under this notification.
but
So if
notification,
it's a designated court,
No.
then the question of the specified value or the applicability to the Court Fees Act would become irrelevant.
that notification is about the valuation for the purpose of court
There is
fee.
a notification.
I'm not carrying it, my lord.
Then that is a basis and come to para.
I
16.
understand it, lordship. You can adjourn it or give me some short date, I will bring that.
Very list. Notification per se. You have a notification. IPR matters a lot.
All right, my lord.
And proxy counsel appearing for petition. Kindly have it next week.
Lords, I'm seeking to, my lords, prayer seeking to consider annexure A and A1, my lords. They are the claim applications, so writ of mandamus, my lords. My lords, the brief facts, my lords. 4 acres of land was granted to one
Okay, to
Venkata
take
Subbaiah.
notice for R1 to R3,
For the response.
R1. Post file caveat,
No caveat.
No caveat.
Wakalat is.
For KADB, he is appearing.
R4 and R5.
Please, my lord, I take notice for response.
You already filed, I've
Please,
already,
my lord. I have already filed wakalat.
in what is your stand?
Lord, there is a appeal pending before my lord, the Assistant Commissioner. Your Lordship, kindly take page number 47, Lord. F1, annexure F.
F and F1.
Now, in this appeal, it's, the KDB is made a party in a 136 proceeding.
Yes, my lord. Yes, made.
My lords, may I please brief the facts? My lords? My lords, the brief facts is, my lords, the land measuring 4 acres was granted to one Venkata Subbaiah wide annexure B, my lords, Darkas. Subsequently, my lords, the husband of petitioner number 1 and petitioner number 2, they purchased the land in the year 1971, my lords. The said fact is mentioned in the EC at annexure D, my lords. The names of the husbands of the petitioner number 1 and 2 was also mentioned in handwritten RCCs, my lords. Subsequently, when the RTCs were computerized, their names got to be omitted, my lords. To rectify the same, I have approached the Assistant Commissioner's Court wide annexure F and F1, my lords. Only to mention my the names of my husbands, late husbands in the RTCs, my lords. In the meanwhile, my lords, the KADB wide annexure E has acquired my lands. Since my lands, my name was not reflected in the computerized RTC, my lords. My name was not reflected in the.
Your vendor's name was reflected.
No, my lords.
The RTC whose name was
Government.
Kar ಹೆಸರು ತೋರಿಸಿಲ್ಲ sir.
RSU ತೋರ್ಸಿ.
Like government ಅಂತ.
Government ಅಂತನೂ ಇಲ್ಲ.
ಯಾರ ಹೆಸರು ಇತ್ತು ನೋಟಿಫೈಡ್ ಖಾತೆ ಇದಾರೆ.
Lords, no name is mentioned, my lords. Wide annexure, my lords.
The notification.
My lords, annexure E, my lords.
Page 30.
Page 34.
Survey number ಏನು?
37, my lords. Ink page 36. ಅದು ಗೋಮಾಳ ಲ್ಯಾಂಡ್.
ಗೋಮಾಳ ಅಂತ ಹೇಳಿ. Page number 36, my lord.
Ink page 36, my lords.
Serial number 71, my lord. First name itself is not ಗೋಮಾಳ.
ಬಟ್ ಬೇರೆ ಹೆಸರು ಇದೆಯಲ್ಲ ಮುನಿಯಪ್ಪ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ನೋಡಿ RTC ಹೋಲ್ಡರ್ಸ್ ಹೆಸರು ಇದೆ, ಇವ್ರ ಹೆಸರು ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
Deposit the compensation before the civil court then. If there's a claim for this particular land.
Please.
ನಿಮ್ಮ ಅವ್ರೇನ್ ಬಂದು ಅವ್ರು ಕ್ಲೇಮ್ ಮಾಡ್ತಿದಾರಾ?
ಇಲ್ಲ sir, ಅವ್ರು ಮಾಡ್ತಾ ಇಲ್ಲ sir. My vendors are not claiming.
Deposit the compensation amount.
Lord, I seek instruction, Lord, matter is coming for first time, but if already deposited or not.
Lords, may I please, my lords? My lords, ink page 63, my lords. May I please? My lords, similar circumstances, my lords, this honorable court has allowed similar petitions. Right.
Holding what?
Lords, holding that the KADB may consider my claim petition, and meanwhile, I may be permitted to pursue my.
Suppose you give them that right.
Please.
To decide on your title, and they said that you don't have title, then what is your remedy? You want to go and subject yourself to them?
No.
Get instructions. Deposit that compensation into court.
Please, please.
List.
Petitioner is challenging, my lords, the general award, my lords, annexure E, my lords. At page 27, my lord. In respect of the land owned by the petitioner here, my lords, initially, my lords, if lordship kindly peruse dated notice, my lords, dated 4/6/2022, my lords, annexure B, my lord. Award was passed, my lord, on consent, my lords. Consent award was passed, my lords, and compensation of rupees 1.1 crore, my lords, was awarded in favor of annexure B, my lords. B and B1. At rupees 1 crore, my lords, compensation was awarded. However, my lords, unilaterally, my lords, without any basis, my lord. Now, annexure E, my lords, at page 27, my lords, dated 7/12/2022, my lord.
Same land?
Same land, my lords, very same land. If your lordship kindly peruse, my lord.
Is there any reference to the consent award that is passed in this
My
award?
lords, in the general award, there is no reference, my lord, in respect of the land owned by the petitioner. At page number 11, my lords, of the general award, my lords. If your lordship kindly peruse, my lords, serial number 3, 18/1, my lord. Rangaswamy, my lords, and another survey number, my lords, serial number 12, my lords, 69/1. These are the very same, my lords, lands owned by the petitioner, my lords, which are part, my lords, of the consent award, my lords, dated 4/6/2022. My lord, at serial number 3 and 12, my lords, at page number 11 of the general award. Survey number 69, my lords, and
Dated 17/7/12/2022.
please, my lord.
When was the consent award passed?
My lords, consent award, my lords, 4/6/2022. My lords, annexure B, if your lordship.
Annexure?
Annexure B, my lords, I'm sorry, my lords.
It's only a notice.
My lords, annexure B1, my lords, at page 21, my lords. Please, my lords. Pursuant to the consent award, my lords, notice was
It is
issued.
not a consent award. This is a-
5/3/2022.
My lords,
Is it 29 to?
my lords, there is some, my lords, I'll rectify, my lords, there is some mistake, my lords, in production of the documents. Annexure B1, if your lordship kindly peruse, page 21, my lord. B1, my lords.
Hmm.
That notice, my lords, dated 4/6/2022.
No, this is a notice saying that this is the offer that we're making.
Please,
Either
ma'am.
accept it or we'll refer it to, we'll pass an award. We'll refer it to the deputy commissioner. Where is the consent award passed?
My lords, pursuant to passing, my lords, of consent award, this is the notice issued, my lord.
No. Read the notice. It's
Hello, sir.
dated 4/6/22, isn't it?
Please, my lord.
Please read.
ಕರ್ನಾಟಕ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಕಾಯ್ದೆ 1966 ಕಲಂ 28(4) ಅನ್ವಯ ಸರ್ಕಾರವು ಹೊರಡಿಸಿರುವ ಅಂತಿಮ ಅಧಿಸೂಚನೆ ಡೇಟೆಡ್ 11/8/2021 ಪ್ರಕಾರ ಈ ಕೆಳಗೆ ನಮೂದಿಸಿರುವ ಜಮೀನುಗಳನ್ನು ದಾಬಸ್ಪೇಟೆ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶಾಭಿವೃದ್ಧಿ ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಈ ಜಮೀನುಗಳಿಗೆ ಭೂದರ ನಿರ್ಧರಣಾ ಸಲಹಾ ಸಮಿತಿ ಶಿಫಾರಸಿನಂತೆ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ತಮ್ಮ ಪತ್ರದ ದಿನಾಂಕ ರಲ್ಲಿ ಎಕರೆ ಒಂದಕ್ಕೆ ₹1.1 crore ಭೂ ಪರಿಹಾರವನ್ನು ಮಂಡಳಿಯು ನಿಗದಿಪಡಿಸಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ತಿಳುವಳಿಕೆ ಪತ್ರ ತಲುಪಿದ ದಿನಾಂಕದಿಂದ 15 ದಿನಗಳೊಳಗೆ ಈ ತಿಳುವಳಿಕೆ ಪತ್ರದ ಹಿಂಬದಿಯಲ್ಲಿ ಸೂಚಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿ ಭೂ ಪರಿಹಾರ ಪಡೆಯಲು ತಿಳಿಸಲಾಗಿದೆ. ಮಲೋಜ್, pursuant to this notice, my lord.
Please read for
ಮಲೋಜ್, ಈ ಗಡುವಿನೊಳಗೆ ನಿಮ್ಮಿಂದ ಭೂ ಪರಿಹಾರ ಕೋರಿ ಕ್ಲೇಮು ಅರ್ಜಿ ಬಾರದಿದ್ದಲ್ಲಿ ಮಂಡಳಿಯು ನಿಗದಿಪಡಿಸಿರುವ ಪರಿಹಾರ ಧನದ ಮೊತ್ತವು ನಿಮಗೆ ಒಪ್ಪಿಗೆ ಇಲ್ಲವೆಂದು ಭಾವಿಸಿ 1894 ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆ ವಿಧಿ 3031 ರನ್ನು ಕೆಳಕಂಡ ಜಮೀನಿಗೆ ಸಂದಾಯವಾಗಬೇಕಾದ ಪರಿಹಾರದ ಮೊತ್ತವನ್ನು ಸಕ್ಷಮ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಠೇವಣಿ ಇಡಲಾಗುವುದೆಂದು ತಿಳಿಸುವುದು. ಮಲೋಜ್, ದಿ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್, ಇಫ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ kindly peruse, my lords, page 23, my lords, annexure B2, my lord. This is the letter, my lord, dated 21/6/2022, my lord. I have submitted all the documents, my lords, requesting them, my lords, to release the compensation in terms of the consent award, my lord.
This is the reason why I said in that judgment that the deputy, under the act, land acquisition officer is to make an offer.
Please.
If it's not acceptable, it will be referred to the deputy commissioner. Your deputy commissioner decides the compensation and says, if you don't accept it, I'll refer to the civil court. This deputy commissioner is the head of that committee. Then what is the procedure that is being followed?
But this notice, my lord, issued by my lord, the special land acquisition officer, as per annexure, my lord, B1.
What does it say? ಈ ಜಮೀನುಗಳಿಗೆ ಭೂದರ ನಿರ್ಧರಣ ಸಲಹಾ ಸಮಿತಿಯು ಶಿಫಾರಸಿನಂತೆ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ತಮ್ಮ ಪತ್ರದ ಸಂಖ್ಯೆ.
Lord, after my lord.
Fixes the value.
No. After my lord, the price advisory committee, my lord,
What
recommend, my lord.
What statutory power does that committee have? Under the statute, if the person to be compensated and the land acquisition officer are not agreeable on the amount, then you refer it to the deputy commissioner for determination. Here it's a reverse. Special deputy commissioner chairs a committee. An offer is made. If that is not accepted, then you refer it to the civil court.
Lord, deputy commissioner of the district, my lord, headed by my lord, the committee, my lord, the special deputy commissioner, one of the
Show
members.
me the statutory provision for that. Where you can form a committee and the committee decides.
No such, my lord. ಅವಾಗಿಂತ ಇದೇ ತರ ಮಾಡೋದು. ತಮ್ಮದು ಜಜ್ಮೆಂಟ್.
Now, what is the difference between this amount and that amount?
Malots, 1 crore, 1.1 crore Malots is the consent award Malots. Now Malots, the general award Malots is passed at rupees 20 lakhs Malots. 20
How
lakhs.
can it be lesser amount than the money that you offer?
Based on, my lord, the sales statistics, my lord, the date of.
Then you're very. ನೀವು ನಮ್ಮ ಹತ್ರ ಒಪ್ಪಿಗೆ ತಗೊಂಡ್ರೆ 1 ಕೋಟಿ ಇಲ್ಲಾಂದ್ರೆ 30 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ are you not blackmailing them?
Lord, we will refer the matter, my lord, then, my lord.
You
they can
offer
entertain-
1.10 crores. If it's not agreeable, then all right, refer it to somebody for a higher amount.
Lord, that is
How
consent.
can you go below that 1.10 crores?
Lord, that is consent, my lord.
See, now they're in this position where, because they didn't accept, they'll have to delegate for 10 years to get 1.10 crores. This is the way you're blackmailing them.
No, my lord, Lordship, kindly take page number 45. There was a dispute, my lord,
If you make an offer, deposit that amount into court. Then if they are not agreeable, let them go to civil court, let them do whatever they want. You can't, by referring it to the land acquisition officer
but
again,
in
he
some
can't reduce.
cases, my lord, we have deposited consent award, but the reference court, my lord, for the consent award also, my lord, granted interest.
It'll
That
have
will
to be,
the problem.
it'll have to be more than what is being offered by you. It can't be lesser than what you offer. How can you offer 1 crore for 1 acre? And then land acquisition offer pass an award for 30 lakhs? Which is the true market value? When you yourself say, the beneficiary says 1 crore is the value, then
Lord, that is, my lord, decided by, my lord, recommended by the committee, my lord, price advisory.
file your objections. I
Please,
think this is wrong.
Notice.
Yeah, Pradeep Kumar to take notice for respondents. 2, 3. AJ to take notice for R1. Uriya Lakshma Mayara,
Lord, sister of the petitioner.
she notice to R4. This permit to take out notice on R4 personally. ನಿಮ್ಗವ್ರಿಗೂ ಜಗಳ ಇದೆಯಾ?
She has filed a suit, my lord, for
Suit is-
partition.
Suit is.
This is what they'll do. They'll
My
take
lord,
advantage of your.
Please, my lord. Let them, my lord, deposit the amount, my lord, in terms of the consent award. That we are agreeable.
Now they can't,
Please,
because they're passed an award, they can't
Please.
go back to the consent award until I set aside this
Please.
award.
I'll take out hands on.
Lord, to deposit the consent award, my lord, there should be a consensus between, my lord, the
No,
both.
no,
the
I have said, if you make an offer, deposit that money. It's not saying ನನ್ನ ಹತ್ರ ಕಾಸಿದೆ ಕೊಡ್ತೀನಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಆಟ ಆಡ್ಸೋದಲ್ಲ.
Consent
ಇದ್ರೆ
consent ಇರ್ಬೇಕು. ಇಬ್ರದ್ದು consent ಇರ್ಬೇಕು. There is a
ನಿಮ್
dispute.
ಪ್ರಕಾರ ಕನ್ಸೆಂಟ್ ಇದೆ ತಾನೆ?
ಹಾ.
ನೀವು ಡಿಪಾಸಿಟ್ ಮಾಡಿ, ಅವ್ರದ್ದು ಒಪ್ಪಿಗೆ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅವ್ರಿಗೆ ಹೋಗ್ತಾರೆ ಕೋರ್ಟ್ಗೆ. ನೀವು ಅದನ್ನ ಇಟ್ಕೊಂಡು ಇಲ್ಲಿ ಆಸೆ ತೋರಿಸಿ.
ಇಲ್ಲ.
See, this is the classical case where you are depriving them of 1/3, 2/3 of the compensation. Suppose they go to the civil court and becomes 1.5 crores. To the extent of 1.1 crores, your interest is saved. Now, after 10 years, civil court would say, no, when you yourself offered 1.1 crores, it can't be 30 lakhs. I think you're abusing the system.
Lord, invariably, my lord, the consent award, my lord, does not income, my lord.
Consent award, I have my own reservations. There's no negotiation. There is you saying, take it or leave it. You determine it in the manner that you think it is appropriate.
Not mean.
Show me one case in which the claimant said, pay me 50 lakhs and you agreed to pay 50 lakhs. That's not bargaining power. You are in a dominant position there.
I'll file a.
Lord, I'll serve, my lord, the fourth respond. Lordship, may any date.
As soon as you serve, you move.
That's.
Order C number 10.
I am for respondent.
Cause of action illa anta. This particular flat is
As
not mortgaged to the bank.
As per my instruction, they have seized this flat,
No.
though it is fallen to the share of
No,
the
it is
owner.
not seized. ಇಲ್ಲಿ ನಾವು petition ಅಲ್ಲಿ ಹಾಕಿದೀವಿ. I haven't taken any physical possession at all. I have not initiated any surface proceedings against this property.
I'll record a statement, delete him and continue.
ಅಲ್ಲಿ seize ಮಾಡಿದ್ದಾರೆ ಅಂತ my instruction.
He will record a statement that he has not done anything.
Otherwise, he will file necessary application before the trial court to delete.
ಇಲ್ಲೇ ಮಾಡಿ ತಿರ್ಗಿ ಅಲ್ಲಿ ಹೋಗಿ ಅದಕ್ಕೆ ಯಾಕೆ ಇದ್ ಮಾಡ್ತೀರಾ?
I'll
I'll ask him to file an affidavit saying that he has, they
Please.
have no mortgage on this property, they have not seized the property, they are
Yes,
not,
yes. Yes, on
on that
terms,
basis, you make an
please,
application,
please,
file an affidavit,
please.
relist.
Next week.
ಯಾವತ್?
Thursday?
First.
15th I will.
ಅವ್ರ affidavit ಹಾಕಿದ್
My presence.
ಆಯ್ತು 15.
For petition in this case, my lord, certain objections are there, my lord, in respect of section 115 of CRP. Not maintain the maintainability of CRP, my lord. These orders passed, the application 7 to 11A and is filed, my lord, that application was allowed.
Then what should you do? I think RFL.
My lord, RFP, my lord.
Rejection of a plaint includes
The decree, amongst decree, my lord. Just a
What do you
minor.
want
Which time, just, I'll file a necessary petition, my lord, and also file
the petitioner seeks permission to convert this revision into an appeal. He is permitted to do so. An amended, an appropriate appeal memorandum may be filed and other requisite formalities will be completed. For statistical purposes, the CRP is disposed of. File an amended appeal memo and pay the necessary court fee.
Please, ma'am.
This matter, I pay for the respondents. My lord, in this matter, my lord, I have received the file on Wednesday, last Wednesday, my lord. I'll make my return submissions, my lord. That apart,
In the records,
please,
it said he was a principal for 9 years.
please.
That is factually incorrect.
My lord, I'll put it on record, my lord. I'll put it on record, my lord. 1 week time, my lord. Because the
we have been
procedure is that,
dragging
my
on
lord,
this for past-
I'll also tell them, my lord, it was brought to the notice of the court. I'll make my submissions, my lord. on that.
For the past 2.5 years, they have been dragging on, my lord.
Next
No,
Monday,
no question of dragging, my lord.
next Monday,
I know what is the
Please see
result
the order
also.
sheet, my lord.
My lord,
Kindly see the order sheet, my lord.
Monday.
grateful.
No, serial number 13, my lords have called.
Yes,
Serial number 13 and 13.1, my lord, I represent the BDA where they are subsequent purchasers. And in respect of serial number 13.2, your lordships, my lord, had passed an order on 26/2/2024 directing the BDA to file an affidavit. My lord, now an affidavit has been filed. And if your lordship sees the order passed by your lordships on 26/2, in effect, my lord, there were 6 directions. In respect of 4 of them, my lord, they have provided the details, the BDA. In respect of one, my lord, with regard to whether the layout has been formed and whether the sites have been allotted. In respect of these 2, my lord, the BDA have written a letter, the engineer, my lord, to conduct a spot inquiry and give necessary details.
so you are confirming that the land all around has been denotified? Or
But
washed?
to an extent of 20 guntas, it appears it has been denotified. And 30 guntas that has been quashed in respect of that, my lord, has been, my lord, in fact, I must, at the outset, I must bring it to your lordship's notice, my lord. In that, I am not appearing, Mr. Sachin appears, my lord. I am appearing only in 13 and 13.1.
How many matters are here?
There are 3 matters, my lord. 13 and 13.1 are subsequent purchases.
Where is the sketch that you showed Samit last time?
My lords, that case, if your lordship sees, the OS is at,
You showed me a
one-
sketch in the last occasion.
sketch, my lords, was present.
R6,
Yes, my lords.
R6 is in 13 minutes.
that's by the BDA.
In serial number 13, my lord.
That's serial number
13. And I'm
13.
also producing the sketch of, the pictures along with the
no.
denotified ones.
The
my
last
lords.
occasion you showed me the sketch. This is the one, right? The one the BDA.
Yes, my
had
lords.
done.
Yes, my lords. That is in writ petition 17/865.
17,795. So far as that, we have said spot inspection.
I'm also submitting photos, my lords. Your lordships had directed me to submit the photos of the land.
54/1 was 2 acres, 5 guntas. He notified is 20 guntas. Which portion of 20 guntas? In this
Roads.
sketch?
May I just pass on, my lords?
Oh, what was my order? They filed an affidavit in accordance with the.
My lord, it appears as per your lordship's directions, affidavit has been filed, and in respect of two of your lordship's direction, my lord, they have written a letter, my lord, to conduct a spot inquiry, and to the extent, my lord, in effect, your lordships had passed 6 directions, my lord. So whether a layout has been formed abutting the land shown in annexure, so R6, and whether sites have been allotted to anybody in that particular area. In that affidavit, document number 4 is a letter written, my lord, to get a report. Probably, my lord, the Shravan would be able to.
What has happened after this resolution that was passed in 2000?
That in fact, my lord, I do not have the information, because it appears, my lord, that because though I'm not appearing in that matter, only the information which Mr. Shravan has given is that in the trial court, my lord, they have passed an order saying that these lands were dropped from acquisition as per those resolutions, but however, those resolutions do not
What
say
is
so.
that? Why can't you be clear about this?
Resolution, my lords, I have placed affidavit on. From a resolution, my lords, dated 31/1/2000 and 26/4/2000, passed by the BDA Directing Engineer Section, Town Planning Section, Survey Department to conduct a land audit.
This was 24 years ago.
Correct.
And you don't know what has happened there afterwards?
My lords, I secured instruction. What has the
Is
material?
the way the deputy commissioner files an affidavit?
My lords, we have not passed any resolution, because whatever the document which is available on record.
No, it shows that she's very casual in filing of the affidavit.
My lords, I'll file a better affidavit. My lords want to know that whether any resolution is passed for deleting the land is question. My lords want to know.
Because that was their contention.
Yes, my lords.
That resolutions are passed.
Correct, my lords. The resolution which referred by the petitioner, which is on record in the present affidavit. That's what I am trying
Which
to.
is the
impress.
resolution that you referred to?
Yes, he has referred it
two
dated 31.
Resolution dated 31/1/2000
2000
and proceedings dated
26/4/2000. That is where, my lords, that is a part of record in
There
affidavit.
are some tippanis along with this, my lords, which they have not
What about the
produced.
tippani? Come to page number 10.
My lords may kindly see in second serial
ಪ್ರಾಧಿಕಾರದ
number 2.
ಸಭೆಯ
ಪ್ರಾಧಿಕಾರದ
ಮುಂದೆ
ಸಭೆ
ಮಂಡಿಸಲಾಗಿದೆ. ಟಿಪ್ಪಣಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಚರ್ಚೆಯ ನಂತರ 800 ಬೆಳ್ಳಾರಿ ರಸ್ತೆ 3ನೇ ಹಂತದ ಬಡಾವಣೆಯ ನಕ್ಷೆಯೊಂದಿಗೆ ಸಂಪೂರ್ಣ ಮಾಹಿತಿಯನ್ನು ಸಂಗ್ರಹಿಸಿ ಪ್ರಾಧಿಕಾರದ ಸಭೆಯ ಮುಂದೆ ಹೊಸದಾಗಿ ಮಂಡಿಸಲು ನಿರ್ಣಯಿಸಲಾಯಿತು. This was 24 years ago.
ಅದಾದ್ಮೇಲೆ ಏನಾಗಿಲ್ಲ ಅಂತ. That's what I secured instruction.
That means you're deliberately being a part of this entire controversy of ensuring that they develop the land and nothing happens.
So whatever the document which is available on record, last time my lord petitioner has referred to that resolution, which I have placed it on record along with an affidavit. That's all we have got documents. Other than that, we don't have any documents.
ಏನೋ ನೀನು ಅತ್ತಂಗಾಡು ನಾನು ಸತ್ತಂಗಾಡ್ತೀನಿ ಕಥೆ ಆಯ್ತಲ್ವ ಇದು.
ಇಷ್ಟೇ ಇರೋದು. I made an endeavor to secure all documents, but only these documents are. ಅದು ಇದನ್ನು.
Lords may kindly peruse the pictures also, my lords, of survey numbers 54/1.
And it takes you 10 days to find out whether a layout has been formed or sites have been allotted.
Layout form ಆಗಿಲ್ಲ.
Should she not say that? She
My lord,
simply say washes around of saying,
ಅದಕ್ಕೆ
I have asked the ex-engineer to make a
what is
statement.
in reality as on today, what is there ಅಂತ ಹೇಳುವಂತದ್ದು.
Like, ಅವ್ರು ಹೇಳ್ಬೇಕು ತಾನೆ.
inspection ಮಾಡಿ you'll fill.
28ನೇ ತಾರೀಕು ಕಾಗದ ಬರ್ದೀನಿ ನನ್ನ ಕೆಲಸ ಮುಗೀತು ಅನ್ನಕ ನಾನು ಅಫಿಡವಿಟ್ ಮಾಡು ಅಂತ ಹೇಳಿದೆ.
As on today, what is the my notes, we'll furnish this thing. Inspection ಆಗಿ report ಹಾಕ್ತೇವೆ. Reality, what is the exact positions as on land is.
I don't want to summon them and make them stand here. You are forcing me to do it.
No.
This
My lord,
is the-
we-
Deputy
my
Commissioner,
lord, may I just,
will ensure that they are here. And I will pass strictures against them.
My lords, we'll secure the report and we'll furnish the documents. Spot inspection report ಹಾಕ್ತೀವಿ.
And you engage a senior counsel, you don't even instruct him.
My lords, we have no time. It's connected with petitions as well.
my lord, may I make this submission?
Yes.
My lord, though, my lord, I am appearing in 13 and 13.1 in the case of subsequent purchases. However, my lord, since this affidavit may have some bearing on these two matters, and as your lordships rightly said, my lord, that the details and the affidavit has not been filed in a proper manner. My lord, it appears, my lord, that they have done that spot inspection also. The lordship just gives us about 2 or 3 days time, my lord, we'll file that. And with respect to the subsequent purchases also, my lord, we will argue, and any date may be given, we'll argue the main matter itself. my lord.
I listen to your technical arguments afterwards, but I need you to comply with my order first.
Yes, my lord. That's why, my
You
lord.
can't treat this court so
No, my lord.
casually.
No, my lord. Your lordships have, that's why, my lord, at the outset I said in your lordship's order, there are 6 directions. In respect of 4, my lord, the BDA appears to have complied, and in respect of 2, that spot inspection report has to be given. That, my lord, if your lordship just gives us a very short accommodation, probably 2 or 3 days time, we'll have that filed, and then after that, my lord, your lordship may fix a date for hearing whichever is convenient to your lordship.
But if this is the attitude of the deputy commissioner, I will take a strict view of
I understand, my lord, what your lordships are saying. They should have given it by now and taken your lordship's order seriously and given.
Because you made a request that they are collecting information, I granted a week's time.
Yes,
Even
my lord,
after
I had made a request, my lord, and that is the reason why I had asked them. So, my lord, it is only in respect of this, my lord, that they should have by now filed it. But since if your lordship, my lord, only to an extent, my lord, that at least 75% of your lordship's directions have been implemented, my lord, only 25%. That will do it in 2-3 days time, my lord. That's a
That's why
short
I granted you a
accommodation.
week's time for the 25%, not again to grant one more.
No, my
week's
lord,
time.
that was for the entire affidavit, my lord. Within that week, then we complied with 75%. my lord.
An affidavit is filed, which is however not in compliance with the terms of the order dated 26/2/2024. Faced with this situation, then a senior counsel seeks for 3 days' time to file a more comprehensive and complete affidavit. Relist on.
Grateful, my lords.
Please. Oblige.
We are for the petitioner. ma'am.
Who's Arne?
I was on the last date of hearing, my lords had asked the KIDB to take instructions whether or not the consent award had been passed, my lords, in this matter.
I forgot the facts. Tell me the facts again.
Please, my lords, there were 2 references in the trial code, which were under, 2 references, my lords, under section 30 and 31 in the trial code, which came to be closed, although we were a party to the, as objectors, we were a party to the reference. They came to be closed, my lords, on the strength of an order passed by this honorable court in a writ petition, wherein this court was pleased to, my lord, set aside the general award in light of previous decisions and said that consent award may be given in case there is no dispute to the title of the property. My lords, we raised serious disputes in the reference. However, without taking cognizance of that conditional portion of this honorable court's order, my lords, learned trial court closed the 2 references. On the last date, my lords had asked them whether consent award was already passed or not. Also, my lords made a reference saying may not be relevant in this context.
Yes.
My lord, I appear for respondent number 1 and 3 in the connected matter, my lord. My lord, the compensation is not disbursed to anyone. We have received from the civil court. It is with the KDB, my lord, we have not disbursed to anyone.
You have passed a consent award.
Not, my lord, general award. Initially, we passed general award deposited before the civil court, my lord. Some of the claimants has filed a writ petition here, and that the general award came to be quashed and directed us to consider their case under section 29(2).
No, have you now passed a consent award? Are you
No, my
prepared?
lord, general award. We have not.
No, are all of them agreeable for any amount?
No, my lord.
Even the
some of
rival
them-
claimants, are they
Some
agreeable?
of them are not agreeable.
No, no. For dispersal, they will not be agreeable, but for the amount, are they agreeable?
No, my lord.
Your lordship, I am for the impleading application.
In the meanwhile, I have also filed an
want-
impleading application, my lord. That is,
So
I
all
am,
of you agreeable on the amount?
No, your lordship, this.
no, my lord, we
You're
have,
agreeable on the amount?
my lord,
Can
we
I
have,
refer
we
it
have
under
got serious objection, my lord, for the, my lord, I'm the Waqf board. The entire property is, belongs to Waqf board, my lord. That has not been
not-
considered, I have not been issued with notice also, my lord.
This
So I
property
will,
belongs to Waqf, your lordship.
If you will again fight for 30 years, if all of you are agreeable on the compensation amount regarding apportionment, let the matter go to the civil court.
My lord, this is a Waqf property, my lord, which has been notified,
not depriving of
notified as a graveyard, my lord.
So therefore, you will have to establish that right before the civil court, not before the land acquisition officer.
No, my lord, I will have my objection filed, my lord,
For what?
before the land acquisition officer that, my lord, my name has
And he will
not been,
determine the objections.
my lord.
You will determine the objections.
No, they not.
If there are 4 claimants, he has the power to determine the title.
No, he has not, yes.
Then
My lord, even the petitioner, my lord, they are only agreement holders. They are saying,
whether
yes.
they are entitled to compensation or not, that decided by the trial court. But on the amount of compensation, if all of you are in agreement, that is a true market value, it will be one major hurdle crossed. Then only fight for the entitlement.
My lord, now the general award which has been passed by this honorable court and directed, my lord, to determine the compensation under section 29(3), my lord. That,
29(2) is only by consent, isn't it?
yes,
Consent is regard the amount to be paid for the land. If all of you are agreeable to the amount that is fixed,
my lord, in
that
the
amount
in the
is-
same order, my lord, this honorable court has also held that if there is any title dispute, my lord, the general award will prevail.
you people will lose money if you argue like this.
No.
You just saw in the other case, they'll give you 1/3 of the market value. If you agree on the value of the land, that will be deposited in the civil court, both of you fight for that particular amount.
My lord, I will get instructions, my lord, your lordship may kindly have it next week, I will get instructions and make a submission, my lord.
What was the
Because-
consent award for? What was the amount fixed in the consent award?
Yes. Lordship may kindly allow the impleading application, my lord, there.
You have not challenged it, isn't it?
Yes, my lord.
You have not challenged the order of closure of reference.
No, my lord, that is why, my lord, I have,
Why should I
my
allow
lord,
you to come
I
on
came
record?
to know recently, my lord, that this is,
File a separate petition. Why should I allow you to come on record?
Your
In
lordship,
our writ petition.
this property is a gazette notified property, your lordship. Waqf
that is
property.
why, my lord, my name was not shown at all.
You should
Yes.
file a
Yeah,
separate report.
I understand, my lord, yes.
I can
May-
also be technical if you are technical.
Yes, yes.
My lords, I have one submission to.
1 minute. What is the value of the land that you have fixed under 29(2)?
Consent award was 62 lakhs for,
62?
sorry, my lord, 25 lakhs 39,530.
And the general award?
Central award was 6 lakhs 4,463. My lord, may I make a submission? Even after appropriation, they can claim for the consent award, my lord. It is not that if now they can claim, not later. Even
And
after,
you will sit on the money for all time to come.
no, ma'am. Anytime they can seek
Well,
for consent.
I'll make one submission. I'll make one submission. I'm for the respondent number 4 and 5. The petitioner claim is, my lord, in respect of the survey number 73, some sites, my lords, are 19, 20, 21, 22. Here is a case, my lord, where my writ petition was allowed in respect of the properties, my lord, the site number 5, 6, 5 and 6, my lord. That is something completely different. It is not their property.
Who's to decide that?
That, my lord, that is, there is no decree or in,
Who's to decide that?
therefore, my
Land acquisition officer will decide that?
no, my lord. My actual submission is, my lord, where, my lord, the petitioner is claiming that the setting aside of the decree which is relied by the petitioner, my lord, that is nothing to do with
I'm
this.
repeatedly telling you, the entitlement to the compensation is a separate question.
Yes.
Whether you are entitled, he is entitled or she is entitled.
Yes.
That the civil court will decide. But are you people agreeable for the 25 lakhs that the consent award had been passed? If that amount is agreeable, I'll ask him to deposit the amount to civil court. All of you will thrash out your title dispute before the civil court. Whoever succeeds will get that amount. Or else I'll suggest this order, send it back. all of you enjoy for the next 10, 15 years.
I will take instructions, my lord. Any possibility, since, my lord, in first petition, my lord, I am for the respond number 4 and 5. And my lord, today instructed, my lord, two other sisters.
I should stop giving advice and simply pass orders.
I'll know, my lord. Maybe tomorrow or day, I'll definitely will come with them, my lord, the final one. This is, my lord, the multiple litigation, my lord, the way in which, my lord, petitioner is claiming their agreement to sell, my lord, is for the year 1977. And, my lord, their suit is 84. That is in respect of it, site, my lord, 19, 20, 21, 22. But that is nothing to do with my property, my lord.
ನೀವು respond number 1 ಅಲ್ಲಿ
I don't think.
ನೀವು respond number 1. You are seeking for refund of the amount now.
No.
Page number 30.
Please, my lord, after the
How?
quashing of the general award, we sought for an refund.
My lords, in respect of this one particular village, my lords, that was acquired for BMRCL's metro, for reasons best known to them, there are 5 references made to civil court with respect to the very same survey number 73/1A in various land parcels, my lords. Names of the khatedars and claimants in most of these matters are the same. We are now contesting 5 different LACs, my lords, before the trial court, 2 of which came to be closed in this manner. Today, my lords, the BMRCL says your property was never acquired. Your name should not have been there in the reference is the contention that they are taking now via their objections. For the very first time that now they are telling me, my lords, I filed my objections to the KIDB and BMRCL in 2017 and 18. Now they, for the first time in the writ petition, my lords, are saying this property does not belong to you. All of these years spent in litigation are now meaningless. Whereas we don't know, we have even preferred an RTI application asking for the map vis-a-vis this reach number was determined.
Where is the order passed with this court?
Please, my lords.
Where is the order passed with this?
29, my lord.
29 operative portion is at 40 minutes. $39.40.
In operative portion, my lord,
The compensation that is paid for adjoining lands in under 29(2), what is the amount? For the adjoining lands, is there any consent award passed?
Same amount, my lord, 25 lakh.
Where do you get that?
My lord, I have an original file.
File a memo stating what is the amount that is paid as consent award. I'll ask you to deposit that amount into the civil court and ask the civil court to consider all these questions, including their entitlement to a higher compensation and also regarding apportionment. Why should you sit on the money and file a memo as to what is the consent award passed instead of the neighboring lands? Then I'll pass an order.
Lords, if I may.
I will pass an order directing the consent award to be deposited with the civil court. That will be tentative. All of you will have the right to seek for higher compensation and also for determination of your respective title. As and when the civil court decides, the money will be dispersed, including the question of enhancement.
Then your lordship may kindly allow our pleading applications, my lord.
I'm being, giving you a concession. Don't push your luck too far.
Lordship may kindly have a look at this
Yes,
My lords,
notification.
File a
also.
memo.
My lords.
Let him file a memo first.
please, I just wanted to make a submission on that point. My lords, in respect to consent award amount, I have filed, my lords, one application IF 1 of 24, where I have produced the adjoining lands consent award.
Let him file, let him commit himself first.
Please, my only request is, my lords, I'm only seeking an indulgence from this honorable court. If there could be, my lords, a survey, a joint survey with all the parties present.
You do all that in the civil court.
We made a similar application. What they do, my lords, is in the name of an inquiry. They take out all of the OS numbers and all of the degrees.
Not with these people. Let the civil court decide that question.
Please, my lords, in the civil court, I filed an application to that effect. What civil court does, my lords, is accepts an inquiry report with all the various contested litigations.
I'll make it clear the civil court will determine it independently.
My lords,
in connected matter, I'm for respondent number 11, my lords. In connected matter, my lords, maybe served a copy on me, my lords. I
Plus,
don't
we
have a
also
copy.
don't have a copy of this impleading application as of now.
No,
Who's to serve your copy?
my lords, I'm respondent number 11, my lords. Petition has to serve a copy on me, my lords. In connected matter. Sagar BP.
Name the application allow ಆಗಿದ್ಯಾ?
Alla, respondent number 11, my lords.
Yes.
Not an
Who's respondent number 11?
11 in connected matter.
ಯಾರು R11 ಯಾರು lawyer? Sagar BP.
Sagar BP, yes. my lords.
Who's R11?
I'm for R11, R11, my lords.
Another sister, my
My lords,
lord,
he is
another
also,
brother of the respondent number 4 and 5.
You want copy of the writ petition?
yes, my lords. I'm also agreement holder in the,
Not given him a copy of the writ petition?
My lords, they're all claiming through the same LRs of the person. Now we'll give them a copy.
Relist.
My lord, your lordship may clarify that as the consent award is deposited, they are not entitled for enhancement.
How can you,
My lord, once they agree for
I'm
consent,
inclined to hold that once you make an offer,
Please.
the general award cannot be lesser than that amount.
no, my lord, it should be the lesser than, because my lord, I will explain, consent award is one-time settlement. And there will be no dispute between the acquiring body and the claimant. However, my lord, general award, they can check for enhancement. There will be further litigation. That is why we offer more, my lord. Please, my lord. Because
lord,
that
that
is
is
why
assuming
before passing
already
consent
that
award,
we
we
will
offer
seek
more.
I'll consider your argument. File a memo.
May I request for 19, my lord, instead of 18?
19.
Like,
Pleasure.
This matter, my lord, of 6 for weeks time for this reason, my lord. Last occasion, my lord, this court directed to conduct a survey with regard to the, identify with regard to the standing of sandalwood trees and age of the trees, my lord. Today morning, I received the report, my lord, and the concerned officials also present. I will place it on record, my lord, for weeks time, my lord. Survey has been conducted, my lord, as per the direction of this honorable court.
Lord, may I submit? Lord, I appear for the.
Let me look at the order first. You report ready ಆಗಿಲ್ವಾ?
Just now I received the copy of the, I will place it on record, my lord, for weeks time, along with memo, my lord.
AGA submit.
Lord, I appear for respondent number 1, my lord. My lord, this is a for bypass road. My lord, it is 10-kilometer stretch. Out of that, my lord, only 390 meters, my lord, work is pending. Otherwise, the entire work is completed. My lord, now when survey is conducted, my lord, now data is there, my lord. So, my lord, interim order may be vacated, so we can, my lord.
Let him put the report on record. In a DGA
My lord, similar short date maybe.
Survey was conducted as directed by the order dated 15/2/2024. And you will be filing a report within a period of?
Next week, my lord, next month.
Within a week.
My lord, this week, my lord, some date. My lord, it's.
Ask
next
him,
week.
not me, ask him. If you can prepare it, I'll take it up tomorrow.
It's ready, no? You have the report.
Please list on 18th.
interim order be extended.
Interim order to continue to the next.
My lord, I appear for the petition. I appear for petition, my lord. My lord, the office objection is regarding production of certified copy of the notification. I have produced the Xerox copy and along with an application for dispensation. My lord, the earlier, my lord, the.
In IA 1 of 24 prayer.
Yes, my lord, that is for dispensation, my lord, of the notification, certified copy of the notification. 2 IAs were filed, my lord, saying for the same relief. So the-
ಯಾವ IA reject ಮಾಡ್ಲಿ?
My lord, the IA number 2, my lord.
ಎರಡಿದೆ IA 1/24, IA 1/21.
Yes, my lord, IA bar, second IA, my lord. Otherwise.
Since IA 1/2021 and IA 1/2024 are having similar prayers, IA 1/24 is dismissed.
My lord.
IA 1 for dispensation,
Please, my lord.
is allowed.
My lord, as a petitioner, my lord, has earlier approached this honorable court, my lord, as per annexure, yes, my lord, page number 176, my lord. My lord, this honorable court, my lord, was pleased to issue direction to consider my representation in terms of annexure page 176, my lord, 176. 176. My lord, 176, my lord, para 3, my lord. Though several contentions are urged by both sides in respect of their respective contention, having regard to the undisputed fact that the representation at so and so submitted by the petitioner to the respondent having not been considered and no orders have been passed so far, without expressing any opinion on the merits and demerits of the rival contention, I deem it just and proper. Again, my lord, they have issued an endorsement without considering, my lord, in terms of the circular, annexure used the impugned endorsement, my lord. Neither any opportunity of hearing was given, neither, my lord, neither, my lord, the circular was taken into consideration. Just as a, my lord, since, my lord, the notification has been issued and the amount has been deposited in the civil court, your claim cannot be considered. My lord, adjacent land, my lord, very same survey number, adjacent land belonging to my neighbor has been deleted, holding that, my lord, there are horticulture crops. In fact, my lord, horticulture crops is situated on my property, my lord, and the adjacent land is a barren land, my lord. I produced even the photographs as on today also.
Notice ಆಗಿದೆಯಾ?
ಇನ್ನು ಆಗಿಲ್ಲ. It's in notice.
AGA to take notice for
85.
respondent number 1. Shri Chennaigoda to take notice.
2 and 3.
Respondent 2 and 3.
Sought for stay of disposition.
ಏನಕ್ಕೆ ಇದು acquire ಮಾಡಿರೋದು?
My lord, acquired for KDB, my lord, for the apparel park.
They've already taken possession.
No, my lord, they have not taken position.
For ಅದೇ ತಾನೇ ಹೇಳಿದ್ರು.
My lord, kindly see, my lord, photographs are produced, my lord, annexure Y, my lord, page 188. Yes, even today, my lord, horticultural crops are standing on my property, my lord. They want to make this my land as a park, my lord. That was what was told by my client. In fact, my lord, kindly see the pages.
But ನೀವು ಇದು order ಆಗಿ ಎಷ್ಟು ದಿನ ಆಗಿರೋದು?
My lord, this order was
You
passed.
come after 3 years.
My lord, still, my lord, still, my lord, status quo as on, my lord, I have filed in the, my lord, in COVID, my lord, in COVID-19, my lord, it was filed and my lord, it was not, it was filed immediately, my lord.
Let
It
them
was,
file objections. Let
my
them
lord, 29th, status quo,
File
my lord,
objection.
status quo as on today, my lord, as on today, as on for, I am not, even today, my lord, I am in possession. That is. I produced, my lord's photographs also. Recent photographs.
21 photograph ಇದು.
ಹೌದು, ಈಗ recent photographs also there, my lord. Just last month photographs.
No, I'll ask him to get instructions and dispose of petition, ask him to reconsider because no reasons are given. Why do you want to get into this status quo?
Please.
Relist on. The endorsement does not indicate any of his contents are considered.
2 weeks.
After entry order ಕೇಳ್ತಾರೆ.
Status quo on today, my lord.
He has to comply the office objection.
ಅದ್ ಬೇಡಿ ನೀವು ನಾನು ನೋಡ್ಕೊಳ್ತೀನಿ ಇದು ನೋಡಿ ನೀವು. Relist on.
Petition may be directed to survey copy, my lord, because 23 matter.
Members filed seeking for permission to withdraw the reputation. Amount to withdraw the seven said member reputation is dismissed as withdrawn. Liberty ಏನು ಕೇಳಿರ್ತಾನೆ? Petition sign ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದೆ, I hope.
But appear for a petition in this case, the case of allotment of alternative sites. The site was identified and so far the site was not allotted in favor of the petitioner. Last occasion, your lordship has directed the secretary to present before the court.
Yes,
Please, my lord. Statement of objection.
ಸೈಟ್ ಕೊಡಕ್ಕಾಗಲ್ವಾ?
Sorry,
ಯಾಕೆ?
my lord, site was allotted to the petitioner in the Jana Bharat layout, my lord, in the year 2008, my lord. HSR layout was formed in the year 1987, my lord. According to rule 11A of the BDA rule 1984.
When was rule 11A inserted?
Please.
When was rule 11A inserted?
2000. It was inserted on 27/9/2003.
3. And when was the recommendation made?
Recommendation, in the year, site was allotted in the year 2008, man. Earlier, my lord, 2000, in the year 2000, my lord, site was allotted, but it was cancelled.
Thereafter, my lord, he approached the,
Was this recommendation made for 2763?
2022, they have recommended.
How did they make the recommendation in the light of Rule 11A? Yes, reference.
Even in R1 also, your lordship may kindly see their statement of objection.
we have not recommended the site of,
Why was it recommended if there was a rule?
my lord, kindly see annexure F, my lord. It is a fabricated document, my lord. Entire note sheet, my lord, it was
What is
fabricated.
fabricated?
Which is fabricated.
Subject number, my lord, subject number 131, my lord, in the writ petition. my lord. And
Page?
in the writ petition, page, my lord, 12, my lord. And my statement of objection,
The annexure F ತಾನೆ?
annexure F, my lord.
Annexure F is their representation.
There, note sheet, my lord.
ಅಲ್ಲ,
Note sheet is different.
annexure F our writ petition ಅಂತಾನೆ?
ಹೌದು, ಅವ್ರ writ petition ಅಲ್ಲಿ.
Annexure F ಅಲ್ಲಿ
Annexure,
What is the representation that?
sorry, our page number 27.
27.
27 ಅಲ್ಲಿ 27 ಆಗ್ಬೋದು.
Yes.
ನಮ್ದು ರಿಪೀಟ್ ನಮ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ 27 ಪೇಜ್ ನಂಬರ್.
ನಿಮ್ದು 27 ಅನ್ನ?
ನಮ್ದು 27, ಅವ್ರದ್ದು ಪೇಜ್ ನಂಬರ್ 12.
ನಮ್ದು 27. ನಿಮ್ದು 12.
ಇಲ್ಲ ಒಂದ್ ನಿಮಿಷ.
Note sheet starts at annexure E from
How-
page 23.
23, start from 23. So 23, they are not disputing. 24, they are not disputing. 26, they are not disputing. Only 27, they are disputing.
27 ಅಲ್ಲಿ
Only they are
ಸಬ್ಜೆಕ್ಟ್ ನಂಬರ್
27.
134.
27, page 27, 134 is
Subject number?
ಸಬ್ಜೆಕ್ಟ್
Paragraph?
ನಂಬರ್ 134.
Paragraph.
134, page number 27.
134, 135, 136, 137 ಇದೆ ಅದನ್ನ ಹೇಳ್ತಾರೆ.
Entirely different.
Serial number.
ನೀವು ಹೇಳ್ತಿರೋದು ಇದು ಈ page number 26 of their objections, of their writ petition is not in the original record.
ಹೌದು.
No, 27, page number 27 is not in the original.
Come to
But
page 26 of your writ petition.
26, they have not disputed.
Page
26 ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 131 ಇದೆ ಸಬ್ಜೆಕ್ಟ್ ನಂಬರ್, ಅದು ಚೇಂಜ್ ಆಗಿದೆ.
ಅವ್ರು
not
ಹೇಳ್ತಿರೋದು
disputed.
page 26 ಇದೆಯಲ್ಲ?
Yes, sir. 26 ಅಲ್ಲ.
ಪೇಜ್ ನಂಬರ್ ಸಬ್ಜೆಕ್ಟ್ ನಂಬರ್ 131 ಕೂಡ ಚೇಂಜ್ ಆಗಿದೆ, 132 ಚೇಂಜ್ ಆಗಿದೆ.
serial number 135 to 140 ಹೇಳ್ತಾ ಇದೆ. 135 to 140.
ಸುಂದರೇಶ್ ಅವರೇ, ನೀವು writ petition page 25 ಬನ್ನಿ.
25.
ಟಿಪ್ಪಣಿ ಮತ್ತು ಆಜ್ಞೆ ಆ ಕಾಲಮ್ ಅಲ್ಲಿ
25.
page number
That is not disputed.
ನಿಮಿಷ. ಅದರಲ್ಲಿ
131.
Please,
Chair.
one ನಿಮಿಷ.
ಅದ್ರಲ್ಲಿ page 27 ಅಂತ ಪ್ರಿಂಟ್ ಆಗಿದೆ.
25 ಅದು 117,
ರೈಟ್ ಸೈಡ್ ಕಾಲಮ್ ಅಲ್ಲಿ 27 ಅಂತ ಪ್ರಿಂಟ್ ಆಗಿದೆ ಪೇಜ್ ನಂಬರ್. ಅದರಲ್ಲಿ
24 ಅಂತ ಪ್ರಿಂಟ್ ಆಗಿದೆ. 27 ಪ್ರಿಂಟ್ ಆಗಿದೆ.
27 ಆಗಿದೆ.
27.
130 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
130 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
ಅವ್ರದಕ್ಕೆ ಬನ್ನಿ. ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ
ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ
ಅವ್ರು ಹೇಳೋದು ಇದೆ, ಈಗ ಎಂಟೈರ್ ಪೇಜ್ ಬೇರೆ ಇದೆ ಅಂತ.
130 ಇಂದ ಬೇರೆ ಇದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. See, I have collected,
ನಿಮ್ಗೆ ಯಾರು ಕೊಟ್ರಿ ಇದನ್ನ?
I have collected through RTI, CD, entire CD record is there. Even this page is also there. Entire CD. I get it Xerox, all
Sorry,
papers.
my lord.
This is there. The CD is there.
This is the original file, my lord.
How did he get, who gave them the RTA?
I don't
know ಅಂದ್ರೆ ನಿಮ್ಮ ಆಫೀಸ್
ಅಲ್ಲ, ನಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಅದಿಲ್ಲ ಸರ್. ನಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಅದಿಲ್ಲ.
ಡಾಕ್ಯುಮೆಂಟ್ ಇರೋ ತಾನೇ ನೀವು ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು CD.
They have to say, my lord, we have not.
They are saying it. They are
My
saying
lord,
that you
in
gave
the-
them
in
the.
in the original record, my lord, there is no record, my lord. There is no document.
They have removed the
Yes,
pages.
if he has been given that particular CD, which contains a different page number, why can't he argue that you have inserted this page number afterwards?
Sorry, my lord.
No, I am also sorry because you are given an RTA.
Entire file is here, my lord. Entire original.
Please explain how we got that record.
RTA ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದಕ್ಕೆ ಅನ್ನೋದಕ್ಕೆ ಏನು ದಾಖಲೆ ಇಲ್ಲ. RTA ಸೀಲ್ ಇಲ್ಲ, ಏನಿಲ್ಲ ಇದು.
I will furnish the documents.
ಕೊಡ್ತಾರೆ the CD ಅವರು. If it is found that you had furnished that record, what is inference that I should draw?
Even otherwise, R1, your lordship may kindly see, they have recommended. R1, your lordship may kindly see. Page R1. Page 8.
What is original record code?
Annexure R1.
Even they have not furnished acknowledgement also, RTA, the acknowledgement.
When did you make the RTA application?
RTA application.
Acknowledgement ಕೊಡ್ಲಿ ಸ್ವಾಮಿ, ನಾವು ಅದನ್ನ ವೆರಿಫೈ ಮಾಡಿ ಹೇಳ್ತೀವಿ.
ಇಲ್ಲಿ ಎಂಟ್ರಿ ಇರ್ಬೇಕಲ್ವಾ ಅದನ್ನ RTA
ಇಲ್ಲ ಅಂತ ನಮ್ಮಲ್ಲಿ ಎಲ್ಲೂ ಎಂಟ್ರಿ ಇಲ್ಲ ಸರ್.
I will file this detailed statement. I will file statement when I have applied for RTA, when they have furnished the CD.
Where have you, what have you said in your writ petition about the?
Even their own statement of objections, they have stated that this is the site is under 11A. You will not may kindly see R1. And the opinion of the law officer is also there.
Kindly see page number 32 of my statement of objection, annexure F, my lord.
File this along with the.
Yes. Ready to file.
Leonard, the petitioner to state on affidavit. the manner in which he procured the note sheet at annexure E. Learned counsel submits that the petitioner was furnished with a CD when he applied under the RT Act. If so, the petitioner shall also produce the CD released on the Munchi Act. The Deputy Secretary is present and a statement of objections is filed on his behalf. The same is taken on record. Released on. If I find that there's some tampering on either side, then there'll be some.
Please. 19.
And is the resolution of that alternative state committee available on record?
Please, ma'am.
The resolution of the alternative state committee, is it on record?
No, ma'am.
No,
Where is that
everything is there, your lordship may kindly see annexure R1, everything is there. R1, your lordship may kindly see R1. R1, your lordship may kindly see, their own record, according to them. R1, your lordship may kindly see. The opinion and everything is there.
R1 of what?
R1 of a statement of objection.
Filed just
A
now.
statement of objection filed by them. Page 8.
Where is it referred to?
Page 8 ಅಲ್ಲಿ ಬದಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಸಮಿತಿ ಸಭೆಯ ತೀರ್ಮಾನದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹಂಚಿಕೆದಾರರು HSR ಬಡಾವಣೆ
113.
ನಿವೇಶನವಾಗಿ ಹಂಚಿಕೆ ಮಾಡಿ ಕೊಡಿರುತ್ತಾರೆ. ಕಡತದಲ್ಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ನಿಯಮಾವಳಿ ಅನುಗುಣವಾಗಿರುವುದಾಗಿ ಕಂಡು ಬರುತ್ತದೆ. ಸದರಿ ನಿವೇಶನ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿರುವ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತಕರು HSR ಲೇಔಟ್ ಅಲ್ಲಿ ಖಾಲಿ ಇರುವ ಅಳತೆ ನಿವೇಶನವನ್ನು ವಿಧಿಸಲಿದ್ದು CA ನಿವೇಶನ ಭಾಗವಿಲ್ಲವೆಂದು.
Where is the decision of that committee?
And then ಬದಲಿ ನಿವೇಶನ.
Where is the decision of the alternative state committee?
ತೀರ್ಮಾನವನ್ನು and opinion of the law officer.
Kindly see my statement of objection, page number 29.
Page?
29, madam. Annexure R1.
Where is the resolution of that committee?
Committee resolution is there. That I will.
In the original. Page number 129.
I need the resolution, not your noting. The resolution.
Please.
Resolution is also there.
Then despite this resolution, to allot it in a subsequent layout, on what basis was the recommendation made? By whom was it made? Even if that one particular page is ignored, the resolution was clear. ಅದೇ ಅಥವಾ ನಂತರದ ಬಡಾವಣೆಯಲ್ಲಿ ಬದಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು.
Please, the opinion of law officer is there.
Then who made the recommendation to grant this site in HSR layout? The resolution of the committee was clear, isn't it?
So petitioner himself has
Forget about the petitioner. The record does indicate that this particular site was identified and recommendation was made. How can they have made a recommendation in the light of this resolution of the committee? Who was responsible for that? Ask him.
It's a discussion matter. ಅದು ಚರ್ಚೆಯಲ್ಲಿ ಇರ್ತದೆ ಅದು. ಸೊ ಅದು ಕೊಡ್ಬೇಕು.
Resolution clear ಆಗಿತ್ತು. ಇಲ್ಲ ಜ್ಞಾನ ಭಾರತಿ ಲೇಔಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟು
ಅಥವಾ
ಇಲ್ಲ subsequently formed layout ಅಲ್ಲಿ ಅಂತ. Then who made the recommendation that you should grant him a set in HSR layout, which was an earlier layout? Who made that recommendation? Ask him.
Law department has recommend.
How will the law department know which layout? Law department will testify the legality of the allotment. Who identified that? Has any action been taken against them for identifying a site in HSR layout? The next date he will mention on oath as to who was the person who made the recommendation. The Deputy Secretary shall also file an affidavit indicating who had identified site number 2763/C to be allotted as an alternative site to the petitioner. And who was the person who made the recommendation? To solve the problem, if they can find a site in Gnana Bharati layout, it will be better. Or else I will have to do something against everybody because all of you are playing the fool here. He is saying that the records are manipulated. The resolution is deliberately ignored. For the past 18 years, he is still fighting for an alternative site. And what was his fault? If you form a site in one portion of the survey number and another survey number which was denotified, was he responsible? For 18 years, he has to fight for one site.
2008, he was allotted site in the year 2008.
2006 was the layout that was formed, in which one site was in one survey number, the other site was in another survey number, which had been denotified. So you will pay the compensation now for 18 years of delay. You show him a site in HSR layout. He is happy because he'll get a much better site. Now after 22 years, you're going to say, no, you will have to get a site in Nadaprabhu Kempegoda layout. I'll ask somebody to pay for the compensation for the 18 years. Even if he has manipulated those records. This has got to be stopped. This can't be continuing forever. I know how the alternative site committee works. Realist. Gnana Bharati layout on site is identify madukotre. When next date of hearing, the problem is solved. Or else it will go further.
18 by 19th, you're lying.
Milord, on
Please.
previous date of hearing, I was direct. Milord, on previous date of hearing, I was directed to take notice for response number 2, but response number 2, they have, by error mentioned as NHA, National Highway Authority of India, but it is National Highway Division, which comes under state of Karnataka.
You're not.
No, Milord.
Suitably amended.
In this matter, my lord, 6 for weeks time, my lord, to file objections. Award has been challenged, my lord. in this matter.
Pasha submits that National Highway Authority of India has been wrongly arrayed as the second respondent. Who should have been in their place?
National Highway Division.
She submits that the cost study should have reflected as National Highway Authority of India Division.
National Highway
As a
Division.
part of the
National Highway
state government
Division
of
under
Karnataka.
state of Karnataka.
Council is directed, Petitioner's Council directed to amend the cost title suitably. The name of Shri Shilpa Asha be deleted from the array of parties AGA to take notice for R2 also.
Weeks time, my lord, to file statement of objections.
My lord, there's some kind of an emergency, my lord. I will amend the cost title, my lord. My lord, may I have it on 18th, please, my lord.
We are challenging the award.
Award has been challenged in this matter, my lord.
On
On the
what
ground
ground?
that no opportunity has been given
My lord,
for passing
there
award.
was no notice given to us. The first principle, my lord, I was not heard. And more than, my lord,
Reference ಮಾಡ್ಕೊಳ್ಳಿ ತಿರ್ಗಾ ಯಾಕೆ ಇಲ್ಲಿ ಬಂದು ರೆಫರೆನ್ಸ್ ಕೇಳ್ಕೊಳ್ಳಿ ಇನ್ನು ಟೈಮ್ ಇದೆಯಲ್ಲ.
Let me kindly peruse the method they have adopted. They have not even adopted a linear method or a concentrating method. Straight away they come into a curve, damaging my property.
Have you sought for reference to the civil court by giving a representation?
No, because I have not even a clue about the acquisition proceedings and including the award and award notice. My lord, my is a rich cultivated land and
I have to secure records, my lord. I will file objections in this matter.
Relist.
18th, please, ma'am. Please.
Obliged.
Ah.
Number 2 and 3. Lord, file objections, Lord. Lord, I need, Lord, a 10 days time, Lord, in this case.
My objections are filed.
Yes, filed is objection. EWSSB has filed, but the acquiring authority has to file objections.
This is that subsequent you said.
Yes, yes.
Subsequent
But is
purchase
there
of-
on the question of whether.
8th
possession
round
will be
litigation,
taken.
8 rounds, twice before the Supreme Court, now third time before.
ಇವ್ಯಾವ ಆಗ್ತಾರೆ?
Please, ma'am.
On that day, 10 days.
Relist.
25th. Date begin. Huh?
Presentation ನ ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗಿ ತಂದು ಕೊಟ್ಟು ಹೀಗೆ ಕಾಪಿ ಮಾಡ್ಸೋಕ್ಕಾಗಲಿಲ್ಲ.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಅದೇ ಇದನ್ನ ನೋಡ್ಬೇಕು ಅಂದ್ರಿ ತಾವು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದು ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಹಾರ್ಡ್ಶಿಪ್ ಇದೆಲ್ಲ ಹೇಳಿದೀಯಾ ಅಂತ ಹೇಳಿದೆ.
ಕೊಡಿ.
ಅದು ಕಾಪಿ ಮಾಡ್ಸೋಕ್ಕಾಗಲಿಲ್ಲ, ಸಾರಿ. ಇಲ್ಲ ಒಂದ್ ದಿವಸ ಟೈಮ್ ಕೊಟ್ರೆ ಕಾಪಿ ಮಾಡ್ಸ ನೋಡಿ ಇವತ್ತು ತಾವು. ಅದು ಫಸ್ಟ್
2019
ಕೊಟ್ಟಿರೋದು.
ಅರ್ಲಿಯರ್ ಅಲ್ಲ, ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಆರ್ಡರ್ ಆಗೋಕ್ ಮುಂಚೆ ಇದನ್ನೇ ಕನ್ಸಿಡರ್ ಮಾಡು ಅಂತ ಹೇಳಿರೋದು. ದಿಸ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಟು ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅಂತ. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ವಿ ಹ್ಯಾವ್ ಬೀನ್ ಆಲ್ಸೋ ಗಿವನ್ ರೈಟ್ ಟು ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಲ್ಸೋ ತಿರ್ಗಾ ಹಾಕ್ಬೋದು ಅಂತ ಕೊಟ್ರು ಈ ಡಿಸಾನಬಲ್ ಕೋರ್ಟ್. ಇದು 19 ಒಂದು ಆರ್ಡರ್ ಆಯ್ತಲ್ಲ, ಅನೆಕ್ಷರ್ ಸಿ ಅದನ್ನ ನಾವು ಅನೆಕ್ಷರ್ ಬಿ ಪೇಜ್ 60 ಪೇಜ್ 60
30/11/2019 ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇದು ಯಾವ್ದೋ
ಅದೇ
ಇಲ್ಲ 1910 ಇದು 1910 1310
ಸೀಲ್ ಹಾಕಿದ್ದಾರೆ, ಬೇರೆ ಡೇಟ್ ಏನೋ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ
ಕೊಟ್ಟಿರೋದು ಬೇರೆ
ಈ ಆರ್ಡರ್ 30/11/2019 ಇದು ಯಾವ್ದೋ ಬೇರೆ ಕೊಟ್ಟರು. ದಿಸ್ ಇಸ್ ನಾಟ್ ದಿ ರೆಪ್ರೆಸೆಂಟೇಷನ್.
ಅದಾದ್ಮೇಲೆ ನಾವು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ, ಲೀಗಲ್ ನೋಟಿಸು.
ಇಲ್ಲ ಇದಲ್ಲ, it's not 30/11/2019 because page 56 he again says on perusal of the representation dated 30/11/2019 annexure be submitted by the petitioners.
ಅಲ್ಲ ಫಸ್ಟ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇದೇ ಕೊಟ್ಟಿರೋದು 1910.
No, the order of this court was clear.
Yes.
30/11/2019 represent consider ಮಾಡಿ ಅಂತ.
ಅನೆಕ್ಷರ್ ಬಿ ನಲ್ಲೂ ಇದೆ.
Please come to page 56.
ಅನೆಕ್ಷರ್ ಬಿ ಬಂದು ಇದು ಫಸ್ಟ್ ಆರ್ಡರ್. This is dated 17th September 2012.
Page 56 ಬನ್ನಿ, page 56.
Page 60 60.
56 ಬನ್ನಿ ಒಂದು ನಿಮಿಷ. 56
56 11/19 56 56 ಇದು ಈಗ ಆರ್ಡರ್ ಮಾಡಿರೋದು.
ಅದರ ಓದಿ ದಯವಿಟ್ಟು on perusal.
On perusal of the representation dated 30/11 19 annexure B ಅದೇ ಅದು ಕಳಿಸ್ಕೊಟ್ಟಿದ್ದಾರೆ ನಾನು ನೋಡಿಲ್ಲ ನೋಡಿ ಕೊಡ್ತೀನಿ ಇದನ್ನು ಕೊಡ್ತೀನಿ ನಾನು ಇಲ್ಲ ನನಗೇನು ಐ ಡೋಂಟ್ ಹೆಸಿಟೇಟ್ ಐ ಫರ್ನಿಶ್
ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿರೋ ಪ್ರಕಾರ ಈ ಮೂರೇ ಗ್ರೌಂಡ್ ರೇಸ್
ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಇದ್ರೆ ತಾವೇನಾದ್ರು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೋದು ಇಲ್ಲದೇ
ಅವ್ರ ಗವರ್ಮೆಂಟ್ ಅವ್ರು ಈ ಮೂರೇ
ಅರ್ಥ ಆಯ್ತು ನೀವು ಹೇಳಿದ ಅರ್ಥ ಆಯ್ತು ಇದು ಇದ್ರೆ ಮಾಡ್ಬೋದು ನೀವು ಇಲ್ಲದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಅನ್ನೋದು ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಬಟ್ ಈ ಪೇಪರ್ ಇವಾಗ ಬಂತು ನನ್ನ ಕೈಗೆ ಈ ಪೇಪರ್ಸ್ ಬಂತ 14th ಹಾಕೊಳ್ಳಿ ತಾವು 13ಕ್ಕೆ ಹಾಕೊಡ್ರಿ ನಾನು ಸುಮ್ಮನೆ 13ಕ್ಕೆ ಇರ್ಬೋದಾಗಿತ್ತು 14th ತಾವು ಅದೇನೋ ಇದ್ರ ಮೇಲೆ ಹಾಕಿದ್ರಿ 13th ನಾನು ಏನೋ ಐ ಸಾರಿ
I pay for the petitioner. ಹಾಕಿದ್ದೀನಪ್ಪ ನೋಡಿ CEO. It's a suit pending, acquisition ಇದೆ. Till the disposal of the suit ಏನು ಕೊಡಬಾಡಿ ಅಂತ.
Who appears for the respondents?
I filed ವಕಾಲತ್ recently.
ನೋಡಿದಿರಾ?
ಇಲ್ಲ ಇವಾಗ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
Next week ರಿಲಿಸ್ಟ್.
ಅಲ್ಲ ಅಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ ಸರ್ವ್ ಆಗಿದೆ.
ಫೈಲ್ ಮಾಡಿದ್ವಿ ವಕಾಲತ್. I filed ವಕಾಲತ್ ಮೇಲೆ.
Kenegoda has entered appearance on behalf of respondents.
223 ಆಗಿದೆ. 4th ಹಾಕ್ಬೇಕು 8 to 5.
On behalf of.
I already filed 2 and 3 ಮೇಲೆ.
Kenegoda accepts notice for respondents. 2, 3.
Special and acquisition 8 to 5 ಮೇಲೆ.
He submits that he has already entered appearance on behalf of R2 and R3. Relist on.
I have sent the copy, my lords, on the council.
Because of the civil disputes, my lord, they are given that endorsement, my lord. If they compromised or they have withdrawn that civil dispute, my lord, you will disburse the amount as per the 20-2, my lord.
What is annexure A?
Annexure A, my lord, the issued by the respondent, date number 11, my lord, dated 20th/11/2023. The civil dispute is pending before the parties in OS number 168 of 2020. Third paragraph, my lord.
ನ್ಯಾಯಾಲಯದ ಹಿಂಪಡೆಯಲು ಅಂತ ಕೇಳಿದ್ರ ನೀವು. What was your request?
Request, my lord, the amount has been deposited by the respondent before the LAC court. That amount has to be released in favor of the petitioners, my lord. And they have given the endorsement stating that, my lord, the civil suit in OS number 168 of 2020 is pending.
How can they withdraw the amount in deposit?
The subject outcome of the result in.
ಹೆಂಗಾಗತ್ತೆ? ಒಂದ್ಸಲ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ವಾಪಸ್ ತಗೋಬೋದಾ?
There is a direction, my lord, sir.
If the award is quashed, my lord, if the direction was given by this court, my lord.
Annexure D is the direction.
withdraw that
Annexure
amount.
D, page number 32, my lord.
Only thing is, my lord, they have to settle the disputes.
Para number 7, my lord. Page number 32. In the light of the same, the general awards at annexure A and A1 in so far as the petition's lands are concerned are set aside. Respondent KADB is directed to consider the request of the petitioner.
Needless to say, in the event of any dispute, general award would stand restored.
Restored.
ಮತ್ತಿನ್ನೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
The subject outcome of the result of the OS, my lords, the
ಏನ್ ಮಾಡ್ಬೇಕು?
amount in deposit may be dispersed, my lords. In
ಹಿಂಗೆ?
the
ಹೆಂಗಾಗತ್ತೆ ಹೇಳಿ? The prayer in this petition is for washing off the endorsement dated 2011-2023 and the ಎರಡು ಅದೇನ ಸೇಮ್ ಡೇಟಾ?
Yes, my lord. Annexure A, A1 and A2
Endorsements dated 2011-2023
and A3.
which are produced as annexure A1, A2 and A3. In the said representation, in the said endorsement, the KADB has stated that would be impermissible for it to withdraw the amount that it has that it had deposited to the civil court in view of OS 168/2020, which had been instituted by Srimati Papamma and Lakshmi. Next, this court in WP 15771/2023, by an order dated 25th of July 2023, had set aside the general awards and directed the KEDB to consider the request of the petitioners for availing compensation by way of agreement as provided under section 29(2) of the Act, and to pass necessary orders within a period not later than 3 months. So this court also had permitted KEDB to withdraw the amount that had been deposited by it pursuant to general award of the jurisdictional court. However, ultimately, this court stated as follows, page 32. In view of the above, since there is admittedly a dispute pending adjudication before the civil court in verse 168/2020, the order passed by this court in WP 15771/2023 would in fact restore the general awards, and there will be no question of determination of compensation by way of agreement as contemplated under section 29(2) of the Act. And therefore of the view that the endorsements which are impugned in the petition cannot be found fault with. Consequently, the petition is dismissed.
I have filed the wakalat kindly.
Yarage
Gopal. Respondent.
has entered appearance on behalf of respondents 2 to 4, Alva.
Respondent, only one respondent. has-
Therefore, for the respondent.
Sorry, Mother, to Lordship may kindly grant 1 more week time to comply the office objection, Mother. 25 same,
Weeks time.
please, Mother. I'm sorry, Mother.
Matter where we had filed an application for rejection of the plaint partition suit under 11D block. Last time I had pointed out the judgment of this honorable court. That, my lords, of course, has been upset. My lords are set aside by the honorable Supreme Court, but on a different ground, though not on any of the grounds.
That can't be a proposition now.
That's not a proposition, of course, my lords. I will not rely on that. Supreme Court Suraj order set aside ಆಗಿದ್ದು. I'll just pass on that order copy. Suraj order set aside ಆಗಿದ್ದು ತೆಗೆದ್ರಲ್ರಿ ಪ್ರಿಂಟ್ ಔಟ್.
Apart from that, ಬೇರೆ ಏನಿದೆ ಏನಿಲ್ವಲ್ಲ?
My lords, no. My lords, I would only submit. That's 2 things subject to my lord's consideration. The 11D, my lords, this is the order passed, my lords. So there they have gone into the issue of forgery, but not other issues. Now, my lords, under section 100, article 110, my lords, the limitation period is 12 years from when he is denied, my lords, the right to a share.
What is limitation?
Limitation Act. ಇಷ್ಟೊಂದು ಜನ ಕೂತ್ಕೋಬೋದಿಲ್ಲ, ಕೂತ್ಕೊಳ್ಳಿಲ್ಲ limitation. ಕೂತ್ಕೊಳ್ಳಪ್ಪ. 110 if your lordship sees. I want that judgment of Fulvadi Ramesh and Ramana. I mean, sorry, the other one I checked is Pillai also.
Does the plaint admit that she was excluded from the joint family property? Or does she state that she was in joint possession?
No, she only, my lords, it's a very vague plaint if your lordship
No,
sees.
but if she admits in the plaint,
She admits about the sale deeds having taken place from 2004.
she says that she has been excluded from the joint family property, then
No.
I'll accept.
My lords, that, my lords, I would submit like this, my lords, subject to my lord's correction. Now, my lords, 110, the issue is, my lords, when she has been excluded or what?
That's
Now,
what I
if
said.
there are
In the
sale
plaint-
deeds,
In the plaint, if she says that I was.
she does not say so, my lord. She says, I came to know about the transactions only in November. But then, my lords, the courts have interpreted once there is a sale deed which is executed, that amounts to a constructive notice, my lords. And if there is a constructive notice that she's been excluded from her share and there have been alienations, now,
That
my
is
lords,
on
the
the
point.
merits. For the rejection of the plaint, that is on the merits. that she had constructed notice, etc., etc. That can't be a ground to reject the
My lords,
plaint.
I
That is a
would
determination on the merits of the claim.
Now, my lord, that's the issue. Now, if there is a sale deed from 2004 onwards, if that amounts to constructive notice, if the law is that the sale deed, registered sale deed amounts to a constructive notice, then 12 years starts from 2004
They
onwards.
said that's a determination on the merits of the claim.
My lord, not
For me to
if
reject
it is
the
a
plaint.
limitation point, my lords, on a limitation point. Now, under 11D, it is a question, my lords, that limitation can be considered by the courts. The court below, trial court also says,
If you, that's why I said, if you show me a paragraph, an averment in the plaint saying that she admits that she was excluded from the.
my lords,
plaint,
all that she says is all partitions have taken place, gift deeds have taken place. In the plaint is as
Difference, how can we draw that?
my lords, only point for my lords, if your lordship sees the cause of action, what she says at page, my lords, running page 79. My lords, 77, your lordship may come. The last sentence in 77, that's para 25 of the plaint. My lords, running page 77, my lords. And the trial court holds, my lords, that only one defendant has filed the application, others have not filed the application. That also can't be a ground, my lords, for rejection of my application. That's para 25, page 77. That's the 28. '27, my lords, the 25 and 28 would probably. The other pages are missing. This says fresh partition is required. At page 78, my lords.
Page 78.
78 on top, my lords.
Till the suit.
Till the suit schedule properties and the undivided family and with possession and enjoyment of plaintiff and defendant 1 to 2, 10, due to the same fresh partition of the scheduled properties.
She says she's in joint possession.
Well,
How
that's
can
the our.
How can you bring in article 110 to say that in the plaint she admits?
Well, then para 28 also. Plaintiff submitted till date, there is no registered partition. She says no registered.
As such, the plaintiff and defendants 1 to 10 are in
Are joint. That she says, that my lords, that is
She
how.
had admitted that she was excluded.
No.
In the year 2010.
My lords, that's from what I am trying to establish.
I understand what you're trying to tell me, but I can't reject the plaint on that ground.
My lord, because if 110, my lords, if sale deed is taken as a constructive notice, and if possession has
Determination on merits, Pranindra, I can't go into that question. I'll have to hold on a question of law. The consequence of this pleadings is that is not what Order 7 Rule 11 will contemplate. On the bare reading of the plaint, I should be able to reject the plaint.
Lords, I was only trying to make out that if the plaint itself shows that from 2004 onwards, there has been sale deeds and gift deeds, and she says a fresh partition has to take place. The words used are fresh partition.
That's a tribal issue, whether she's entitled for a fresh partition or not. That can't be a ground to reject the plaint.
If it is constructive notice, 110, 12 years from 2004 is what I was trying to make out, and that's what the courts have held. That if there is a notice, then it should start, the clock starts ticking. That, my lord, the very fact that sale deeds have been executed, gift deeds are executed, that means she has been excluded from the, that's how the courts have interpreted. Otherwise, my lords, probably, my lords, I would only request an issue needs to be framed on the issue of.
That is, you will take a defense and they'll frame an issue.
That, my lords, that is.
This petition is filed challenging an order by which the trial court has refused to reject the
permit
plaint.
us to withdraw then.
For the petitioner seeks permission to withdraw the petition, the civil petition. As requested, revision is dismissed as withdrawn.
How can, that's the rest.
For the response, it's covered by judgment, last occasion as submitting.
Pasoran, Allah. Pasoran.
Or Hagos. Rana. This all connected matters, Rana. The same cause. On submission. The same covered by judgment, same they have to challenging all the petitioners and the parties in the earlier petition.
That has been,
Only all
Writ
the
appeal is filed.
family members. All the
writ appeal is
family-
pending,
You're challenging annexure B.
Yes,
Yes.
That order, it is in writ appeal,
What is annexure B?
Amended petition has been filed. We are questioning the preliminary notification, final notification, and the award. You have not been made a party to the entire proceedings. Now the compensation is sought to be paid in favor of some persons who are not connected.
No, you're challenging the notification issued under 3J.
Yes, please.
3A, 3D, and award.
On what ground?
My lord, we have not been made as a party to the proceedings. The record of rights.
They are not made parties?
You are made a parties, all the land acquisition offices, they have made a parties in that they have already taken that. Prana, what happened is all the family members, they have one fellow is filing a withdrawal, then again you have to fill. Kindly see that is, I pursue that. One Ramana, like one other, is also all the connected mind, Sampa Shetty, one another connected.
Was the notified Katha at for the national highway authorities?
Annexure A is the RTC. It shows that Muttakke was the owner.
Now, what is the survey number that we are concerned with?
163.
167, part 2.
That is the name of Srinivas Naik.
Yes, please.
Srinivas.
ಒಂದೇನಾ 167
ಹೌದು ಅಲ್ಲ ಇನ್ನು ಬಾಕಿ ಬೇರೆ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಬೇರೆ ಬೇರೆ
ಇಲ್ಲ ಯಾರಾದ್ರು ಹೇಳ್ಬಿಟ್ರೆ ಅದು
ಇದು ಫಸ್ಟ್ ಪಿಟಿಷನ್ 167 ಬಾರ್ 2 ಶ್ರೀನಿವಾಸ್ ನಾಯ್ಕ್ ಅಂಡ್ ಅದರ್ಸ್ have been shown.
ಆಮೇಲೆ
They have got only right in respect of
tell me the lands first. Tell me the lands that are involved.
ಇನ್ನೊಂದು 168 ಬಾರ್ 10 ಅದು ಶ್ರೀನಿವಾಸ್ ನಾಯ್ಕ್ ಅಂಡ್ ಅದರ್.
Then
112 bar 111 P12, my lord. 112 bar 11 capital P12. Measuring 1.5 acre.
112 per 11.
112 bar 11 P2, my lord. That is insofar as WP.
The notification only talks about 112 bar 1.
Yes, my lord. This survey number is in respect of survey WP number 23851.
One notification, same notification.
Same
notification.
112 bar 11 was the land.
112 bar 11 P12, my lord.
The P12 ಅಂತ ಇಲ್ಲ, but 112 bar 11 ಅಂತ ಇದೆ. Serial number 1. That's the name of Maya Devi.
Malata Devi. Yes,
Muttaka.
Earlier writ petition is also one of the party.
ನೀವು ಯಾರು ಅದರಲ್ಲಿ ಮಾಯಾದೇವಿ is the petitioner there?
Mayadevi illa.
Alti Devi.
Tampa Shetty, my lord. That is WP number 23851. That is the petitioner. Her survey number is?
There are 4 writ petitions.
Yes, my lord.
Five writ petitions.
Yes.
Another one is, my lord, Saroja Hegde, that is, my lord, 168 bar 13 P2. Saroja Hegde, that is, my lord, 10900 WP.
168?
168 bar 13 P2, 168 bar 30, and 168 bar 44 P2. It is mentioned in the schedule of the writ petition.
68 bar 13,
13 P2.
30.
13 P2. 46 cents. ಮತ್ತೆ 168 ಬಾರ್ 30
Standing of Shetgarthi.
Saroja Hegde, my lord. That is in WP number 10900, my lord.
No, the notification says 168 bar 13.
How?
It stands in the name of Shetgarthi Maya Devi.
Maya. Well, artists I have produced, my lord. This is Saroja Hegde. That is my grandmother.
ಇಲ್ಲಿ three ಸರ, four
three servo numbers, my lord. ಅದರಲ್ಲಿ three servo number ಇದೆ.
ಇಲ್ಲಿ ಅದೇ ಹೇಳ್ಬಿಡಿ ನಾನು ಬರ್ಕೊಳಕ್ ಈಸಿ ಆಗುತ್ತೆ.
Please, my lord, please, my lord. 168/13 P2 measuring 46 cents, 168/30,
30.
32 cents. And 168/4 P2 74 cents.
168/30 ನೋಟಿಫೈ ಆಗಿರೋದು 0.067.
168/30 32 cents. ಮತ್ತೊಂದು 168/4 P2. 4 capital P2 measuring 74 cents. These three are numbers involved in WP number 1090. These three servo numbers are involved in WP number 10900, my lord.
That's standing name Bharati Shetty.
Yes, my lord. And the next one, that is WP 3779.
First land scope ಆಮೇಲೆ
ಅದೇ.
now
And another one, my lord.
the lands involved are 167/2,
ಹೌದು.
168/12, 112/1 11, 168/13,
112/11 P2.
168/30, 168/4. ಅಷ್ಟೇ ಅಲ್ವಾ?
168/13 P2, 168/30 and 168/4 P2. ಮೂರು ಸರ್ವೆ ನಂಬರ್.
They are all arising out of
Same accusation, same. And another writ petition, that is, my lord, 169/3 35 cents.
Which writ petition?
169/3 35 cents. So also 112/11 P12. ಬಂದಿದ್ರೆ ಹೇಳಿದಿದ್ರೆ ಅದೊಂದು 112/11 P12.
that's part of 112/11 ತಾನೆ.
11 ಹೌದು, ಸಬ್ ಡಿವಿಷನ್ಸ್ ಬೇರೆ, ಬಟ್ 112 ಅನ್ನೋದು.
What is the date of the first notification?
Is there of 2014.
Well, there are three notifications has been taken place, my lord, in respect to the very same land.
3A ಯಾವಾಗ, 3D ಯಾವಾಗ?
22/20,
2020.
28/20.
22,
28 August of 28th of 2020.
22/8.
2020.
This is a 3A notification.
Yes, sir.
3A, then 3-2.
Yes, sir.
3G, 3DD,
8/12/20.
8/12.
8/12/20.
What is the award?
Award
Award is,
15/3/21.
my lord, according to us, 3C2 order has not been passed.
There is a civil dispute in that Udupi, Your Honor. This is all the family members, they have to file a different.
Under section 3A.
Did you file objections?
Yes.
All of you filed
No,
objections?
they have not filed objections. Other side. For this,
3A.
ಹಾಕಿದ್ದೀರಾ?
ಅವರು ಅವಾರ್ಡ್ ನಲ್ಲಿ ಪರಿಗಣಿಸಲಾಯಿತು, ನೋಡಲಾಯಿತು, ತಿರಸ್ಕರಿಸಿದೆ ಅಂತ ಅಷ್ಟೇ ಬರುತ್ತೆ.
ಅಲ್ಲ, ನಮ್ಮ ಹೆಸರೇ ತೋರಿಸಿಲ್ಲ ಇದು.
But you have filed objections.
ಅಲ್ಲ, ನಮ್ಮ ಹೆಸರೇ ತೋರಿಸಿಲ್ಲ.
ಇರ್ಲಿ, you have filed objections.
ಇಲ್ಲ, objections ಇಲ್ಲ.
3 ಹಾಕಿಲ್ಲ objections.
ಇಲ್ಲ.
No.
Did they file objections?
No, they are not filed any objections.
Still, they are required to pass an order.
There is no title of the documents, you know. Or this is a difficult for that. Why they are showing that another? You have to show the correct title of the document, then you have to what are the compensation. Your Honor, it's a hot circle of Udupi circle, Your Honor. I see the photographs, Your Honor, that original photographs misplaced in the earlier writ petition, Your Honor. That is a clearly shows, that is a very difficult for the rainy season from last 3 years. From AC and DC also as a member of the parliament also is called upon, you have to vacate.
Sir.
Please read 3A, whether it requires the Khatedars to be notified. Please read 3A.
Yeah. Overpaid, where the central government is satisfied that for a public purpose, any land is required for building, maintenance, management or operation of the national highway or part thereof, it may by notification in the official gazette declare its intention to acquire the land. Every notification under subsection 1 shall give the brief description of the land. The competent authority shall cause the substance of the notification to be published in 2 local newspapers, one of which will be in a vernacular language. Power to enter survey. Now 3C, madam, is
Therefore, 3A does not require the khatedars to be mentioned in the notification. Only the description of the land is to be stated.
that includes the owners.
No, no. Description of the land, that is all, not of the ownership of the land.
Description of the land, my lord, includes ownership.
That is
also.
the extent of the land, the
My lord,
kind of,
3C, my lord, 3C mechanism.
yes.
Any person interested in the land may within 21 days from the date of publication of the notification under subsection 1, section 3A, object to the use of the land for the purpose or for the purposes mentioned in the said section. Every objection under subsection 1 shall be made to the competent authority in writing and shall set out the grounds thereof, and the competent authority shall give the objector an opportunity of being heard either in person or by a legal practitioner, and may, after hearing all such objections and after making such further inquiry, if any, as the competent authority thinks necessary, by order either allow or disallow the application.
So this is an opportunity given if objections are filed
These objections are filed.
by any person interested. There is no requirement under the act for notifying the persons who can file objections.
My lord, interested persons means,
No,
my lord,
under
all
the-
the interested persons.
No. Any person interested can file objections.
Yes.
But they are under no obligation to notify all the interested persons unless you show from the rules whether the notification should contain the owners of the land to be mentioned.
My lord, otherwise, my lord, the owner will not be
That is
knowing
the-
about the acquisition at all.
That is the act, isn't it? The objective appears to be that it's for a highway. Everybody will know the moment notification is issued. Individual notice may not be necessary because it's abutting a highway.
My lord,
Let us see
our
the,
name was found in the record of rights.
let us see the rules. No, that's why I said, like under the BD Act or under the Land Acquisition Act. It is a requirement. ಏನ್ ಬೇಕಿಲ್ಲ ಅಲ್ವಾ ನಿಮ್ಗೆ ನೋಟಿಫೈ ಮಾಡೋದು ಬೇಕಿಲ್ಲ ಅಲ್ವಾ ಬರೀ ಪೇಪರ್ ಹಾಕ್ಬೇಕಷ್ಟೇ ಅವ್ರು. ಸ್ಟಾರ್ಟಿಂಗ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಇಲ್ಲಿ ಏನಿಲ್ಲ ಶೆಟ್ರೆ ದಟ್ ಯು ಶುಡ್ ಬಿ ನೋಟಿಫೈಡ್ or that the lands not to know. Notification should contain the list of the people who are interested in the land and that they should be served. ಅದೆಲ್ಲ ತೆಗೆದಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Now the compensation is being given to some persons who are not connected.
No, that is a next stage. Now for you to challenge the validity of the declaration. On this ground, you can't challenge the declaration.
Lord, we have, here the owners of the land, admittedly, they have to see, my lord, who are the owners. Blindly, they cannot issue the notice.
They only have to issue a notification describing the land. They are not required to notify every person who is interested in the land.
My lord, if the records prima facie show.
If you can show me from the rules.
Yes.
That the names found in the revenue record should be part of the notification. Then it's easy for me to accept and quash the notification.
It may be posted on a different day. Point out.
Because the act as it stands Next month. Does not contemplate the notified Katedar or now an award is passed. 18th hour. 18th month. Next week, month. 18th.
Next week.
Research. 18th one. Fuller at 18th. Research ಮಾಡ್ಬೋದಾ? ಒಂದು ಸರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಉಂಟು. The lands, some of the lands are not involved in the subject matter of the acquisition that has to be considered to interfere. Some lands are not at all the part of the notification. Media. Providing records. Because under 3G2, they have required to pay compensation to the owner. Only then the question of notifying the owner would arise. For the purpose of 3A and 3D, unless you file objections.
Even the award, my lord, award ನಲ್ಲಿ ನಮ್ಮನ್ನ ಹಿರಿಯರೇ ಮಾಡಿಲ್ಲ, ನಮ್ಮನ್ನ ಇದು ಮಾಡಿ.
Some of the lands are not at all the subject matter of the acquisition at all, my lord. Some survey numbers are not at all include them, my lord, they have. It was not the part and parcel of the award.
See 3G4. 3G3 talks about before proceeding to determine the amount under subsection 1 or subsection 2. The competent authority shall give a public notice published in 2 local newspapers, one of which will be so and so, inviting claims from all persons interested in the land to be acquired. Such notice shall state the particulars of the land and shall require all persons interested in such land to appear in person. So at this stage, they'll have to notify. But we have not.
It is also not done.
Where is the award?
Award is set.
Page.
Page 21 onwards.
Page?
21 onwards.
ನಿಮ್ ಜಮೀನಲ್ಲಿ ಏನ್ ಹೇಳ್ತೀರಾ?
ನಮ್ದು 46 page 78. Serial number 46. Only Srinivas Nayak has been shown.
78,
Oh,
December.
78, serial number 46. 167/2.
ಖಾತೆದಾರರು ಹಾಜರಾಗಿರುತ್ತಾರೆ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಬರ್ದಿದ್ದಾರೆ, ಬಟ್ ನಾವು ನಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ಲ.
That is not.
ಅಲ್ಲ, ಇದರಲ್ಲಿ RTC ಅಲ್ಲಿ ನಮ್ಮ ಹೆಸರು ಕಾಣುದು. RTC page 19 man. 2 acres 61 cents, we are the owners.
Oh, it's a government land, Your Honor. They have surveyed. It's totally.
No, page 76 talks about it being ವಿಚಾರಣೆಗೆ ಖಾತೆದಾರರು ಹಾಜರಾಗಿರುತ್ತೆ.
Yes, some of the lands.
Where is it the government land?
Alla, not the fully land, Your Honor. There's a part of the, they have not any obtained the RTC.
Your name was in the RTC?
Yes, my lord, page 19, page 19.
Then you should have notified them.
Already they notified.
And our house is shown, my lord.
ಮಾಡಿದೆ.
ಅವ್ರನ್ನೆಲ್ಲ ನೋಟಿಫೈ ಮಾಡಿದ್ದಾರೆ.
ಇವ್ರು ಮಾಡಿದ್ದಾರೆ.
Then I'll set aside the award only insofar as they are concerned, notify them and determine the compensation.
No, Your Honor, what happened is, what are the sketch, you can see that the sketch, Your Honor, what
But
they.
then have you made the ಖಾತೆದಾರ್ಸ್ a party here?
ಬೇರೆ ಖಾತೆದಾರರನ್ನು ಮಾಡಿಲ್ಲ, ನಮ್ಮ
ಅಲ್ಲ, rival claim ಇದ್ದಂಗೆ ಆಯ್ತಲ್ಲ.
They are not rival claimants, my lord. They are the.
According to them, there's one ಖಾತೆದಾರ್.
ಹೌದು.
They have been heard in the matter and the compensation is paid. If you want this award to be set aside.
I will implement.
Late ಆಗುತ್ತೆ ಸುಮ್ಮನೆ.
ಇಲ್ಲಿ page 19 ನಲ್ಲಿ ನಮ್ಮ ಹೆಸರು ಕಾಣುತ್ತೆ.
Persons interested in the land as define ಮಾಡಿದಾರೆ ಯಾರು ಇಲ್ಲಿ? How do you determine the persons interested in the land? On what basis? For 3G? Land acquisition officer of city.
In the connected writ petitions, so objection statements are filed, my lord. Even legal notices are also issued, stating that, my lord, you have already acquired the land at the first instance. Now you are again widening the road without calling for acquisition and notifying.
You cannot challenge 3A, 3D because you have no right to be notified individually about that.
So far as interested person, my lord, we all come, our lands are also not included in the
Tell
award.
me from the act as to what is the definition of persons interested in the land?
Interested ಅಂತ ಹೇಳಿ separate ಆಗಿ ಕಾಲ್ ಮಾಡಲಿ.
Then,
The landowners ಮೇಲೆ
because according to them, the Katidar was some Srinivas Naik. He has been notified, he appears and he says, this is the compensation to be paid. Now somebody else comes and says, I am a person interested in the land.
They have to identify as per the names mentioned in the ಖಾತಾ.
ತೋರಿಸಿ ನಂಗೆ actual rules ಇದೆ, ನಾನು ask them to follow it. That is all.
One of the ಇವ್ರು ಮಾಡ್ಬೇಕು ಅಂತ ಏನಿಲ್ಲ. ಹಾಗೆ RTC ಇದ್ದವ್ರು ಎಲ್ಲರೂ ಸ್ವಾಧೀನದಾರರೇ.
How can I?
That is why, my lord, the evaluation may call for the records with regard to their acquisition process.
From the position of law, I'll.
Please.
On what basis do
I will do some research, my evaluation.
Interest land andre the persons in the revenue records, how exactly are they to determine?
I will do some research, my evaluation. I have 18, my lord. We'll do some research, my lord.
Please apply your mind.
Please, my lord.
It looks like draconian that they can just publish a newspaper report and then proceed. But their logic, I'm sure, will be that because it's an acquisition for a road, everybody in that area will know.
ಅಲ್ಲ ಅದು ಏನ್ ಮಾಡಿದಾರೆ ಅಂತ ಈ ಪ್ರಾಜೆಕ್ಟ್ಗೆ 4ನೇ ಸಲ 3ನೇ ಸಲ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದೆ. ಅರ್ಲಿಯರ್ ರೌಂಡ್ ಅಲ್ಲಿ ಕೊಟ್ಟದೆಲ್ಲ ನಾವು ಒಪ್ಕೊಂಡ್ ಬಿಟ್ಟಿದ್ದೇವೆ. ಇದೀಗ ಲೇಟೆಸ್ಟ್ ಒನ್ ಬಂದಾಗ ನಮ್ಮದು ಆ ಹಳೆ ನೋಟಿಫಿಕೇಶನ್ ಇಟ್ಕೊಂಡು ನಮ್ಮ ಲ್ಯಾಂಡ್ ಅನ್ನು ಫೋರ್ಸ್ಬಲ್ ಈಗ ಡ್ಯಾಮೇಜ್ ಮಾಡ್ಕೊಂಡು ಎದ್ದೋ ಎತ್ಕೊಂಡು ಹೋಗಿದಾರಲ್ಲ ಬುಲ್ಡೋಸರ್ ತಂದು. ಸೊ ಹಾಗಾಗಿ ನಾವು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ವಿ. ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡುವಾಗ ನಮ್ದು ಲ್ಯಾಂಡನ್ನೇ ನೀವು ಸೇರಿಸ್ಕೊಂಡಿಲ್ಲ, ಇಲ್ಲ ಅದು ಎಲ್ಲ ಅದರಲ್ಲೇ ಬಂದಿದೆ, ಯು ಆರ್ ನಥಿಂಗ್ ಟು ಸೇ ಅಂತ ಹೇಳಿ ಹೇಳ್ಕೊಂಡೆ ಹೋಗಿದ್ದಾರೆ ರಸ್ತೆನಾಗಿ. ಯಾವ ವಿಚಾರಕ್ಕೂ ಡಿಟರ್ಮಿನೇಷನ್ ಇಲ್ಲ. ನಾವು DC ಮುಂದೆ ಹೋಗಿ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ದೇವೆ.
That is earlier judgment, satellite photo, kindly pursue that, Your Honor. Producing. No, there is no any houses, only is a dilapidated condition on house is a old factory. Only they have taken advantage for that as a factory is old, there is not running also. Even Your Honor, one scholarship I am submitting. So many accidents have occurred in the rainy season. Sumar death ಆಗ್ತಾ ಇದೆ ಸಮಯ. For that reason only that we are taking a straight way, Your Honor. From last 4 years, they are filing a writ petition, vacating the writ petition. Then again, one more of the family member has filed. These are all writ petition has filed the same thing, Your Honor.
This is not by way of causing any hurdle to the project.
I will show that I can submitting the report.
Elosh may kindly call for their papers, my lord. They are none of the papers, they are not disclosing by way of the Right Information Act.
No.
None of the documents. We asked for certain documents, my lord. They did not disclose those documents. The special land acquisition officer, he is, my lord, he is not at all determined. He disclosed the document which he demanded.
Our house is shown, my lord, but we are not inheriting the land.
And one more writ petition, well, there is a soda factory is there, my lord. Soft drink factory is there. They have dumped the house in and around the soda factory. Just to see that, my lord, workers should not attend the factory. That kind of illegalities they have done. It is still there. better position to convince your lordship. Thank you. Thank you. What procedure, sir? You can do it in the back. So that we can find out the mechanism.
Even this court does not say that you should be notified. 3A1 only the plan should be published and that satisfies the requirement. K1, no question of notifying all persons interested. The requirement of just publishing the plan.
But my lord, if the wrong persons are
Our house is shown in the award, my lord, that the existence of the house is shown, then they don't hear us. ವಾಸ್ತವ್ಯದ ಕಟ್ಟಡ ಮುತ್ತಕ್ಕೆ ಅಂತ ತೋರಿಸ್ತಾರೆ ಆದರೂ ನಮ್ಮನ್ನು ಹೇರ್ ಮಾಡೋದು.
may I request my lordship to secure the records, my lord, so that my lord, we will be in a better position to convince your lordship. They have to produce.
Let us assume that you have filed your objections. What is your right? You tell me from the law rules or the provision.
My lord, that will do the research. We will come back to your lordship. Lordship, I have on 18.
I'm interested in knowing how exactly you follow the procedure for notifying the persons interested in the land.
Okay, then I'll do it.
Suppose they voluntarily make a claim and you admit in your plan that there are structures.
Yes.
Should not notify the person who is residing there.
Okay, then I'll find out and then produce it. No, they are not residing, Your Honor. I'll find the photographs is that earlier judgment has scanned the big photographs they are producing there, Your Honor. Show that there is a
Forward
vacant
mention
land, is not a
ಮಾಡಿದ್ದಾರೆ,
agricultural.
How do you identify the person's interest in the land to determine the compensation?
Please. I'll find it.
Satisfy me on that.
Please, Your Honor.
18.
18.
Meanwhile, interim order.
Idea.
Interim order.
Intermode is
But continue to. Yes.
And has been acquired, my lord, the formation of that layout. That's by the KID,
Yes.
aerospace.
Lord, I have appeal for the KDB, my lord. There is a suit, my lord, pending adjudication before Devanali, my lord, the suit in, my lord, yes, extracted in his
Page
petition,
number
page
7.
number 7, my lord.
Paragraph 10. I've given a chart of the litigations that are pending. Notification is in 2007, my lord, final notification. From 2008, my lord, one after the other litigation, there is no injunction. Ultimately, my lord, KIDB says in view of the litigation, we will not release the compensation.
Refer it to the civil court.
Let, subject to the result, let them, my lord, my lord, kindly see, my lord, partition suit is dismissed.
There are rival claims, isn't it?
Let's no rival claims. I am the notified khatedar.
There were rival
In
claims.
the final notification, my name is notified. My land is acquired. After acquisition, my lords, there are 110 people who would come and say, my lords, this land belongs to me, so on and so forth. There is no order operating in anybody's favor other than, my lords, saying that, my lords, all these suits are pending. There is no injunction. There is no, my lords, stay of release of compensation. Subject to the outcome, my lords, ultimately, even if those lands ultimately suits are dismissed.
Is there a decree holding that you are the owner and the property by the civil court?
Nobody has disputed, my lords, my ownership.
No, then why are there so many suits?
Lord, they have filed suit for partition, injunction, kindly see, my lord, serial number
Lord,
5.
first is-
Injunction to withdraw the compensation.
So therefore, there is a rival claim. How can they disburse the amount to you?
My lord, subject to the, it is not that, my lords, they have a decree in their favor
I
saying.
will ask
that
him to
they are
refer to the civil court under section 30-31 for apportionment.
not. My lord, if they are held to be the owners, my lord, then question of.
That the civil court will determine. What is it the land acquisition officer can do if there is a rival claim?
My lord,
There's a frivolous claim.
please,
Can you say it's a frivolous claim and reject it?
no, my lord, no claim is made before them. No rival claimant.
But there are suits in which I'm sure they're also parties.
No, my lord.
You're not parties in any of the suits?
I'm not party, but my lord, there's a suit, my lord, pending.
They are not.
Somebody has, my lord, lord,
ನಿಮ್ಮದೆಲ್ಲ claim ಮಾಡಿದಾರಾ?
ಅಲ್ಲ ಅವ್ರು ಬಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ.
ಹಾಕಿದ್ದಾರೆ.
Suit, ಅಲ್ಲ SLO ಮುಂದೆ.
ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ.
Respect of respond, my lord, serial number 2, suit for partition, my lord, ಅದಕ್ಕೆ ಬಂದು ಅಬ್ಜೆಕ್ಷನ್ ನಮ್ಮ SLO ಮುಂದೆ ಕೊಡ್ಬೇಡಿ ಕಾಂಪನ್ಸೇಷನ್.
Let it go to civil court. For how long will you fight?
But in fact, my lord, ultimately, my lords, if one after the other, after acquisition suits are filed, my lords, by the time, my lords, those suits are decided.
The claim dispute start only after the money is shown, isn't it?
Like even my lords, even if they were to disperse be after my lords, my lifetime, lords, then
So what can you do?
lords, subject to the outcome, my lords, if they are held to be, my lords, if they have any right in the property, subject to the outcome, my lords, I'll furnish a bank guarantee.
You will have left this earth, then where will they go?
I would have produced, my lords, the bank guarantee, my lords.
Risk. Bank guarantee can't be indefinite.
My lord,
It won't last beyond your lifetime.
my lord, SLA, my lords, can't even say that they are not the notified khatedars. Then, my lords, the entire acquisition will have to go. If they have a right in the property, if they are khatedars, then, my lords, the entire acquisition will have to go because they are not even notified in the acquisition process.
I can only say refer it to the civil court. Forthwith, and the civil court to determine the claims as expeditiously as possible.
May I make one suggestion? My lord, the petitioner has filed, my lord, one more writ petition, my lord, against the, my lord, the revenue department, and also, my lord, making the KDB as a party respondent, my lord, to, my lord, recent file, Monica.
FR ಅಂತೀರಾ? I don't
The
know what
FR
this- I'll verify. I don't know, my lord, what this.
Generally, genuineness, my lord, in the year 2010, my lord, after a final issuance of final notification, KDB, my lord, addressed letter to the, my lord, the Tashildar, to, my lord, ascertain the, my lord, the genuineness of the grant. So far, my lord, we have not received anything, my lord. There are certain, my lord, the lands which have been said, alleged to have been granted, my lord, there's some
Let
dispute.
it go to civil court.
So, my lord, that case is, my lord, filed recently by the
Petitioner,
petitioner.
pass over. Pass over.
ಅವ್ರು ನಿಮ್ ಗ್ರಾಂಟ್ಗೆ ಅಡ್ಡ ಇಟ್ರಿ ಈಗ.
ಅಲ್ಲ ತಗೋಬೇಕಾರೆ ಗ್ರಾಂಟ್ ಏನು
ನಿಮ್ ಬುಡಕೆ ಬಂತೀಗ ಸುಮ್ನೆ ನೀವು ಇರ್ಲಾರ್ದೆ.
ಅಲ್ಲ ಲ್ಯಾಂಡ್ ತಗೋಬೇಕಾರೆ ಯಾರ್ದು ಗ್ರಾಂಟ್ ಇದೆಯಾ ಇಲ್ವಾ ಏನು ನೋಡದೆ ತಗೊಂಡ್ಬಿಡ್ತ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ಬೇಕು.
ಅವ್ರನ್ನ ಕೇಳ್ಬಿರ್ ಎತ್ತಾಕೊಂಡ್ರೆ ತುಂಬಾ ಕಷ್ಟ ಇದೆ. ಸಿಗಲ್ಲ ಅಷ್ಟು ಬೇಗ.
ಗ್ರೇಟ್.
Matter is settled. The suit itself is settled. And parties have, the suit filed by the respondent has been withdrawn as settled. I am also filing a memo.
When it comes to the petitioner files a memo stating that the suit from which the impugned order emerges has already been settled, has already been disposed of, as having been withdrawn on 7/2/2024. In view of the suit itself having been disposed of, this revision would obviously not survive for consideration. It's accordingly dismissed as become unnecessary.
I
The
pray for
defendant's
time, my
application
lordships.
for rejection of the plaint is
I
rejected.
pray for time, my lordships. I pray for time.
Why?
Repeatedly, they are taking. time.
2021.
Yes, my lordships. 2 days, my
But the
lordships.
peculiarity of this case is mortgagee has filed a suit for declaration in an unredeemed mortgage.
Finally, don't ask for time again. Release on
15th of if possible. 15.
Obliged.
Because the respondent in this part,
Suit for eviction. He's a tenant. But I'm running a Malad, the timber business in the Malad, the premises 245 square feet. No, that, but in fact, not by interim order, Malad, I have deposited Malad, all the Malad, the arrears of rent Malad. Before this. The dispute as to that, Malad, he's not, Malad, my contention before the trial court, that Malad, he's not the owner. The land, Malad, that, is not the Malad, the owner of the land. Not the trial court dispute that Malad version and Malad allowed the Malad the suit and directed me to Malad vacate the premises 2 months. Or since Malad I am running a Malad the commercial business there in Malad, if my lordship Malad, if the other side Malad 1 year Malad time is granted Malad, then I'll vacate the
No,
premises.
lordships, because in the year 1989, they had taken this property for rent, lordships. From 1989, the per month rent is rupees 100, lordships in this. They're squatting over the property for more than 35 years. Time and again, they have been like, pushing this, lordships. In the year, from 2010, the father of the respondent passed away, lordships. Hence, the son has been taking care of the shop. From 2016, 100 rupees rent also, time and again, they have been like pushing the respondent to like receive the rents, lordships. In 2018, they have filed a suit for injunction against the respondent seeking not to interfere in the peaceful possession, lordships. Further, in 2018, a suit was filed by the petitioners for in suit for injunctions not to interfere in the peaceful possession.
The extent of the property?
245 square feet.
130 square feet.
135 square feet, lordships. Now, lordships, after that,
They have
2000,
been there for 35 years.
almost 35 years, lordships. 1989 till
For
today.
1 year, I'll ask him to withdraw the revision, subject to them.
Well, 1 year is too much for lordship, because again, there's no rental amount also which we have been receiving. 100 rupees rent for the today's market.
But they have not sought for an announcement of the rent so far.
Let them vacate the property, lordships.
1 ವರ್ಷ ಫ್ರೀ ಆಗಿರಕ್ಕಾಗಲ್ಲ. ಇವಾಗ ಎಷ್ಟಿದೆ ಮಾರ್ಕೆಟ್ ರೇಟ್ ಅಲ್ಲಿ?
10,000 lordships.
10,000 illadu. In fact, not the 200 rupees not have been paying.
If you deposit 1 lakh and withdraw the revision, I'll grant you 1 year's time.
Let them vacate the property, lordships.
Not, I'll vacate the not the property, not.
I'll grant you 1 year time, provided you deposit 1 lakh immediately and withdraw the revision.
That could be withdrawn not after 1 year. 1 lakh could be withdrawn after 1 year.
ಯಾರು?
ಅಲ್ಲ, ನಾವು withdraw ಮಾಡ್ಕೋಬಹುದು 1 year.
ಇಲ್ಲ ಅದು ಹೋಯ್ತದು. ನೀವು ಅಲ್ಲಿ ಫ್ರೀ ಆಗಿರಕ್ಕಾಗತ್ತ ನೀವು?
ಅಲ್ಲ, ನಾನು ಪೇಮೆಂಟ್ ರೆಂಟ್ ಕೊಡ್ತೀನಿ. what is agreed not I'm paying the rent not.
100 rupees ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ, in fact not he has not. ಇಲ್ಲಿವರೆಗೂ ಅವ್ರು ಕೇಳಲು ಇಲ್ಲ, ಅನೌನ್ಸ್ಮೆಂಟ್ ಕೇಳಲಿಲ್ಲ, ಏನು ಕೇಳಿಲ್ಲ.
ಅದಕ್ಕೆ ನೀವು 1 ಲಕ್ಷ ಕೊಟ್ಬಿಟ್ಟು 1 ವರ್ಷ ಟೈಮ್.
Let them vacate the property, lordships. They're not ready to pay also, not ready to vacate also. Yes, lordships.
I'll take instruction now kindly.
Tomorrow. Or I'll dismiss this petition, grant you a month's time.
I'll take instruction on it, sir.
It'll be listed for tomorrow, lordships.
Tomorrow.
No, not tomorrow, day after tomorrow.
Again,
Tomorrow I have some difficulty. Have some tomorrow.
I appeal for petitioner, my lord.
ಹೇಳಿ ಸಂಗರ್.
Your lordship will kindly see. The London fund is not filled. ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು.
ಈ ಕೇಸಲ್ಲಿ. ಆಯ್ತು. No, your lordship will kindly see. The respondent filed a suit for ejectment, saying that there is a lease agreement dated.
Both the suits are same alva?
Same. 25/3/2000 for a period of 20 years. 25/3/2000, there is a lease agreement executed by his father, not by him, in favor of the defendant.
Yes.
Then in para 4, he says it is for a period of 20 years. He files a suit.
My lord.
Yeah, I may be.
ಕೂತ್ಕೊಂಡ್ಬಿಡಿ ನೀವು ಅವ್ರು ಮಾಡ್ಲಿ ಮುಗಿಸ್ಲಿ ಅವರು.
He files a suit on 26/9/2019.
26/9/2019.
2019. If period is for 20 years, whether suit is maintained.
All right. What is the order that you have challenged now?
Then I have challenged the order. I filed an application under Order 11/14, stating that the plaintiff has not produced the lease agreement dated 25/3/2000. He has not produced any title deed. There was an office objections when they filed the suit before the trial court. The office objection, rental agreement is not produced. 2, title deeds such as khata certificate and khata extract are not produced in respect of scheduled property. RPAD court cannot furnish. These are the objection by the office. No, your lordship will kindly see the very base. Abdul Wajid case says now one more court is added. 2011, the division bench of this honorable court held that the lease agreement has to be produced in case of simple suit. If HRC case is applicable, they have to file HRC case. If small cases court applies, they have to file SC case. If pecuniary jurisdiction exceed, if there is a dispute regarding title, then it is the only city civil court. Now, after commercial establishment, there is one more court, commercial court. In respect of the commercial shop premises, they are having the jurisdiction. So my respectful submission is, the very foundation is a lease agreement. If it is for 20 years, whether they can determine the tenancy. Without production of document, whether the plaintiff can determine the tenancy.
Yes.
He has not produced his title deed. Admittedly, he says that his father, Dodkalappa, he was the owner of the scheduled property. He has let out the shop premises. I have filed an application under Order 11 Rule 14 stating that, no, my lord, CPC says Order 7 Rule 14, the plaintiff has to produce the document if he is relying upon production of document on which plaintiff sues. He files the suit based upon the lease agreement dated 2000. So he has to produce the document. Your lordship will kindly say Order 7 Rule 14, where a plaintiff sues upon the document or relies upon document in his possession.
Your application is under order.
Order 11 Rule 14 for production. Because what I have stated.
Let us read order 11 rule 14.
Order 11 Rule 14 says, your lordship will kindly. Production of document. It shall be lawful for the court at any time.
Order 11 no de. Order 11 rule 14.
How Order 11 Rule 14. It shall be lawful for the court at any time.
11.
Order 11 Rule 14. It shall be lawful for the court at any time during the pendency of any suit to order the production of any party thereto upon oath of such of the document in his possession or power relating to any manner in question in such as the court shall think right, and the court may deal with such document when produced in such
No, but
manner.
the application is filed on, kindly come to page 16. You filed the application under order 11, not
Order 11 Rule 14.
ನೀವು 7 rule 14 ಓದ್ತಾ ಇದ್ದೀರಾ?
Order.
You made an application
No,
under
no,
order.
my lord, no. ನಾನು ಈಗ ಓದಿರೋದು Order 11 Rule 14. Order 7 Rule 14 mandates the plaintiff to produce.
Let us read order 11 rule 14 first.
What I have read, Order 11 Rule 14, your lordship will can. This is Order 11 Rule 14, your lordship may can. It shall be lawful for the court at
This
any
order
time.
7 rule 14.
Order 7 is less, Order 11 Rule 14. Order 7 Rule 14, production of the. No,
CPC commercial court is
No,
different.
commercial court I am not getting.
Order 11 is different.
I am not. Order 7 Rule 14 says, if the plaintiff relies upon the document, he is bound to furnish the document. Then Order 7 Rule 14 subclass 2 says, if it is not in his possession, he has to submit before the trial court.
All right.
No, that is Order 7 Rule 14. I have not filed under application because Order 7 Rule 14 mandates the plaintiff to produce the document. I have no rights. It is bounded duty. I have filed an application under Order 11 Rule 14, directing the plaintiff to produce the documents.
Yes.
The lease agreement, title deed, khata certificate, income tax return, to show that he is the owner and to show that to produce the document to adjudicate. In view of the circulation issued by this honorable court in 2021 to all the courts. Now your lordship will kindly see. I have produced the copy. When he filed the suit, he did not produce any document, khata certificate. He did not produce any document lease. It is his case that it is for a period of 20 years. Now, the trial court surprisingly, instead of going on the merits of the application, whether the documents are necessary or in his possession, completely says, no, he is the owner, any co-owner, based upon the Supreme Court citations, that any person can file a suit. That is not the case. Matter is, the trial court was under wrong impression. She has not read the application, Order 11 Rule 14, what I have filed that application. And she has not disclosed whether it is relevant to adjudicate the case. There is an office objection. No lease agreement has been produced. No title deed has been produced. No khata has been produced. How the court will adjudicate? It is the case of the plaintiff that he is the absolute owner. It is not his case. His father, the Kalapa, has let out the premises, not to the defendant, to the entire property, lovely company, your lordship will tell us. Now the suit is filed, what they do, they bifurcate the tenancy into the two parts. They filed two suits. I have produced both the CRP. Northern portion sales are southern front portion and back portion. Schedule is different. How can they divide the portion? Your lordship will tell us. So my respectful submission is, the trial court was supposed to consider whether Order 11 Rule 14 documents are necessary, relevant. Title deed, because the lease agreement, as they admitted, it is necessary. They have not produced. Office objection says they have not produced the document. Point two, title deed they have not produced. As stated, Khata certificate, and it does not say that I am not having. And nowhere the court discloses, discuss this point. Nowhere in the order sheet, anybody can file a suit. Still, cross-examination is not over. It is the stage of cross-examination. I filed an application saying that the plaintiff has adduced the evidence that he is having a lease agreement. His Khata certificate, title deed, how he has become the owner. Because there is a dispute in the property. There are 3 brothers, 2 daughters. Of course, I am not coming. I have not said that they are my owner. Relationship has not been established. Which court will get the jurisdiction? So is it not necessary? They have relied upon the para 3 and para 4 says that it is for a period of 20 years. And I have disputed in my written statement that there is no such lease agreement. That is my contention. For a period of 20 years, is it not necessary? Whether the small cases court will get jurisdiction or whether the city civil court will get jurisdiction, there is a serious dispute regarding rent. He claims, no, it is 10,000, earlier it was 4,000. There is no document. Not a scrap of paper has been produced before the court. And there is a notification from this honorable court, your lordship will kindly see, the general circular that fraudulent suits are filed. And trial court are advised to see the documents, Khata certificate, lease agreement. And I rely upon the citation passed with this Abdul Wajid case. The trial court has, the division bench has held that there should be a lease agreement. Simple suit only, small cases court can file. No. And so far as the only notes I have produced because it is 150 pages. Simple suits before the small cases. Simple, where there is no dispute of title. Here it is not the case of the person Ravi, that he is the absolute owner and he has let out the premises man. It is not his case. So documents are relevant. Which court will get the jurisdiction? The very basis upon that. And the trial court order is coming in my way. The trial court says that yes, he is the owner and I am the tenant. So nowhere the court has considered Order 11 Rule 14 application. The Order 11 Rule 14, it is the duty of the court to find out whether the document are in possession are necessary to adjudicate the case. No finding has been given. In fact, the court says that regarding the title. So my respectful submission, the court has erroneously passed the orders and observed that there is a dual relationship. Any person can file a suit without discussing whether there is a lease agreement executed in 2000, whether there is a Khata certificate, whether the plaintiff is having the title deed, and whether he should be directed. Plaintiff has not disputed that he is not having Khata certificate, he is not having rental lease, no document. He does not dispute in the objection. So trial court has erroneously passed the order without going through the order level reporting. So I request your lordship to set aside the order, direct the trial court to reconsider the IA, or as your lordship. Or either it has to be set aside because that should not come in my way. Tomorrow they say already finding has been given by the trial court, you have not challenged before the honorable high court. So that order is pinching me. That there is he is the owner, any person can file a suit. Or reserved.
Reserved. Waiting for the respondent, my lord.
My humble submission. This petition copy has not been served to the
One
respondent.
circular, your lordship required. That circular, even by the sum. ಕೊಡ್ತೀನಿ ಆ copy.
It is on the basis of my judgment only, I know. Based on my judgment only, I know that.
Yes, yes, your lordship.
26th ಕೊಟ್ಟಿಲ್ಲ.
That's why I have told your lordship.
ಕೊಟ್ರೆ ನಾಳೆನೇ ಕೊಡ್ತೀನಿ. Lord, in this case, I have responded, humble submission.
Similar petitions,
Copy has not been served.
in one,
Copy
it
is
appears
served.
here,
2 days time for filing the objection.
according to my instructions, my lord, there was a caveat in one case, which we have served. If he wants a copy in the other case, I will give him no problem.
ಕೊಟ್ಬಿಡಿ.
No, your
The case
lordship
is, caveat is.
There's one more case,
Yes.
Actually, 2 more CRPs are already admitted.
ಕೊಡಿ number ಕೊಡಿ.
Number
391.
391 of 2022.
Post along with so and so on.
And apart from that, Madam, may make one request. There is another miscellaneous first appeal which is pending before this court, wherein, my lord, the issue that is that is governing that MFA will have a substantial bearing on decision-making process.
MF is against which order?
MFA, what has happened is a separate suit, a separate suit is filed by the defendant, by the respondent association, against an association of which the petitioner and others are parties. The dispute is which association is that? In the suit filed by them, there is an interlocutory in the.
You have to pay either to this association or to some other association.
Some association. My submission, we are the part of another association. My only request is the controversy.
You first deposit the money here. I will discharge your
deposit-
obligation in the other, as against the other association.
What I am submitting is this, Miller. I will deposit 50% of the money, because in
50%.
other 2 cases, we have already done that.
What is the suit for?
Suit is for recovery of the maintenance charges from persons who are not members of the association admitted.
That is
We
the
are
only,
not members of the association.
that is the only point. You are a
That is
resident,
one point.
you are a resident there.
I am a resident. What I am submitting is this. Let me complete it. My respectful submission is their association, according to us, it is not legally constituted because it is an association formed under the provisions of the Karnataka Apartment Ownership Act, which contemplates 2 things. Number 1, all the owners of the apartments should file a deed of declaration. Admittedly, this respondent association is not formed by all the apartment owners, number 1. Number 2, it should be an apartment, it must be a building which is exclusively used for residential purposes. Here there are 4 office spaces are there in the basement. So as a result, what we suggested right from beginning is, this Karnataka Apartment Ownership Act does not apply. Let us form an association under the Plaint Act. We have formed an association under the Plaint Act as a company. They have formed.
ಅಂದ್ರೆ ನೀವು 4 ಜನ.
4 ಜನ ಅಲ್ಲ, other total 7-8 members. Problem is, we have questioned the validity of their association in another suit, and they have filed an independent suit against this association, and in that they have taken temporary injunction. My respectful submission is that MFA, which is already filed by them, if it is decided along with the CRPs.
What is the trial court is? What is the trial court held here that they are the association?
No, they are not, they have only granted interim order that you don't have, I am not.
In this proceeding,
Not in this proceeding.
in this proceeding, what is the pending that they are the association?
They are entitled to receive the money, that's what they have said, but according to me, it is wrong. Because we are not members, unless and until we are the members, and unless until the play.
Where is the reasoning?
Your lordship may make one submission, your lordship may kindly get other CRPs also. So that we can argue.
CRP ಕೊಡಿ number ಕೊಡಿ.
Number ಕೊಟ್ಟಿದ್ದೀನಿ.
Post CRP number so and so along with this.
Millard, till then, Millard, let them not execute this order.
If you deposit the entire money, I will not execute, I will not permit them to execute.
Millard, I have deposited 50% in other 2 cases, Millard.
Or my interim order full.
ಆಯ್ತು, ನಮ್ಗೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು ಅದಕ್ಕೆ. ಒಂದು 3 weeks ಟೈಮ್ ಕೊಡಿ.
ನೀವು ಅಲ್ಲಿ ಇಷ್ಟು ವರ್ಷದಿಂದ ಇದ್ದೀರಾ, ನೀವು ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡದ್ರೆ
ಅದು ಏನು, what I am submitting is this. The only reason is this, not that we don't want to. In fact, we are ready to maintain the entire building. In fact, we have also purchased.
I'll have it on Wednesday.
By that time, we have also purchased lifts to be installed in the building for the old citizens, senior citizens. They are not permitting us to install the lifts. That is the problem.
First entire amount deposit ಮಾಡಿ ಆಮೇಲೆ ನೋಡೋಣ.
ಅದು ನಂಗೆ at least ಒಂದು 2 weeks time ಬೇಕು.
Don't execute till Wednesday. On Wednesday.
Wednesday ಒಳಗಡೆ ದುಡ್ಡು ಕಟ್ಟೋದಿಕ್ಕೆ ಆಗುತ್ತೆ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ. I will find out.
ಅದಕ್ಕೆ Wednesday ನೋಡೋಣ ಏನ್ ಮಾಡ್ತೀನಿ ನಾನು, ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ನೋಡೋಣ Wednesday.
ಅಲ್ಲ, money has to be deposited. I will deposit by the.
You have to pay every year. You have had a nice time.
Not every year.
Maintenance every year ತಾನೇ ಕೊಡೋದು.
My submission is only this, because there are 2 pending litigations in this.
Wednesday, I'll have it all of them together, Wednesday.
And let the MFA also be listed. But what will happen is if MFA is listed, your lordship will be in a
Why are
position.
you interfering?
An injunction suit where they have been restrained not to.
Why are you interfering when I am arguing on your behalf? You should keep quiet. Wednesday,
Wednesday, next Wednesday.
post along with.
Next
the
Wednesday,
event.
day after tomorrow.
Event.
Day after tomorrow ಒಳಗೆ ದುಡ್ಡು ಕಟ್ಟಕ್ಕಾಗಲ್ಲ.
ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳಿರಲ್ಲ ಅದಕ್ಕೆ
ಅಲ್ಲ ನಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಬಟ್ 2 ದಿವಸದಲ್ಲಿ ದುಡ್ಡು ಕಟ್ಟಿ ಅಂದ್ರೆ ಆಗುದಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ.
Next month. We deposit the
Have a
money.
document to file my objection. Whatever submission they made is absolutely wrong. I will
Correct.
convince this court.
34, 35 ಎರಡು ಒಂದೇನಾ?
ಎರಡು ಬಂದೆ.
ಇನ್ನು ಎರಡು ನಂಬರ್ ಕೊಡ್ತೇನೆ post along.
Copy may be served on me so that I file
They
my
will,
objection.
they will, they will.
ಒಂದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವಿ, ಒಂದರಲ್ಲಿ ಕೇವಿಟ್ ಇತ್ತು
ಕೊಟ್ಬಿಡಿ.
ಇವತ್ತು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಕೊಟ್ಟಿಲ್ಲ.
ಇನ್ನೇ ಒಂದು ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿನೇ ಕೊಟ್ಬಿಡಿ.
correct ಆಗ್ತದೆ.
Main deed of the year 1996. That is sought to be attacked by the daughter
Lead of the
in
year.
a partition suit.
Where's the plaint?
That's Plaint.
Number 24.
30, 24.
Issue
24.
notice. The council is permitted to take out notice on the respondents through the respective council. So, till the next date of hearing, there should be an interim stay released on.
Pertaining to this annexure A and L may not premature actually. Call for notice from the production of the documents may not.
Next year,
Annexure L. Page
A and
number
L.
34 may. Only letter for production of documents.
But in this case, my lord, grievance of the petitioner is, my lord, unscientific demarcation of the village limit, my lord. That is only short grievance of the petitioners, my lord. But kindly.
what is annexure K? It's only a notice saying
Yes, my
that.
lord. Yes, my lord. My lord, annexure G, annexure based on annexure G, my lord. In this next page, my lord, in annexure G, next page. Middle of the village, the respondent decided as.
Next year G.
Yes.
Next year G is
Information issued by the respondent to the petitioner, my lord. Information, my lord, issued by the respondent to the petitioner, my lord. My lord, petitioner number, my lord, 12707 of 15, my lord.
next year G is page 24.
Yes, my lord. My lord, in the next page, my lord, the
Yes.
respondent demarcated the village limits, my lord. Middle of the village limit marked as out of the village limit, my lord. My lord, regarding that, the village panchayat and other villagers also made representation to the respondent, my lord. My lord, kindly come to the page number, my lord, 29, annexure H and annexure J, my lord. ಅಲ್ಲಿ ಏನಾದ್ರೆ ಸ್ವಾಮಿ ವಿಲೇಜ್ ಲಿಮಿಟ್ ಅಲ್ಲಿ ಒಂದು ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ, ಔಟರ್ ವಿಲೇಜ್ ಲಿಮಿಟ್ ಅಲ್ಲಿ ಒಂದು ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ. ದೋ ದ ಪ್ರಾಪರ್ಟಿ ಕಮ್ಸ್ ಅಂಡರ್ ದಿ ವಿಲೇಜ್ ಲಿಮಿಟ್ ಮಾರ್ಕೆಟ್ ಆಸ್ ಔಟರ್ ದಿ ವಿಲೇಜ್ ಲಿಮಿಟ್. ಅದನ್ನ ಅಷ್ಟೇ ಸರಿಪಡಿಸ್ತೀರಿ ಅನ್ನೋದಷ್ಟೇ ನಮ್ದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ರಿಕ್ವೆಷನ್ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಅದೇ
ಎಲ್ಲಿದೆ ಪ್ರಿಪರೇಷನ್ ಎಲ್ಲಿದೆ?
annexure H, my lord, annexure H and annexure J.
Read your representation.
ಇಂದ ಗ್ರಾಮಸ್ಥರು ಬುಕಾಮದಿ ಗ್ರಾಮ ಯೋಜನಾ ನಿರ್ದೇಶಕರು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಇದರ ಅಭಿವೃದ್ಧಿ ಯೋಜನೆ ಚೈನೇಜ್ ಸರಪಳಿ 25,380 25,675 LHS ಮತ್ತು RHS ಎರಡೂ ಬದಿ ವಿಲೇಜ್ ಲಿಮಿಟ್ಗೆ ಸೇರಿಸಿಕೊಡುವ ಬಗ್ಗೆ ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚಿಕ್ಕಮಗಳೂರು ಜಿಲ್ಲೆ ತರೀಕೆರೆ ತಾಲೂಕು ಶಿವನಿ ಹೋಬಳಿ ಬುಕಾಮದಿ ಗ್ರಾಮದಲ್ಲಿ ಹಾದು ಹೋಗಲಿರುವ ರಾಜ್ಯ ಹೆದ್ದಾರಿ ಸಂಖ್ಯೆ 76 ಮತ್ತು HSR ಎರಡೂ ಬದಿ ವಿಲೇಜ್ ಲಿಮಿಟ್ಗೆ ಸೇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಚೈನೇಜ್ ಸರಪಳಿ 25,380 25,675 LHS ಮತ್ತು RHS ಎರಡೂ ಬದಿ ವಿಲೇಜ್ ಲಿಮಿಟ್ಗೆ ಸೇರಿಸಿಕೊಡಬೇಕಾಗಿ ಕೋರಿದೆ. Next page is
ನಿಮ್ ವಿಲೇಜ್ ಲಿಮಿಟ್ ಸೇರಿಸಿ
village limit, my lord.
ನಿಮ್ಗೇನ್ ಬೆನಿಫಿಟ್ ಆಗಿದೆ ವಿಲೇಜ್ ಲಿಮಿಟ್ ಸೇರಿಸಿದ್ರೆ?
My lord, limit is 9 meters, my lord. 9 meters, my lord. Acquisition extent is 9 meters, my lord. Village ಇಂದ ಆಚೆ ಕಡೆ ಇದ್ರೆ 13 meter. Village ಒಳಗಿದ್ರೆ 9 meter, my lord.
You want them to alter the village boundary now?
Yes, my lord.
Well, Gram Panchayati also made a letter to the respondent, my lord. ಯಾಕೆಂದ್ರೆ ಅದು ವಿಲೇಜ್ ಒಳಗೆ ಇದೆ. ಮಿಡಲ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟೀಸ್ ನ ವಿಲೇಜ್ ಲಿಮಿಟ್ ಸೇರಿಸಿಲ್ಲ. ಅದನ್ನ ಹಿಂದೆ ಮತ್ತೆ ಮುಂದಿನ ಪ್ರಾಪರ್ಟಿನ ವಿಲೇಜ್ ಲಿಮಿಟ್ ಅಲ್ಲಿ ಇದೆ. That is the grievance of the petitioners, my lord. Kindly read the annexure J also.
What is your stand? No, on annexure H, what is your stand?
We will consider unaccordance with law.
ಒನ್ ಕೈಂಡ್ ಸಬ್ಮಿಷನ್ ಮಾಡ ಅದಾದ್ಮೇಲೆ ಆದ್ಮೇಲೆ ಯಾರ್ದು ಪ್ರಾಪರ್ಟಿ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಆಮೇಲೆ ಯಾವ್ದು ಮಾಡಿಲ್ಲ ಸಮ್ ಆಫ್ ದಿ
No, my problem is annexure K is only a notice.
ಎಸ್ ಮೇಡಮ್
Annexure L is also a notice.
ಎಸ್ ಮೇಡಮ್
Asking you to produce documents regarding the formation for the passing of an award.
ಎಸ್ ಮೇಡಮ್
Now you are now changing your argument and saying consider annexure H.
ನೋಡಿ ಬೇಸ್ಡ್ ಆನ್ ಅನೆಕ್ಷರ್ ಹೆಚ್ಚು ಮೇಡಮ್
There's nothing wrong with an issuance of an notice asking you to fail your claim petition. Now, in the meantime, you want the village limits to be changed.
ಎಸ್ ಮೇಡಮ್ that is only grievance of the petitioners, my lord.
I'll direct them to consider annexure H and pass the orders if it's,
Please, madam.
if they can do it.
Please, madam.
Though the prayer in this is to a challenge
My lord, one
to the award.
annexure H and annexure J, my lord.
The learned counsel of the petition submits that the petition will be satisfied if the representation that they are given void annexure H is considered by the respondent,
But respondent number 2, my lord.
by the second respondent, and appropriate orders are passed. Next paragraph. By the representation, comma, bracket annexure H, comma, the villagers are requesting that chainage links 25 plus 380 from chainage link 25 plus 380 to 25 plus 670 on the left hand side and on the right hand side. The village, the said land should be brought within the purview of the village limit. In my view, since the petitioner requesting for alteration of the village limits, it would be appropriate to direct the second respondent to consider the said representation and pass appropriate orders within a period of 2 months from the date of receipt of a copy of this order. Please.
Same, my lord. Annexure.
Same. Same annexure, huh?
ಅದು annexure ಅದ್ರಲ್ಲಿ
Same village.
same village, my lord.
Same annexure. Annexure ಅದೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
Yes, my lord. Annexure H, my lord.
Both these cases. Somebody asked for time in this case.
I appear for the petitioner in 39. Your engaged senior counsel is currently on his legs in court. So I think some accommodation.
Release stop.
Matter is covered by the decision of your lordship consistent of division bench. There is no scheme has not been sanctioned by the government. Then, my lord, award has not been passed within 2 years as required in section 11A.
Also, a response for cage.
They have filed a state of objection.
Supreme Court regarding the scheme. In fact, it is covered by that. The acquisition is by Karnataka Housing Board. The issue is this, my lord. The survey number that they are claiming a right over, there is no sketch demarcating that this is their distinct land because no body has been affected. Now, the survey number which we have acquired consists
I
of,
thought his argument was that there is no sanction.
no, my lords, there is a scheme sanction. I will place it before my lord.
No, they have not produced, they have filed state of objection. It is not forthcoming from their state of objection.
I'll file it,
that there
I'll
is a
file the scheme approval.
scheme in question has been sanctioned and no notice has been issued. And my lord, there is a body, my lord, plus my kindly say, my lord, they have notified survey number 39. My lord, I am the owner of 39/5 4 acres and
ನಿಮ್ಮ argument
39/2B.
first ಅದ್ ಕಷ್ಟ ಅಷ್ಟೇ ನಿಮ್ಮ argument.
Yes, my lord.
Sanction ಇಲ್ಲ ಅಂತ.
Sanction illa, notice illa. There is no notice to me.
Is there
And-
a sanction?
And the award has not been passed within.
Is there a sanction?
My lord, there is a scheme approval. my lords. I'll place it before my lords.
Realist.
3 grounds, my lord. One,
Just
no
2 days time, my
notice.
lords. I'll
Then
prepare
award
it
has
tomorrow
not
day
been
after.
passed within. then no scheme has not been sanctioned. 3 grounds.
Really, realist.
Here
for the
view of
respondent.
changed circumstances, my lord, the petitioner is only seeking 13.29 guntas. As per their own report, my lord, petitioners are in possession of the property. Let them consider the representation for collection of betterment charges under section 20. Lord, we are seeking prayer, my lord, in so far as 13.29 guntas.
Prayer is to quash the notifications.
Abandoned and squashed, we are sought for.
In Murugesh?
Lord, here, Lord, their contention with regard to quashing and abandonment, Lord, there is an admission on their part only. They say that out of the entire property, we have already found roads and all, everything has come in. Only a bit of, only portion of the property is not utilized by the BDA. And that they want to, now by virtue of their submission, they want to pay betterment tax and get it
As per
regularized.
section 20. Annexure M page 102, your lordship, kindly see 102, my lord.
Use
There-
Madilva ನೀವು.
Illa, we are in possession of the property since from acquisition. There was a PTCL land, this is the PTCL land. After 1996, the petition was succeeded. 2000, they have filed writ petition. Writ petition came to be dismissed. In the pending writ petitions, my lord, the commission was appointed regarding whether the petitioners are possession or not. Annexure F, earlier during pendency of writ petition, my lord, there was a report saying that petitioners are in
To
possession.
admit that they are in possession.
Yes, ma'am.
Not there. They claim not that they are in possession. What, there is an admission by themselves saying that we have already improved the property.
Skimdala, he's saying something about the 13 guntas.
13 guntas of the lands, Lord, is not utilized by the BDA. In the sense, it's all vested. There is no, there's nothing, they don't say that it is not vested with the BDA. They only say, since the BDA has not developed that portion of 13 guntas
103,
of the
my lord,
property in
report.
2 portions of the either side of the road, Lord, that we should be left out to be used and by collecting the betterment tax. That is what is their submission.
For 40 years, you have not used the land.
Lord, we have used the land, Lord, entire extent.
This
Lord.
is land.
Yes, Lord, he's the
far
claim
as-
is more than 2 acres is the claim, Lord. His property is more than 2 acres, out of which only 13 guntas is not used by BDA.
Lord, page 103, your lordship, kindly see their own report, my lord, as per the
That in fact
commissioner.
allotted it to the
And
private.
sketch also, my
respondent.
lord, 103. There is a sketch, my lord, showing how many extent we are in possession of the property. Page 103.
Sections ಹಾಕಿದ್ದೀರಾ?
Hakidu, Schedule A property. It's 2 acres of a property.
Page 108, sketch notice.
Addition is 2 acres, out of which, Lord, he seeks
A and B,
5.71 guntas in one.
that is the
survey.
report, 103. They clearly admitted that we are in possession of the property.
What do you propose to do with this yellow and green portion?
Lord,
We are in
had
possession of.
We had allotted it to the private respondents who are their allotment is also under challenge before this honorable court. They were allotted with the sites, but that is also challenged by the petitioner.
And they are also keeping quiet for the past so many years.
But they've been given in 2018.
Lord, their filed statement of objection saying that we have no.
Land has
objection
been
to their-
allotted to me, my lord. This land has been allotted to me as an alternate land. ಅಲ್ಲಿ ಬರೀ ಸ್ಪಷ್ಟ
ಯಾವಾಗ ಕೊಟ್ರು ನಿಮ್ಗೆ?
ನನಗೆ 2018
allotment ಅಲ್ಲಿ
bulk
2018.
allotment ಅಲ್ಲಿ my land has been acquired in
Bulk allotment.
Kotnur as alternative land. Then my lord, I challenged by a writ petition. In the writ petition, my lord, this honorable court was directed to give alternative land. Then my lord, I filed a contempt. Contempt ಅಲ್ಲಿ ಅರೆಬಿರಿನಲ್ಲಿ ಈ ಲ್ಯಾಂಡ್ ಅಲಾಟ್ಮೆಂಟ್
Page
ಮಾಡಿದ್ದಾರೆ.
158
ಇದು
note.
ಸ್ಮಶಾನ ಇದು. ನಾನು ಅದಕ್ಕೆ ಐ ಗಿವನ್ ಅಪ್ ಮೈ ರೈಟ್. ಬರೀ
158 ಅಲ್ಲಿ
ತುಂಬು ಅದು ಇದು ಇದೆ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ಮೈ ರೈಟ್ ಹಸ್ ಬಿನ್ ಕನ್ಫರ್ಮ್ ಬೈ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ as per order dated 12
What do you
12
propose to do? What do you propose to do?
But now
You have allotted graveyard to them.
graveyard. It's a graveyard.
they say there is a graveyard of the ancestors of the.
The photos ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ.
Lord,
How do you solve this problem?
Lord,
Lord,
let-
at the end, Lord, if he is not inclined to take it up, Lord, we'll end up giving him somewhere else in the alternate land. Lord, that doesn't, Lord, not anyone to the petitioner's benefit, saying that, my lord, it should be
But if you-
declared as a lapse.
If you admit that for 40 years, this land is not utilized,
Not we had.
then.
We
and
had
if-
declared, we had utilized a series of litigations were filed by the petitioner. That is why, my lord, for a lapsing, my lord, it will not, because
Lapse we today. Now that 40 years have elapsed, what is that you plan to do?
but if not, my lord, we'll have to give it to somebody else, to allot it to somebody else.
Give it to him only at the
We will not claim compensation also.
40% ಏನೋ ಇದೆಯಲ್ಲ,
ಅದು ಇದು ಸ್ಕೀಮ್ಗಿಲ್ಲ, 40% ಇದಕ್ಕಿಲ್ಲ.
ಯಾಕಿಲ್ಲ?
ಇದಕ್ಕೆ ಬಂದಿದ್ದು ಅರ್ಕಾವತಿ ಲೇಔಟ್ ಇಂದ ಅಷ್ಟೇ.
ಸರಿ, ಆಯ್ತು, ಅಪ್ಲೈ ಟು ಪ್ರಿನ್ಸಿಪಲ್ ಇಸ್ ದ ಸೇಮ್, isn't it?
That cannot be applied ಅಂತ ಹೇಳಿ, the government has rejected our several such requests. But when we wanted to give such benefit to the landowners in a previous layout, government rejected, Lord, and this honorable court has upheld such. This one.
No, if you want, I'll rely upon that to say, and that principal, you will collect 40% of the whatever value that you fix. Let them pay that and you take this land. If there's a term, what is that that you will do? You'll ultimately have to go through the same problem, isn't it? 40% ಕೊಡ್ತೀರಾ then ಅವ್ರದ್ದು value. Build and value 40%.
Section 20 is collecting betterment charges, my lord.
ಅವ್ರೇನೋ ಇದೆ ರೀಕನ್ವೆನ್ಸ್ ತರ
D.
ಅದರಲ್ಲಿ 40% ತಗೊಳ್ತಾರಂತೆ ಅವ್ರು. 40% of the market value for this 13 guಂಟಾಸ್ ಎಷ್ಟು ಕೋಟಿ ಆಗುತ್ತೆ ಕೊಟ್ಬಿಟ್ಟು ಉಳಿಸ್ಕೊಂಬಿಡಿ ಸುಮ್ಮನೆ. 20% betterment charges ಆಗಲ್ಲ. Because the land vests with them ಅಲ್ವಾ?
Land west with them and
Get title.
Lord, we are in continuation possession.
How do you get title? In the light of the declaration. The land vests with them, isn't it? Only if the declaration is quashed, you will get title. Or else how will you get title? Suppose they are prepared to give you that property subject to payment of 40%. Consider it.
At 2:30, I will get it instruction. Can be disbursed.
Now, ಅವ್ರು ತಗೋಬೇಕಲ್ಲ instruction ಇನ್ನು. Release next week, next Monday.
Lord, date may be given.
Apply.
Number 27.
ಅವ್ರು ತುಂಬಾ ಗಲಾಟೆ ಮಾಡಿದ್ರು ಪ್ರಕಾಶ್ ಅವರು.
Respondent.
ಕೇಳಿ ಅವ್ರನ್ನ ಒಪ್ಪಿಸಿ.
ನಾನಿದೆ. I am for the respondent number 2.
15th ಇಟ್ಕೊಳ್ಳಿ ನಾ ಬೇರೆ.
ನನ್ಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಯಾವತ್ ಬೇಕಾದ್ರೆ ಇಟ್ಕೊಳ್ತೀನಿ. ಅವ್ರು ಅಪೋಸ್ ಮಾಡ್ತಾರೆ ನಿಮ್ಗೆ.
ಅಲ್ಲ ಅದು ಈಗಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋ ಮೊನ್ನೆ 13 ಇಂದ ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ.
ಅವ್ರು ಅಪೋಸ್ ಮಾಡ್ರೆ ನಾನು ಏನ್ ಮಾಡ್ಲಿ?
ಅಲ್ಲ ಫ್ರೈಡೆ ತಗೊಳ್ಳಿ ನಾ ಮಾಡ್ತೀನಿ, ನಾನು ಟೈಮ್ ಕೇಳಲ್ಲ.
ಅವ್ರು ಬಂದು ತಿರ್ಗಾ ಗಲಾಟೆ ಮಾಡಿದ್ರೆ
ಎರಡು ಮೆಸೇಜ್
ಇದು ಪಾರ್ಟ್ ಎರಡನೇನೆ ತಗೊಳ್ಳಿ.
ಅಲ್ಲ ಮತ್ತೆ ಲೆಟ್ ಮಿ ನಾಟ್ ಅಗೇನ್ ಆಸ್ಕ್ ಫಾರ್ ಪಾಸ್. ಐ ವಿಲ್
2:30 ಬನ್ನಿ. 2:30
ಅಲ್ಲ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ ಫ್ರೈಡೆ.
Serial number 43 tomorrow, my lord. 40 is ready to 40%.
tomorrow.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮತ್ತೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
Serial number 50.
45 ಮಂಡೇ ಕೊಡ್ತೀರಾ?
First list closed. Closed.
Serial number 50. Sir.
ಯಾವತ್ತು next?
Sir, dates
Next one.
ಕೊಡ್ತೀರಾ?
45 ಮಂಡೇ.
Sir, 51 mandamus, sir, one date. 51 mandamus.
18 ಮಂಡೇ.
One date. Monday.
45 ಮಂಡೇ ಅಲ್ಲ? ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಾ ಇಲ್ಲ ಇದೇ ಫಸ್ಟ್ ತಗೊಳ್ತಾರಾ?
2:30. ಇದು ಮುಗೀತು, ಲಿಸ್ಟ್ ಮುಗೀತು.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗಿತಾ? ತಗೊಳ್ಳಲ್ಲ.
2:30 ತಗೊಂಡ್ರು.
14 ಯಾರು ತಗೊಂಡಿದ್ದಾರೆ 2:30?
14 ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು ಅವರು.
ಯಾವ್ದು ಇಲ್ಲ.
ಸೋಮಶೇಖರ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ.
2:30ಗೆ. 2:30 ಲಿಸ್ಟ್ 2:30ಗೆ.
ಅವ್ರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು.
ಸರ್, ಒಂದು ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ. ಇನ್ನೊಂದು 13/7. ಇದು ಮಿಕ್ಕಿದೆಲ್ಲ ಅರ್ಜೆಂಟಾ?
ಯಾವುದು ತಗೊಳಲ್ವಾ ಸರ್? ಸರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಯಾವುದು ತಗೊಳಲ್ಲ. ಪಾಸ್ವರ್ಡ್ ಬಿಟ್ಟು ಬೇರೆ ಯಾವುದು ತಗೊಳಲ್ಲ.
Sir, ಇದು Bangalore list. Sir, Bangalore list ಇಲ್ಲಿ ತಗೋತಾರ ಸರ್?
ಸರ್ ಹೇಳಿ.
ಹಲೋ
ಹೇಳಿ ಸರ್.
ಸರ್ ಕೇಳಿಸ್ತಿದ್ಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ, ಕೇಳಿಸ್ತಾ ಇದೆ.
I'm not able to hear the court
ಕೇಳಿಸ್ತಾ
officer.
ಇದೆ ಸರ್.
ಹಾ ಸರ್, ನಿಮ್ ವಾಯ್ಸ್ ಆಕ್ಚುಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಬರ್ತಿರ್ಲಿಲ್ಲ. ಬ್ಯಾಂಗ್ಳೂರ್ ಲಿಸ್ಟ್ ಒಂದ್ ಮ್ಯಾಟರ್ ಇತ್ತಲ್ಲ ಸರ್, ಅದು ಈ ಲಿಂಕ್ ಅಲ್ಲೇ ತಗೋತಾರ?
ಸರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಯಾವ್ದು ತಗೊಳಲ್ಲ ಈಗ, ಪಾಸ್ ಓವರ್ ಒಂದಿದೆ ಅದಷ್ಟೇ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಬ್ಯಾಲೆನ್ಸ್ ಶೀಟ್
ಪಾಸ್ ಓವರ್ ಇದೆಯಾ ಸರ್?
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಯಾವ್ದು ತಗೊಳಲ್ಲ, ರೀಚ್ ಆಗಿಲ್ದೇ ಇರೋದೆಲ್ಲ ಅಜ್ಜನ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಸರ್, ಓಕೆ ಸರ್, ರೈಟ್.
ಹಲೋ ಕೊಡಪ್ ಸರ್. ಹಲೋ ಹಲೋ
ಹೇಳಿ ಹೇಳಿ ಸರ್.
ಸರ್, ನಾನು ಕಾಮತೆ ಅಡ್ವೊಕೇಟ್ ಮಾತಾಡೋದು, ಧಾರವಾಡದಂದ್ರಿ ಸರ್.
ಸರ್ ಹೇಳಿ.
ನಾ ಕಾಮತೆ ಧಾರವಾಡದಿಂದ, ನಮ್ ಧಾರವಾಡ ಲಿಸ್ಟ್ ಇದೆಯಲ್ಲ ಒಂದು.
ಹೌದು ಸರ್, ಫಸ್ಟ್ ತಗೊಂತೀವಿ ಸರ್ ಅದೇ.
ಫಸ್ಟ್ ತಗೋತೀರಾ? ವೆರಿ ಗುಡ್.
ಹೌದು.
ಗುಲಾಬಿ ಸರ್, ಧಾರವಾಡ VC ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಕೂಗ್ತೀರಾ?
ಸರ್ ಫಸ್ಟ್ ಅದೇ ತಗೊಳ್ತೀವಿ ಸರ್.
ಹಾ ಓಕೆ.
Okay.
Friday, my lord.
Relist.
29th, your lordships may refer it to the civil court past. 29, lords. 20, pass over. Your lordships may refer it to civil.
Serial number.
Please.
Serial number 9. The impleading application ಹಾಕ್ಬೇಕಿತ್ತು ಆಗ್ತಾ ಇದ್ದೀನಿ. My habit of next week ಮೇಲೆ. Serial number 9. ಒಂದು ಸ್ಟೇಟ್
2014.
ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಿತ್ತು ಮಾಡಿರ್ಲಿಲ್ಲ. ಅದನ್ನ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ವಿ ಅದು
ನೋಡ್
ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಸಿ ನಂಬರ್ 1 ಶ್ರೀ ರವಿ ಹೆಗ್ಡೆ. ಶ್ರೀ ರವಿ ಹೆಗ್ಡೆ.
I appear for petitioner. The Prashant has taken time for getting information about compliance.
Prashant Osmani, 6 time, check your instructions. Relist on
18th. Seal number 2, Sri Ram P. Gorpade.
Lordship, for the petition in the case, Lordships. The one more petition should be added, Lordship, in the case. The criminal petition number 100,683/23.
post along with.
ಸರ್ ಇನ್ನೊಂದ್ಸತಿ ರಿಪೀಟ್ ಮಾಡಿ ಸರ್.
So 100,683/24.
683.
100,683/24, Lordship.
83 ಅಲ್ವಾ?
So day after tomorrow, Lordship.
ನೋಡ್ರಿ.
18th.
Yes, much of that.
Seal number 3.
Same 2 1 2 3 2 1 2 3 ಎಲ್ಲ ಸೇಮ್ ತಾನೆ? 2 3 ಸೇಮ್.
For further consideration. Seal number 4.
DB Karika.
Come to ಏನಾಯ್ತು?
Seal number 4.
I pay for this part number 4, my lord.
Where is Mr. Karikar?
Yes.
Government is also not there. Who appears with the government? Who appears for the state? There were 2 or 3, they were changing. Oduchi or somebody appeared.
I appear for the petitioner, please, my lord.
Oh, where is the state government advocate? List. Ask him to come on the other day.
18th.
Number
My lord, serial number 4 pertaining to Dharwad bench.
Seal number 4, my lord.
Yes.
Relating to the Dharwad bench, my lords.
Appear for respondent 29, my lord.
Where is Goduchi?
Sir, Guruchi is not there, sir. Appear for SC R192, sir. Appear for SC.
Matter was not audible, my lord. ಇದು network.
My lord, there seems to be audio issue, my lord.
Can't hear you properly.
Hello.
But audio, I think audio issue is there. Government has already filed objections for
He doesn't know the background.
Government already filed objection.
Day after tomorrow, ask him to get instructions. Day after tomorrow.
13th.
My lord, may please, my lords. My lords, serial number 4.
Sir,
relating
13th.
to the Dharwad bench, my lords.
Sir, voice clear ಇಲ್ಲ ತಮ್ದು.
Date ಅಲ್ಲ ಅದು.
13th ಹಾಕೊಂಡಿದ್ದೀನಿ 13th.
Sir, 13th ಗಜಾನ್ ಆಯ್ತು.
Oblige, my lords.
One request. Leads to serial number. Lords kindly. List to serial number 14, Lordships have adjourned it to 18th, Lord, on petitioner's request. Lords may have it on 19th instead of 18th.
Tell him.
I have informed. 19th. Obliged.
List number 2, for further consideration, seal number 1. SB Mukhalappa.
Mother Dairy.
Yes, but in fact, they were supposed, in fact, in the interregnum, my lord, in fact, Ruben just spoke to me. I'm told, in fact, to be honest, I'm also not had a look at the judgment. I'm told in similar circumstances with regard to the silk board, Honorable Division Bench has taken a view. Can I just examine the judgment and see if it is applicable, I'll place it on record. If it's not applicable, we'll go ahead. I just got the writ petition number just now.
Relist.
Is it the one more issue, my lord, that
PF though, we'll come to them. In fact, last time your lordships indicated if they're willing to forego their PF, then we'll just see the division bench judgment. If it is applicable, so be it. If it's not, then my lord, then we can come to that question.
You waited for so many years.
no.
Thing like that.
Next week, any date is?
Next.
18.
Grateful.
Seal number 2, Shri Manmohan PM.
Permit me to, let's additional statement of objections. I've already served a copy of the same to on my letter. Because certain new contentions were raised and they had produced certain documents along with the memo, just to rebut that.
ಅದಕ್ಕೆ ಅವರೇ ಮೆಮೊ ಕೊಡ್ಬೋದಿತ್ತು ಅಡಿಷನಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ರೆ ನಾನೇನ್ ಪುನಃ
ಅಲ್ಲ ಅದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಡ್ಬೇಕು.
You're scaring them into filing additional objection.
But I'll have a look at it and respond to that anyway, but I will continue, my lord, from.
That's why I said we'll continue this on the following day. All this would have been avoided.
Lord, I am agreeable, my lord. I am agreeable, my lord. That's why I not made a submission last time also. But we are ready, if my lords were to constitute a committee, let the committee, I understand because not all these details, not a committee would be
They
more.
are not ready. They want an order on merits.
ಬರುತ್ತೆ.
categorized companies is, my lord, something else. It is all pay band. It is only relatable to the pay band. Now, please come to my lord second one. BP in MRPL, 61,000. DA, 22,000. Page 19, 123. HRA, 11,000.
They are prepared to live by the old pay scale that they are getting.
No,
They don't want anything more.
my lord. It can't be different, my lord, for a different, my lord, for Jack one and Jill another.
You have agreed under clause 28.
Not, my lord, less favorable. That means, my lord, that's why I said, please come to, my lord, the last of this. Please come to, my lord, page 123, last. What they were getting and what they are getting. There is nothing. It is the same. Instead of, my lord, DA, my lord, being given, my lord, 1 year later, my lord, it was being given earlier. We are giving it, my lord, later because everybody, my lord, in the entire MRPL, my lord, it is in that sense. It can't be, my lord, that, one employee, my lord, gets one, another employee, my lord, gets another. It has to be, my lord, uniform. That's what we did. Normalization. The central government, my lord, specifically said normalize. In fact, my lord, I'll point out, if your lordships hear us, my lord, for about an hour, we'll be able to convince your lordships. In fact, my lord, they sought for an interim order. Interim order was not granted. Your lordship said it will be subject to the result of the writ petition. We are ready to argue. I never said no.
I'll hear you first because.
Very well.
He has now.
No difficulty, my lord.
He has now agreed that he will go by the earlier.
Very well.
CT.
Please come to, my lord, the order, my lord, my petition.
Lord, I'll formally take consent from all the petitioners because the two petitioners are here. They are agreeable. I'll take formal consent from all the petitioners. But
then if I were to proceed on
then,
this.
my lord, have it on another day.
Change your mind, then I again have to start doing the whole thing afresh.
That's all right. I know that. Early.
for everyone. No. As your salary as it was in OMPL, same will continue. That's what the court will proceed with. Rate is a different salary for everyone. Very well, not the proceed.
Yes.
ಲಾರ್ಡ್ ಎರಡು ಪಾರ್ಟ್ ಇದೆ. ನಾನು ಇವ್ರು ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿ ನಾನು ಅಲ್ಲಿ ಒಪ್ಪಿದ್ದೆ. 14ನೇ ತಾರೀಕು ಆಗ್ಬೋದು, ನಾಳೆ ಎಲ್ಲ ನಾಡಿದ್ದು 14th. I'll complete the argument.
I'm repeating. My only.
Very well. I understood, my lord, what is passing on your lordship's mind. Even if I was sitting there, I would have asked the same question, my lord. No difficulty at all. It's my duty to convince your lordship, my lord. If I fail, your lordship, my lord, will allow the writ petition.
Less favorable.
Absolutely.
That is all.
Absolutely. I understand.
My thinking is, since they are agreeable for a less favorable pay structure, you should not come in the way.
My lord, it can't be. I'll point out all that. I'll point out, my lord.
13th, no?
14th. ಇಲ್ಲ, ನಾನು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. ನನಗೆ 13th ಇಲ್ಲಿ ಒಂದೆರಡು ಪಾರ್ಟ್ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ ಪಾಪ. ಆಯ್ತು, ನಾನೊಂದು ಮಾಡ್ಬಿಡ್ತೀನಿ, ಆಮೇಲೆ ನೀವು ಪ್ಲೀಸ್. ಗ್ರೇಟ್.
Intermodal continue order. Lord, also one more request, Lord, if they can also, Sir Rajendra can also verify, Lord, last occasion, Lord said, ask them about the grade, because Lord, the order says normalization of grade. So Lord said, ask them to clarify on that.
That also, my lord, we have put all that. We'll, my lord, I'm fully aware of it.
Please.
Yes, great.
I'm appealing for the response number for 4 minutes. Also, I'm filing my objections.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy is furnished.
Just I received it.
Want to go through it?
Yes.
Very list.
Your Honor, I only need 1 day.
Great, good.
Yes.
This matter, my lord, AG, Mr. Rubin Jacob is representing in this matter, my lord. Next week, my lord, because he is representing what are.
Read list.
Please. It is 19th. 19th.
The petitioners are the owners of the property. I have given the schedule, Your Worship, the page number 10. At Malwali City.
We're challenging the 82 notification, 76 and 82 notification.
The second respond Deputy Commissioner in excess of the power conferred under section 1, section 3 of the Karnataka acquisition of land for grant of outside acts.
Yes.
I issued the preliminary notification on 23/7/1976. 23/7/1976.
Hello.
Yes.
Hello. Huh?
Yes.
On 5/7/1982, the second respond Deputy Commissioner, I issued the final notification under subclass B of section 3 of the Karnataka acquisition of land for grant of outside act. When I filed a writ petition, Your Worship, that point of time, Your Worship, the Pune Municipality Corporation judgment is, Your Worship, benefit of the judgment, Your Worship, I filed this writ petition. When I filed a writ petition, Your Worship, the third time, I was a benefit of, Your Worship, the Pune Municipality judgment. Then, Your Worship, now, Your Worship, the law is settled, Your Worship, in the subsequently Indoor Development Authority.
When was the first challenge to this notification?
I will come to the, Your Worship, I will come to that point. Now, Your Worship, the principal objection in the entire writ petition, Your Worship. The respondent, even after deducting the, Your Worship, all the period of the acquisition proceedings and litigations, even after deducting 35 years, 35 years after acquisition proceedings, after deducting the earlier acquisition proceedings order, then, Your Worship, they are failed to implement the entire scheme, and Your Worship, failed to alert the single sites what purpose they have acquired the property. And virtually, Your Worship, the scheme is abandoned, the project. And Your Worship, this property laying vacant. This is admittedly, Your Worship, there is no implement. The admitted fact, Your Worship, till today, Your Worship, the respondent has not alerted a single site. And till today, Your Worship, the property is laying vacant as on date of acquisition proceedings in the year 1976. That is my principal argument, Your Worship. The scheme is virtually abandoned and it is not implemented even after 35 years, even after deducting the litigation periods. Your Worship, this contention should be.
How do you apply the 2013 Act to this?
Pardon?
How do you apply the 2013 Act to this?
Fact, Your Worship, there is a settled legal position, Your Worship.
Show me the section which makes the 1894 Act applicable.
5, Your Worship, for a moment, kindly take, Your Worship, section 5 of the Act. This Karnataka House. Section 5, Your Worship, this Act. The provisions of the Land Acquisition Act amended by the Land Acquisition 1960 shall.
In respect of inquiry and award.
Yes, Your Worship.
Now come to section 4. Now the land stands vested first year.
Section 4, Your Worship, amount payable.
Under this Act, the land stands vested with the state free from all encumbrances first.
Correct.
No question of divesting.
Correct.
So there is no question of lapse.
Lapse. Your Worship, Your Worship, kindly see this judgment, settled legal position. Mariappa case. Page number 143.
Yes.
Page number 143 ali. Para number 36. Page number 154.
Page?
Page number 154.
Yes.
You are the view that the Karnataka Act 1972 clearly comes within the exceptions stated so and so in the following reason. Firstly, there being a detailed machinery whatsoever in the Karnataka Act 1972, the all cannot be treated as a self-contained or complete code. Secondly, Karnataka Act 1972 and the Central Act 1894 as amended by the Karnataka Act are supplemental to each other for unless the Central Act is supplemental to Karnataka Act. Later cannot function. Thirdly, these acts are parametria because the Karnataka Act 1972, unlike the Calcutta Act 1911 and UP Act 1965, does not deal with any other object but deals with the same subject of the land acquisition, which otherwise would have been fallen within the ambit of Central Act. For the opposite reason, you are the view that amendments made in 1984 to the Central Act 1984, including section 11A, have to be read into the Karnataka Act 1972, so as inquiry, award, reference to court appoint appropriate of amount and the payment of the amount in the respect of the land acquired under the Act. Admittedly, prescribed period of under section 11A as elapsed, and it is stated that even now the award is not passed. Therefore, it is clear that conditions of section 11A of the violated, and according to the entire land acquisition proceeding, including the notification under section 3, subclass 3 of the Karnataka Act, we declare accordingly.
Award is not passed here?
Lordship, the award is, they are saying that award is passed, they are saying that award is deposited in the government treasury.
Award is passed or not passed?
Award is passed.
When?
Lordship, the award is passed in the year 1989.
Date is, yeah?
89.
Date.
Your Lordship, the statement of objection.
When is the date of the award?
3/10/1988.
So if 11A is applicable, you should have filed it within, made the award within 2 years.
My lord, I'll make my submission. What has happened is, he had challenged the preliminary notification also. He challenged the final notification that was pending till 87. That's why the award was not passed. Subsequently, award was passed after this honorable court dismissed the petition.
Say the dates.
Yes, I will come.
Because that is the only argument is that 11A is applicable.
Yes.
If it's
I'll just
within the
pass the
period
judgment
of
of this
11A.
court.
This may not arise also.
All-
The reason that this honorable court had an occasion to have a fourth round of litigation in the requisition.
Well, I will come to the Lordship, the earlier.
My learned friends
No, even if
objected
accept
to-
all his arguments.
Like,
May I just take my notes that?
in respect of res judicata, Lordship, I'll argue, Lordship, in respect of res judicata, they are saying that the entire case of.
You had raised the same condition in earlier round?
No, Your Lordship.
Contention Allah, but all other contentions to say that they have taken the.
No, he is restricting his argument only to 11A now. So we consider only 11A.
I am not taken that contention. This
Give
is
me the dates now. When did you file the first writ petition?
The first writ petition.
When did
Lordship,
you
I
get a
have-
stay?
Correct, Your Lordship. I have given the Lordship the list of judgment along with the. So kindly see, Your Lordship, I am already given on 16/2/2018.
ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
List of Your Lordship, the previous proceedings. 16/2/2018, Your Lordship, I am produced along with separate memo.
Yes.
This is the first writ petition. This is, Your Lordship, the challenge, Your Lordship, the in respect of.
What is the date of filing of this W? You had an interim order here?
In this matter, there is interim order, kindly see, Your Lordship.
You challenge the preliminary notification in this?
Preliminary notification only. Legality of the acquisition proceedings.
This is a petition of the year 82.
Petitioners. Your Lordship, kindly take, Your Lordship, page number 3B. Page number 3B, Your Lordship.
1 minute.
I had produced all the previous judgments along with, Your Lordship, the interim orders also.
You had an interim order here? in
Yes,
this
Your
first
Lordship.
writ petition.
I'll come to that, Your Lordship. Page number 3B, para number 3, Your Lordship, judgment. What are the
number?
issue in that that writ petition? The contention urged for the petitioners are that the inquiry held under sections.
ಬಿಡಿ ಅದು ನಮಗ್ ಬೇಡ. ಇದ್ರಲ್ಲಿ interim order ಯಾವತ್ತಿಂದ ಯಾವ
Swami, the judgment, Your Lordship, the interim order
Kindly take page number 10, Your Lordship. Interim order was passed on 22nd October 1982.
ಎಲ್ಲಿ ಸಿಗುತ್ತೆ ಅದು?
ಅದು page number 11, ದಯವಿಟ್ಟು page number 11 ಅಲ್ಲಿ.
11 of what?
11 of the copy of the interim order. ಅದೇ ನಾನು ಈಗ ಕೊಟ್ನಲ್ಲ ಸ್ವಾಮಿ.
Page number ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಅಲ್ಲ page number
Interim order 38122. There were a batch of writ petitions there.
ಅಲ್ಲ 22nd October 2082. Your Lordship. Otherwise, Your Lordship, I'll give you one more.
ಇಲ್ಲ ಇವಾಗ ಎರಡು ಬ್ಯಾಚ್ ಇತ್ತು ಅದ್ರಲ್ಲಿ 37331 38122.
ಎಲ್ಲ ಕ್ಲಬ್ ಆಯ್ತು ಸ್ವಾಮಿ, ಎಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್.
ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಯಾವತ್ತಿಂದ ಇತ್ತು?
ಯಾವತ್ತಿಂದಂತ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದೀನಿ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ ದಿಸ್ ಇಸ್ ಆರ್ಡರ್ ದಟ್ ಈಸ್ ದಿ ಫಸ್ಟ್ ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಆನ್ 22nd October 1982. 22nd October 1982.
And the writ petition was dismissed, allowed.
Disposed of on fourth day September 1982.
87 ಅಲ್ವಾ?
87.
Therefore, from 2010 82.
Correct, Your Lordship. In this judgment, in this order, Your Lordship, you challenge the legality of the acquisition proceedings. Only preliminary notification.
4987.
Please, Your Lordship.
Interim order in force. They could not have passed an award.
They are not passed the award.
They could not have passed the
They
award.
are not passed the order. But there is no, Your Lordship, interim order not to pass the award. That is only in respect of not to take position.
What is the interim order?
Just kindly see, Your Lordship, be hereby directed to dispose the petitioner from the lands in survey number.
There is a division bench ruling which says any interim order has the effect of impeding them from taking, passing an award. So this period will have to be excluded.
That is correct, Your Lordship. Here interim order is not to dispose us.
ಆಮೇಲೆ
Then Your Lordship, kindly take, Your Lordship, the another judgment, the another second round litigation. This is
ಇದ್ರಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ?
annexure, this is in the, Your Lordship, the award notice.
So in this, you are a party?
I am the party.
This is in 1990.
Yes, Your Lordship. This is the writ petition number 10-144 of 1951.
6852.
Yes, Your Lordship. This is the challenge in the award notice.
Challenging the awards ತಾನೆ?
ಹೌದು ಸ್ವಾಮಿ. Award notice.
So if you have challenged the award, it was available for you to raise the contention that 11A, they should have passed an award within 2 years. You did not raise that objection then. WP was dismissed.
Dismiss. Your Lordship, kindly not dispose, kindly see, Your Lordship, the disposed of. Your Lordship, there are two things, Your Lordship. What they have done is, Your Lordship.
ಇಲ್ಲ ಏನಾರು ಇತ್ಕೊಳ್ಳಿ.
ಅಲ್ಲಲ್ಲ, ಒಂದ್ ಸೆಕೆಂಡ್. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, why I challenge the writ petition is. Instead of, Your Lordship, the alert the sites, what they have done is, Your Lordship, what purpose they have acquired the property, they are call for auction of the sites.
ಅದು ಬೇರೆ ಸಪರೇಟ್.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಅದೇ writ petition ಕೇಳಿದೀನಿ ಸರ್.
ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿರೋದು ಬೇರೆ. ಅವಾರ್ಡ್ ಮಾಡಿಲ್ಲ 2 years ಅಲ್ಲಿ. 11 is applicable, therefore.
That is one thing, Your Lordship. There is no implement ಮಾಡಿಲ್ಲ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅದು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ. If your acquisition is upheld, challenge to the award is repelled, then what else remains for you?
Even after deducting the, Your Lordship, all the litigation period, till then, Your Lordship, after 35 years.
You have challenged the award in the year 1990. This ground was available to you, that the award is beyond 2 years, therefore quash the awards. This court did not accept that argument.
Correct.
This court upheld the award. So now in 2024, you want me to say that the award is beyond 2 years?
No, Your Lordship, that is not my contention before this honorable court. My only contention, Your Lordship, because of beginning itself, Your Lordship, I make it clear, Your Lordship, the Pune municipality judgment.
ಅದೆಲ್ಲ ಆಗೋಯ್ತಲ್ಲ ಇವಾಗ. You did not challenge this award.
Your Lordship, I am not challenging, Your Lordship. My only principal, Your Lordship, contention before this honorable court, till today, Your Lordship, they are failed to implement the scheme. They are not utilize the land, what purpose they are acquiring the property. That is my case.
On what ground can I set aside the acquisition on that ground? Having failed in 2 rounds, both to the validity of the notifications and to the validity of the award. How can I interfere now?
Both are different cause of actions. Both, Your Lordship, there is no, Your Lordship, the question of, Your Lordship, the attack to the res judicata.
What have you done from 1990? This
handed it over to the panchayat. My lordship, kindly see my statement of objections.
The award was upheld
Yes, my lords. Award upheld as of
in 1998.
1998 in requisition bearing number
WP 6852. bar
52 of
I had produced
2019.
all the judgments.
Now Panchayatiga, we, in my statement of objections.
When did you hand over possession to Panchayat?
As on 5/2/1977.
5/2/1977.
For a little bit of clarity, my lords, if my lords kindly take the order passed to the coordinate bench in requisition bearing number.
What is this writ petition? WP 2177?
2177.
He has produced one more writ petition, 21177.
That is in page number 17.
2177 which my lords are reading, I'll just point out from paragraph number 3 minutes.
Yes.
When the matter was argued at length, it was observed by the court, by this court, that the petitioner claimed to be in possession of large families, possessed of large families who have lost their primary source of livelihood in their lands, having been acquired. They are in fact living without proper shelter and a livelihood, and in order to accommodate them, it was suggested that the respondents provide site to each of the petitioners. The respondents point out that the entire land has been acquired as per the layout plan, would be sufficient to distribute it amongst the beneficiaries who have already been identified, apart from taking into account other common areas and amenities to be provided, which would be required for the beneficial enjoyment of the house sites that are found. But after obtaining further instructions, it was reluctantly stated that the petitioners can be accommodated by providing 30 feet into 40 feet site. The learned from the petitioner, however, were not satisfied with the offer and were inclined to seek larger dimensions in order to give up their claims and give a quietus to the proceedings. In the interest of justice, however, since the petitioners have lost their valuable lands, it is not also on record, it is that they have received compensation in respect to the lands they acquired, either by volition or default. It is not unjust for the petitioners being conferred such a benefit by the respondents, providing each of them a 30-40 site. This court is conscious of the fact that it is possible that the landowners who are primarily placed as the petitioners would cite this as a precedent in other seeking such a benefit. It is made clear that as the circumstance stands, there is no possibility of providing any further service of any other land owners who may have approached this court till date. As a challenge to the acquisition proceedings has lasted several decades, the series of petitions filed by being filed, and it is in order to ensure that there is no further impediment for the speedy implementation of the project, that this measure for directing the respondents to provide a site to the petitioner is warranted. Now, my lords may
They are
kindly
the same
see-
set of petitioners, same set of petitioners.
My lords may kindly see, along with the statement of which the Panchayat has filed their plan, which was approved, in which the sites which are to be intended to be given to the petitioners are also there. R19 minutes is the plan which is sanctioned.
One 35-40 side to each of them.
Please.
ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
ಅವ್ರಿಗೆ
ಅಲ್ಲಲ್ಲ ಕೊಡೋ
identify
ಪ್ರಶ್ನೆ
ಮಾಡಿದ್ದೀವಿ.
ಅಲ್ಲ ಕೊಡೋ ಪ್ರಶ್ನೆ ಬರಲಿ ರೀಸನ್ ಏನಪ್ಪಾ ಅಂತ ಹೇಳಿದ್ರೆ ಸ್ವಾಮಿ till today they are not allotted any single site property laying vacant as it is from the date of acquisition proceedings. You will kindly take their statement of objection.
ನಿಮ್ಗೆ ಸೈಟ್ ಬೇಡ ಅಂತ ಹೇಳ್ತೀರಿ ನೀವು.
ಅಲ್ಲ ಸೈಟ್ ಅಲ್ಲ ಸ್ವಾಮಿ ಸ್ಕೀಮ್ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ಲಿಲ್ಲ. For a moment kindly take their statement of objection, lost document.
What was the writ petition that you filed for? What was the prayer in the writ petition?
This writ petition.
And this 2012 writ petition.
Your Worship, you have taken similar contention, but your Worship, there is no issue is dealt with that writ petition. So should kindly tell, Worship, there is no finding. For a moment kindly take your Worship,
You had sought for a declaration that the acquisition of the lands belonged to the petitioners had lapsed.
Lapse.
Now, this was not granted to you.
But your Worship, the issue is not decided in that case.
So, okay, you can file one more writ petition.
Worship,
ಹಿಂಗಾಗೈತೆ ಮಂತ್. ನಾನು ಒಂದು ಪಾಯಿಂಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಇನ್ನೊಂದು writ petition ಹಾಕಾಗತ್ತಾ?
despite of this issue, Worship, I will place this some judgments.
Then you filed a writ appeal against that.
Correct. For a moment, your Worship, the earlier judgment kindly see, Worship, page number 23. The learned single judge not Worship, dealt that issue, whether the scheme is lapsed or not. And admittedly, Worship, the scheme is, Worship, till today, Worship, they are not allotted the single sites.
what purpose they acquire the property. Even after deducting all the ownership, the litigation period also.
So writ appeal is also dismissed.
Writ appeal is dismissed.
ಮತ್ತೆ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಮತ್ತೀಗ?
ಅಲ್ಲ
30-40 ಸೈಟ್ ತಗೊಳ್ಳಿ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ ಒಂದ್ ಸೆಕೆಂಡ್ ಸ್ವಾಮಿ. As on today, Your Lordship, they are not utilized the entire land, still laying a vacant.
You are successful. From 19.
No, Your Lordship, even after deducting, after deducting
For
the
40 years you've enjoyed the property.
after deducting Your Lordship, long battle, period of the long battle of the litigation, then Your Lordship, 35 years. Your Lordship, I am also given the
Every-
judgments. When was the interim order?
Challenge to PNFN rejected. Challenge to award rejected. Challenge on the ground it has lapsed rejected. Now what is it I can do?
Your Lordship, there is no, Your Lordship, earlier occasion, there is no interim order. There is no interim order in all the writ
Interim
petitions.
order or not, your challenge to every aspect of the acquisition has been negative. What is it that you can do, get it now from my hands? I'll have to hold that the acquisition is bad. If I'm saying that, that means I'm reversing the decision of the division bench.
But the earlier occasion, the divisional bench or single judge was not dealt with this issue. Issue is kept open, Your Lordship.
ಅದ್ರ ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗ್ಬೇಕಿತ್ತು, ನಾನು ಹೇಳಕ್ಕಾಗಲ್ಲ ಅಲ್ವಾ ಅದನ್ನ.
Because just one judgment ಕೊಟ್ಟಿದ್ದೀನಿ sir, just for a moment, kindly
I
see.
think I should impose cost on you. ರಿಟ್ ಅಪೀಲ್ ಮೇಲೆ ನೀವು ಮೇಲಕ್ಕೆ ಹೋಗ್ದಿರಾ, ಇಲ್ಲಿ ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬಿಟ್ಟು ಆ ಆರ್ಡರ್ ತಪ್ಪು ಬರ್ದಿದಾರ ಸಾಹೇಬ್ರು, ಡಿವಿಷನ್ ಬೆಂಚ್ ಅದನ್ನ ಗಮನ ಪಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ
ಒಂದ್
30-40 ಕೊಡ್ತೀವಿ ಸುಮ್ಮನೆ ತಗೊಂಡು
ಅಲ್ಲ ಒಂದ್ ಜಡ್ಮೆಂಟ್ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ, ಅದನ್ನ ನೋಡಿ ಡಿಸೈಡ್ ಮಾಡ್ಬೋದು.
ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ. ಆ ಜಜ್ಮೆಂಟ್ ಹೋದ್ರೆ ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ.
ಆಲ್ ದಿ ಫಾರ್ಮರ್ಸ್ Your Lordship,
ಅದಕ್ಕೆ ಸುಮ್ಮನೆ ಇರೋದು
10,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಆ ಟೈಮಲ್ಲಿ.
I'll dismiss it, take that 30-40 seat and go.
ಅಲ್ಲ ದೊಡ್ಡ ಫ್ಯಾಮಿಲಿ ಇದೆ, ಅಟ್ಲೀಸ್ಟ್ Your Lordship ದೇ.
ಆಯ್ತು, ಅದು that attempt also failed to the division bench. Division bench considered that you had filed the writ appeal only to secure a larger seat. ಅದನ್ನು ಕೊಡ್ಲಿಲ್ಲ ಅವರು. ಈಗ ನಾನು 24ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಕೊಡ್ಲಾ ಅದ್ರನ್ನ?
Leave it to Your Lordship.
ಬನ್ನಿ. I'll record your statement that you will give them that site.
That's already identified
Yes.
in the layout plan which is sanctioned and along with the statement of objections they filed.
Where is it?
R19, Milord.
ಯಾರು ಹಾಕಿರೋದು? ನೀವ್ ಹಾಕಿರೋದು, ಅವ್ರು ಹಾಕಿರೋದು? ಇಲ್ಲ, ಅವ್ರು ಪಂಚಾಯತ್.
Town municipality.
ಅಲ್ಲ ಟೌನ್ ಮುನ್ಸಿಪಾಲಿಟಿ ಅವ್ರು ಕೊಡು.
87 in the 106. Lord 6 ಅದು ಓಪನ್ ಮಾಡಿದ್ರೆ
Next year, 20 na.
annexure R19, no?
I think it's R20.
ಇಲ್ಲಿ
ಒಂದೇ ಒಂದು ಸೆಕೆಂಡ್ Your Lordship.
ಎಲ್ಲಿದೆ ಇದರಲ್ಲಿ?
Right side corner. Second one. Start from 126 to 87.
ಅಲ್ಲ, you not mark them here?
Not marked in the one which is given.
ಸುಮ್ನೆ ಯಾವ್ದೋ ಸೀಟ್ ತೋರಿಸ್ತಾರೆ.
Lords, I'll mark it and show it to you. Now just pass this across.
ಈ yellow color highlight ಮಾಡ್ರಿ. You file an affidavit undertaking that these sites will be allotted to them?
Yes, I'll file it, Milord. Forwarded, it's been cleared also. The plan has been approved also. We have forwarded to the planning authority. They've already approved the plan also.
You will also file an
Yes, we'll
affidavit,
file.
will not make them run around again.
Yes.
May I make one request? The statement of objection, municipality or the statement of objection.
ಏನಂತ?
Why they are not implemented in scheme? For just a look. Para number, page number 4.
I cannot say anything on the
One
merits.
second, ದಯವಿಟ್ಟು sir.
Page.
Statement of objection filed by the municipality. Page number 4. Municipality objection. Respond number 4 objection. Respond number 4 objection.
Page number?
Page number 4.
Yes.
Apart from the stated statement of objection filed in the previous writ petition, that is produced in new annexure, it is clear that formation of the layout was completed long before and beneficiaries were identified for allotment. However, on account of some person disputed with regard to beneficiaries being identified, account of a large numbers of claims put forth, the beneficiaries were once again required to be identified. The matter was dragged on, but ultimately set with regard to the said claim. That is the reason they are not implemented.
ನೀವು ಕಿತಾಪತಿ ಮಾಡಿರೋದು
ಅಲ್ಲ ಅವ್ರು ಬೇರೆ ಯಾರು
ನೀವು ಆ ಕ್ಲೇಮ್ ಶುರು ಮಾಡಿಸಿರೋದಲ್ಲಿ ಯಾರು ಬರಬಾರ್ದಲ್ಲಿ ಅಂತ. On 23/7/1976, a notification under section 3 subclause 1 of the Karnataka Acquisition of Land for Grant of House Sites Act 1972 was published. After considering the cost shown, the state government decided to overrule the objections and it proceeded to issue a declaration as contemplated under section 3(4) on 5/7/1982. Next. The petitioners, same set of petitioners, alva?
Outside.
Approach this court by filing WP 37331-37333 of 82, WP 38122-38123 of 82, and WP 4039 and 40180/82, challenging the notification issued under section 3(1) and also the declaration under section 3(4). This court, by an order dated 4th of September 1987, dismissed the writ petitions and thereby upheld the notification and also the declaration. This order of the learned single judge has attained finality. Next. Subsequently, an award was passed on 3/10/89, and this was once again the subject matter of a challenge by the petitioners in WP 6852/1990 and WP 10144-151/89. This court, by an order dated 4th of June 1988, negatived the contention of the petitioners that the awards were illegal. The court, while upholding the award, also directed that the respondent should take steps to form the sites and distribute the same to the persons belonging to the weaker section of the society. And also passed an order that the respondents should not sell the sites in public auction, as it amounted to defeating the very purpose of acquisition of the lands. Next. This order upholding the awards has also attained finality in as much as the matter was not carried further. Thus, in respect of a preliminary notification of the year 76, the award was upheld by an order of this court on 4th of June 1998. Next. 14 years thereafter, the petitioners once again approached this court in WP 21177-21193 of 2012, this time, seeking for a declaration that the lands of the petitioners from amongst the 33 acres and 7.5 guntas notified had lapsed and the acquisition had been rendered void. this court by an order dated 11th of December 2013. Came to the conclusion this court passed an order in the following terms, para 3, 4, and 5. Thus, the challenge to the acquisition on the ground that it had lapsed was also not accepted by this court. But the court observed, or ordered, that in order to ensure that there is no further impediment for the speedy implementation of the project, each of the petitioners should be given a site measuring 30 feet by 40 feet. Next. The petitioners, being aggrieved, preferred a writ appeal in WA number 279-295/2014. However, a division bench of this court concluded that the appeal had been filed only to persuade the respondents to allot a sites larger than 30 by 40, and there was no merit in the appeal, and it proceeded to accordingly dismiss the appeal. Thus, the challenge to the acquisition on the ground that it had lapsed was also negatived by this court and affirmed by a division bench also. The present writ petitions have now been filed seeking for
Page number 15.
a declaration that the preliminary notification dated 23/7/1976 and the declaration dated 5/7/82 had lapsed by virtue of subsection 1 and 2 of section 24 and section 25 of the 2013 Act. And also for a declaration that the proceedings initiated by the respondents was without any jurisdiction. Next. In my view, having regard to the fact that the challenge to the acquisition on the ground that it had lapsed was negatived by learned single judge of this court and also confirmed with division bench, it would be impermissible for the petitioners to file the present writ petition seeking for a declaration that the acquisition had lapsed because of section 24 subclause 1 and 2 of the 2013 Act. It is to be noticed here that the petitioners had in fact challenged the award on the ground that it was beyond the period of 2 years prescribed under section 11A of the 1894 Act. And this challenge of theirs was negated by this court. This by itself indicates that an award had been passed, and the challenge to the legality of the award on the ground that it was beyond the stipulated time was untenable. In the light of the award having been being upheld in the earlier round of litigation, the present set of writ petitions challenging the acquisition on the ground that award had not been passed and possession had not been taken cannot be sustained. The writ petition is therefore dismissed. Next paragraph. Learned counsel for the petitioner sought to contend that the lands had remained unutilized and therefore there was no justification for continuing the acquisition proceedings. It is to be stated here that the lands could not be put to use only because of the litigation that had been initiated with the petitioners, and the petitioners cannot be permitted to put forth this ground to seek for quashing of the acquisition nearly 50 years after the notification had been issued. This argument is therefore rejected. Next. However, since this court had directed each of the petitioners to be given a site measuring 30 feet by 40 feet. And having regard to the fact that the municipality,
Town municipality.
the respondents have also agreed that ಎಷ್ಟು sites earmark ಮಾಡಿದ್ರ?
Totally 17, madam.
That 17 sites have been earmarked. It would be appropriate to direct the, ಯಾವ respondent affidavit?
R4.
The fourth respondent to file an affidavit of undertaking in which it shall be stated, file an affidavit of undertaking. ಮುಂಚೆ, shall I record your statement that you will file an affidavit?
The state already handed over the panchayat to panchayat.
Demarcate matter sites.
That the panchayat has demarcated.
Because you point out that highlighted portion, shall I take that into consideration?
We have filed it with our objections. R4 has filed it along with our objections.
ಇಲ್ಲ site numbers mark ಮಾಡಿದಿರಾ?
Yes, it is marked. It is allotted to them only. Other sites are 20, 30 sites. Only the petitioners have 30, 40 sites. This is for a BPL scheme, my lord, for poor people, sightless people.
Where have you said so in your objections?
No, it is stated.
Site numbers ಎಲ್ಲಿ ಹೇಳಿದ್ರ?
Site numbers we have not mentioned, my lord.
Which paragraph have you said that you earmarked sites?
At para 6, my lord.
ಎಲ್ಲಿ ಆಫರ್ ಮಾಡ್ರಿ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
ಇಲ್ಲಿ ಹೇಳಿದ್ರು. Para 6 of our objections, my lord.
The fourth respondent in its written objections, I have acknowledged the fact that the petitioners had accepted the offer of site measuring 30 by 40. And they therefore accept the fact that a 30 by 40 site would be allotted to each of the petitioners. Learned counsel for the fourth respondent also states that sites have already been earmarked for allotment and you would be filing the approved layout plan in which the sites to be allotted to the petitioners would also be demarcated clearly. The fourth respondent shall accordingly convey the sites demarcated in the layout plan to the petitioners in compliance of the order passed by this court earlier.
Free of cost.
Subject to the above, the writ petition is dismissed. Our free of cost nimgalla. ಜಯಕುಮಾರ್ದ ಸಿಕ್ಕಿದ್ರೆ ಏನಾರು ನಾಳೆಗೆ ಹಾಕೊಡಿ. ಅವ್ರಿಗೆ ಸಿಕ್ಕಿದ್ರೆ ಹೇಳಿ ಬರಕ್ ನಾಳೆ.
The matter of this issue has been covered by the decision of this honorable court.
ಒಪ್ಕೊಳ್ತಾರ ಅವರು?
ಅವ್ರು ಒಪ್ಕೊಳ್ಳೇಬೇಕು because they have not even preferred an appeal against.
What is the challenge here?
The challenge is acquisition of petitioner's land about 34 guntas for the formation of a Alnalli layout, your lordship. And may I pass on the decision and the
synopsis. You appear for?
I petitioner.
ಹತ್ ಕಡೆ ಇದ್ದೀರಾ?
Just want to.
Who appears for the respondent?
Muda, my lord.
Vedmurthy.
Muda, M.V. Vedmurthy.
What is judgment? Same notification?
In that judgment, if your lordship can take from page 10, internal page 10 of the judgment. Same notification, everything is same. Your lordship. And it is admitted, now this court has passed an order. They notify 350 acres of land, take possession 55 acres. They develop only 1 acre, 11 guntas. That is the admission made by them. Page 10 in the told. Page 10 your lordship, internal page, parallel 9 in the.
India worldly? Which village is yours?
I am Allanhalli. Now page 13 the first 8 lines makes it clear.
The challenge in this writ petition is to be,
Milots, I appear for respondent number 2 and 3 in this case, Milord.
Yes.
Serial number 7, Milods.
yes. Yes, what do you say?
Milods, the acquisition proceedings has been for the land has been acquired following due process of law, Milods, and the Alanali second stage in Vasantanagar layout is one and the same, Milods.
What about this? What about this judgment? Have you filed an appeal against this?
Milods, I seek a short accommodation, Milods.
No,
Senior.
I'll follow this in case you have preferred an appeal, file one more appeal, that is all. This court has already said that the scheme had lapsed in 2022.
We have produced all the documents, Milords. The certified copy of the preliminary notification, final notification, copy of the award. We have produced all before this honorable court by filing a memo, Milords.
Right. The same was produced also before another learned single judge in WP 12419 by 2018, which was allowed, saying that you have taken only, you have developed only 1 acre out of the total extent of 150 acres, which is subject to the declaration. And therefore the scheme had lapsed.
The scheme is not lapsed, Milords. There was a slight, they say that Alanali second stage is a separate layout. That scheme was lapsed, and Vasantanagara layout is a separate layout formed, Milords. But both are the same.
Have you seen this order?
No, Milords, I have.
Then without seeing the order, how can you argue?
Milords, I seek a short accommodation, Milords.
Or party irliಲ್ವಾ ಇದರಲ್ಲಿ?
Party ಇದಾರೆ, ಮೂಡ ಇದಾರೆ.
We appear for Muda itself.
Late senior.
You should be aware of this, isn't it?
Milords, our senior is not well, Milords. That is the reason why I am representing on his behalf, Milords. 2 days time may be granted, Milords.
Thursday, give her a copy. Thursday.
Yes, Milord.
Get a copy of this order.
Yes, Milord.
WP 12419 by 2018.
Yes, Milords.
The lordship may post this for further hearing so that.
Leave it on the lane change ಆಗಲ್ಲ. ಏನು SLP ಅಂತ ಬರೆದಲ್ಲ ಏನಿದೆ? SLP ಅಂತ ಬರೆದಲ್ಲ, what is SLP? 8453/17.
There was a litigation, my lord, where their lordship passed an order that since some matters were pending in SLP, but that had been disposed of, my lord. That has no bearing on this petition.
Produce the copy of that SLP also.
Please, my lord.
Income tax. Income tax.
But I'll obtain the copy, my lord. Have been clarified on the last occasion also, my lord.
SLP number ಬೇರೆ ತಪ್ಪಿದೆ ಅಂತ ಕಾಣ್ಸುತ್ತೆ.
For the respondent 1 and 2.
In this matter.
Yes.
Milord, and last time your lordship directed to ascertain whether the alternative site is available. PDA agreement to allot one alternative site, any one of the party. Petitioner or the third and fourth respondent. Here,
ಎಲ್ಲಿ ಕೊಡ್ತೀರಾ?
my lord, this is the 2030, less than 2030 site in the slum area, my lord. We will identify in the area, my lord, the now new layout, my lord.
Lord, there are two writ petition earlier. There are two sites which were allotted to different person in the year 1975. And later, the regular conveyance has been executed by the BDA. Subsequent to it, the petitioner has purchased both two sites from the said allottees. After that, after 10 years from there on, my lord, the BDA has cancelled the sale deeds, virtually allotment, and cancelled the sale deed also. Immediately next day, the site has been allotted to the two persons.
ಅಲ್ಲಿ ಮನೆ ಕಟ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು.
Two persons.
ಅಲ್ಲಿ ಮನೆ ಕಟ್ಕೊಂಡಿದ್ದಾರೆ ತಾನೆ? R2 and R3 have built a house there.
R2, my lord, insofar as other petitioner is concerned, that is, it is not in, my lord, that writ petition came to be rejected ultimately. Allowed and his allotment has been cancelled by virtue of the order dated 29/1/2013 itself. Other petition, only the respondent number 4 herein is fighting out. Insofar as site number 473 is concerned. 472, my lord, the order of reallotment has been cancelled, man.
But ಈ 473 on ಇದಾನಲ್ಲ,
Please,
if I remember last time, he has put up a house
please,
and is staying there.
please. Please, man.
ನೀವು ಸ್ವಾಧೀನ ಹೆಂಗ್ ತಗೊಳ್ತೀರಾ?
My lord, the legally he has occupied, that was the, my lord.
Suppose I were to cancel the allotment, how will you take possession?
My lord, what has happened, it is an illegal, my lord, I have to go for, my lord, regular,
ಅದು ಬೆಟ್ರ ಇಲ್ಲ ಸುಮ್ಮನೆ ಬೇರೆ ಸೈಟ್ ತಗೊಳ್ತೀರಾ?
I will ask. I will take the.
ಅದಕ್ಕೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಲ್ಲ ಹೋದ್ಸಲ.
No. Lord, now, my lord, they were alternative site ಎಲ್ಲಿ ಕೊಡ್ತಾರೆ ಅನ್ನೋದು it is important. Basis, my lord. Now,
They have constructed a house.
Lord, they illegally.
So if I were to set aside the cancellation,
Please.
and restore the title of.
BDA has,
how will you get possession?
my lord, BDA illegally, my lord, at the intervention of BDA, this act has been done by respondent number 4.
So you will now,
My
they will now initiate fresh proceedings and thereafter it will take 10 more years. You want to wait for 10 more years or?
Lord,
I cannot order them to be thrown out tomorrow.
There is a proceeding initiated by the BDA since it was disposed of earlier and again it was restored, this writ petition.
So what is that you want? You want to litigate or you want to get a
No,
site?
my lord, get the site, my lord. But now they will allot is the question, my lord. If it is a.
I would discuss to them, my lord, they will allot one site, my lord, in the, if it is available in that area, my lord, because this is the slum area, the sites. Otherwise, my lord, in the new layout.
ಅವ್ರಿಗೆ compensation?
My lord, compensation is concerned, my lord, they, even, my lord, my submission is, my lord. Even, my lord, that till 2013, they have not taken for the construction of the site, my lord, admittedly. In the 2013, after.
From 2013 to 2024.
2013 ಅಲ್ಲಿ as per their writ petition pleading, my lord, after the disposal of the earlier writ petition, they have started the construction, the other side. So once in the earlier writ petition, my lord,
Who gave them the right to construct? You approved their plan.
plan.
That is what they have said.
ಅಲ್ಲ ಅವರು ಅದು 89 ಅಲ್ಲಿ ಪ್ಲಾನಿಗೆ ಅಪ್ರೂವ್ ಮಾಡಿ ದಿಸ್ ಪರ್ಸನ್ಸ್
ಇಲ್ಲ ಇವ್ರಿಗೆ.
ಹೌದು ಇವರ್ ಪಿಟಿಷನರ್ಸ್
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 and 4 ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ. Pursuant to the approved plan ಅಂತ.
ಬಟ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದ
3 and 4 bed produced with the photographs consisting of ground and first floor as per the approved plan dated 27/8/2002.
But my lord, the writ petition, my lord, it was set aside the.
But ನೀವು ಅಪ್ರೂವ್ ಮಾಡಿದ್ದಾನೆ ಅವ್ರು ಕಟ್ಟಿರೋದು.
ಅಲ್ಲ ಅಪ್ರೂವ್ ಮಾಡಿದ್ರು ಅವ್ರು kindly see the para 11 of the writ petition, my lord. Even 2014 ತನಕ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿಲ್ಲ ನಂತರ.
ಇಲ್ಲ ಅವರು 2002 ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಅಪ್ರೂವಲ್ ಕೊಟ್ಟರೆ ಅವ್ರು ಕಟ್ಬಿಟ್ಟಿರ್ತಾವ.
ಇಲ್ಲ kindly our petitions paragraph 11 of the writ petition, my lord, kindly see. It is shows that, my lord, as on the date of the filing of the writ petition also, there is no construction, subsequently construction, my lord.
No, you prevented them from utilizing a site that they were entitled to.
But in the 2013, my lord, in the earlier writ petition.
93 was the sale of them.
Yes.
Sale it is of year
93. 92 for the vendors.
Then you cancel the allotment of the original allotment in the year 2002.
Yes.
That is after 20 years.
2/1/2000.
10 years.
20 years. Not sorry, 10 years.
Yes.
And
But
3/1
you had no right to do that.
My lord, by that time, they have not taken any steps, my lord.
Even if they have not taken any steps, how can you cancel the allotment after?
That is the mistake I have.
So for the 10 years compensation, who will pay?
My lord, in the 10 years, if they are my constructed, my lord, that is the one thing. Even after 2014 also, they have not constructed. The other side also, according to pleading, my lord, they started construction after the 2014, my lord. So once, my lord, in the 2013, the allotment of the petition is upheld and the allotment of the other side, the respondent 3 and 4 is cancelled, set aside.
ನೀವು ಯಾವ ಸೈಟ್ ಕೊಡ್ತೀರಾ, ಎಷ್ಟು ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳಿ ಅಷ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ.
Sites, my discussion, sites.
ಆಮೇಲೆ ಕಾಸ್ಟ್ I will decide.
Site, I discussed with the commissioner, he accepted, my lord.
Where is this site?
ಇದು ಆನಂದಪುರ ಸ್ಲಮ್ ಏರಿಯಾ, my lord.
ಯಾವ ಏರಿಯಾ ಬರುತ್ತೆ?
HAL 3rd stage.
ಮತ್ತೆ ನಗರ ಹತ್ರ ಇಂದ ನೀವು ನಾಡಪ್ರಭು ಕೊಟ್ರೆ ಸ್ವಲ್ಪ ಕಾಂಪನ್ಸೇಷನ್
ಕಮರ್ಷಿಯಲ್
ಅಲ್ಲಿ ಇದ್ರೆ ಹುಡುಕಿ, ಬಟ್ ಆ ಸ್ಲಮ್ ಏರಿಯಾದಲ್ಲಿ ಇವಾಗ ಸಿಗುತ್ತೆ.
When will you make a statement?
My lord, I discussed with, he said, my lord, we will select one site, verify and identify one site ಅಂತ ಹೇಳಿ.
ನೀವು ಅದೇ ಏರಿಯಾ ಸೈಟ್ ಕೊಟ್ರೆ I will not give.
ಅಲ್ಲ ಅದೇ ಏರಿಯಾದಲ್ಲಿ ಸಿಗ್ಬೇಕಲ್ಲ ಇವಾಗ.
ಅವಾಗ ಕಾಸ್ಟ್ ಕೊಡಲ್ಲ. ನೀವೆಲ್ಲರೂ ಬೇರೆ ಕಡೆ ದೂರದಲ್ಲಿ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ I will impose costs.
I will try, my lord, because the commissioner also said, my lord, they will try to identify site in the same area if it is available. Because this is the slum area, my lord, the vacant site ಇದ್ರು ಯಾರು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿಕೊಂಡಿರ್ತಾರೆ. Otherwise, we will allot some other areas.
Next Monday, you should give me a site number and an area.
Yes.
please, please.
Time ಕೇಳೋದಲ್ಲ.
Correspond number 190.
Objection, statement of objection, ಅಲ್ಲಿ state party ಮಾಡಿಲ್ಲ ಅಂತ objection raise ಮಾಡಿದ್ರು for non-joinder of necessary party.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರ?
Challenging the preliminary and the final notification, my lord, the preliminary and final notification is been issued in the name of the person who holds the property somewhere in 1932, who lost her right by way of settlement to her daughter, and subsequently they have sold.
But 84 notification you are challenging in 2014.
ಅಲ್ಲ ಸರ್, ಅಲ್ಲೇನಾಗಿದೆ, entire the notification is been quashed already by this court in connected to the adjoining property in the very same number.
Is that so?
Very same notification. Kindly see the serial number, the annexure W, my lord.
On what ground was it challenged? Was it quashed?
it has not been notified in the person who is the owner of the property. ಯಾರೋ ಆಲಮ್ಮ ಅನ್ಬಿಟ್ಟು ಒರಿಜಿನಲ್ ಓನರ್ ಸಮ್ವೇರ್ ಇನ್ 1930.
ಆಯ್ತು, ಬಟ್ ಎಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ ಬರಕಾಗುತ್ತೆ ನೀವು?
ಅಲ್ಲ ನಮ್ ಹೆಸರಲ್ಲೇ ಗೊತ್ತಿಲ್ಲ.
ಆಯ್ತು, 30 ವರ್ಷ ಆದ್ರೆ ಇನ್ನೇನು?
ನಮ್ಮ ಹೆಸರಲ್ಲೂ ಗೊತ್ತಿಲ್ಲ, ಅಕ್ವಿಷನ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ಪೊಸೆಷನ್ ತಗೊಂಡಿಲ್ಲ. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಇನ್ 2000 kindly look into annexure W, my lord, in identical this thing. This very notification is been quashed in so far as to their land is concerned. Either the part survey number. Later, recently, when they come to my portion of the property, I came to know immediately. I applied for the.
At least they came to court in 2009. When have you come?
I came in immediately after
they succeeded.
5 years. ಅದಾದ್ಮೇಲೆ ಗೊತ್ತಾಗಿದ್ದು ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ಇತ್ತು ಆಗ್ಲಿಂದ. 2009 ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದು. ಅದು ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ದಿ ಎಂಟೈರ್ ನೋಟಿಫಿಕೇಶನ್ ಇಸ್ ನಾಟ್ ಬೀನ್ ಕ್ವಾಶ್ಡ್, ಬಟ್ ದೇ ಹ್ಯಾವ್ 4-1ಗೆ ನಂದು ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿತ್ತು.
What have you done thereafter?
May kindly taken upon tomorrow, my lord. My senior wants to address the court. Thank you.
ಅವರು the only ground is delay and latches.
There is a delay of 30 years, my lord.
ಲಾಸ್ಟ್ ಟೈಮ್ ಪೊಸಿಷನ್ ಏನಾಗಿದೆ ನೋಡಿ ಅಂತ ಕೊಟ್ಟಿದ್ರು. ವೆದರ್ ದಿ ಪೊಸಿಷನ್ is ಏನಿದೆ ಪೊಸಿಷನ್ ಸ್ಟೇಟಸ್ ಆಫ್ ಪೊಸಿಷನ್ ಅಂತ. I taken the photograph in June 23, my lord. It is still vacant with my. Petitioner purchased in year 1967, much earlier to the preliminary notification. ಅವ್ರ ಹೆಸರಲ್ಲೂ ಆಗಿಲ್ಲ. His vendor ಹೆಸರಲ್ಲೂ ಆಗಿಲ್ಲ. 1965-66 ಅಲ್ಲಿ ಮುಟೇಶನ್ ಆಗಿ ಇದಾಗಿದೆ, ಅವ್ರ ಹೆಸರಲ್ಲೂ ನೋಟಿಫೈ ಆಗಿಲ್ಲ.
You are a subsequent purchaser.
ಅಲ್ಲ 1965 ನಲ್ಲಿ ದಿ ಆಲಮ್ಮ has settled the original the notice.
Who are you?
No, petitioner number 4 is subsequent. Petition number 1 is the purchaser in the year 1966-67. ಸೇಲ್ ಡೀಡ್ ಹಾಕಿದೆ 1966-67 ಅಲ್ಲಿ. Even in the earlier rate petition is also a purchaser of 1965-66. That rate petition came to be allowed. Survey number 49, entire extent is.
ಆ ಪಕ್ಕದ ಏನಾರು ಅವ್ರೇನಾರು ಬಿಟ್ಟಿದ್ರೆ ನಿಮ್ಗೆ ಒಂದು ಚಾನ್ಸ್, ಇಲ್ಲ ಅಂದ್ರೆ ಐ ಕಾಂಟ್ ಡೂ ಎನಿಥಿಂಗ್.
ಮೋಸ್ಟ್ಲಿ ಬಿಟ್ಬಿಟ್ಟಿದಾರ.
Mostly.
Kindly taken upon tomorrow, my lord, by the time.
Day after tomorrow.
I was taken instruction, my lord, nothing has happened so far.
ಅವ್ರೇ ಹೇಳ್ಬೇಕಲ್ಲ.
Notification, my lord, issued under the Slum Clearance Act. Slum Areas Improvement and Clearance Act 1973. The first notification which has been issued is Annexure B, page 28, my lord.
Page
28. This is dated 5/6/92. This notification is issued under section 3(1) of the Karnataka Slum Areas Improvement Clearance Act, declaring the slum area as a slum area. In this significantly, my lord, the petitioners are claiming to be the owners of survey number 136 and 137. 136 measuring 11 guntas and survey number 137 measuring 6 guntas, my lord. This is the,
What is your land?
136, 11 guntas, and 137, 6 guntas, my lord.
Yes. Yes.
136, my lord, is the piece of land which has been allotted by the Bangalore Development Authority. My lord, land of the petitioners were acquired and for the formation of 100 feet road by the Bangalore Development Authority. After the formation of the road, my lord, this piece of land was left out by the Bangalore Development Authority and
136
it was
standing in the-
reconveyed.
136 was standing in the name of Muniamma.
136, my lord, the name of the petition, that's the first ground which I want to make out. The name of the petitioner has not been shown in the notification, my lord.
When did you purchase this property?
It's not a land which has been purchased. It is Annexure E, my lord, page 136. Is an absolute sale deed executed by the Bangalore Development Authority in favor of Chikmarappa, son of Bodappa.
Page?
Page 94, my lord. The second, whereas the vendor Bangalore Development Authority notified for acquisition survey number 136 Binmangla for the formation of layout called 100 feet road to be linked to Madras Road, Indiranagar, and has taken possession of the land on 10/7/1985. Chikmarappa, son of and B, who are the owners of land bearing survey number 136 Binmangla village, requested the government to allot the balance of land 1 acre 14 guntas in survey number 136 to at free cost in lieu of the land being acquired by the BDA without making payment of compensation. Whereas the government in order number so and so ordered the remaining portion of land in 136 not utilized for the, by the Bangalore Development Authority for the formation of 100 feet road be allotted to the purchaser for their own free use of cost as no compensation is claimed by them.
This is 1 acre.
This is, my lord, only 136 measuring about
38,000.
11 guntas, my lord. Here in the notification, it is shown as Schedule E, my lord, of the sale deed gives the exact measurement actually. Approximately measures about 11 guntas, my lord.
There are two pieces of survey number 136. One says 38,280 and the other says 12,927.
Annexure Schedule E, my lord, is the portion of the land which has been allotted is, sorry, at internal page 3, at page 98, in page 98, my lord.
And there appears to be 3 pieces of land. There are 3 bits of land.
3 pieces of land, my lord, but total area.
One is 38,280, second is 12,927, and the third is 7,680. We are concerned with which bit?
In item number 1 and 2, my lord.
That roughly is almost more than an acre.
Yes. It appears 1 acre more than.
My lord, what they are restricting is to only 11 guntas, my lord.
Now, out of this 1 acre, they've declared 11 guntas as slum area.
Yes, ma'am. Only 11 guntas has been declared as a slum area.
Who is this lady shown in the notification, Muniamma?
This, my lord, is not known to the petitioners, my lord. We don't know who the petitioner's name is. And the other extent of land.
Then after this 3-1 notification, what happened?
You know, my lord, one more survey number, my lord, is survey number 137 measuring 6 guntas. This has also been allotted to the petitioner's predecessor entitled the father, my lord, by the Special Deputy Commissioner for Enams Abolition.
No,
by
there are 2 lands.
Annexure H, my lord.
There are 2 lands in Annexure B. One is 136, 11 guntas, 137.
137, 6 guntas, my lord.
6 guntas.
In this piece of land also, my lord, has been allotted to the petitioner's predecessor father.
Right. After this notification.
After this notification, the petitioners, my lord, had filed objections that is annexure Q, my lord, is the first objections filed by way of notice, 3/10/1992, page 151.
Page?
Page 151, annexure Q, my lord. In page 151.
Yes.
This is the first notice. Thereafter, my lord, once again, in the previous page, annexure P, page 150, once again is a notice issued by the slum board, my lord, asking the petitioners to produce all the documents in respect of the land. Now, in respect of this notification, two objections are filed, annexure N and annexure M. After that, my lord, no further proceedings take place. And finally, on 28/1/2014, annexure A is the final, what they say is the final notification, page 26, my lord. That is the annexure prior to the annexure B. Annexure A. In this notification, which says that it is a final notification, my lord.
Please read that.
I'll read the last paragraph, my lord. Last paragraph, that is sufficient, my lord. The previous paragraphs are all recitals. ಆದ್ದರಿಂದ ನಕ್ಷೆಯಲ್ಲಿ ಕಾಣಿಸಿದಂತೆ ಕೊಳಚೆ ಪ್ರದೇಶದ ಒಳಗಿರುವ ನಗರ ಮಾಪನ ಸಂಖ್ಯೆಯಲ್ಲಿ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ಖಾಲಿ ಜಾಗ ಮತ್ತು ರಸ್ತೆಯನ್ನು ಹೊರತುಪಡಿಸಿ ಅಥವಾ ಪ್ರಾರಂಭಿಕ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ನಮೂದಿಸಿರುವ ಈ ಕೆಳಕಂಡ ಶೆಡ್ಯೂಲ್ನಲ್ಲಿ ತೋರಿಸಿರುವ 31 ಗುಂಟೆ ಕೊಳಚೆ ಪ್ರದೇಶದಲ್ಲಿ ಗುಡಿಸಲು ಮನೆಗಳು ದುರಸ್ತಿ ಇಲ್ಲದೆ ಕುಡಿಯುವ ನೀರು, ದೀಪ, ರಸ್ತೆ, ಚರಂಡಿ ಇತ್ಯಾದಿ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳು ಇಲ್ಲದೆ ಅನಾರೋಗ್ಯದ ವಾತಾವರಣ ಉಂಟಾಗಿರುತ್ತದೆ. ಸದರಿ ಪ್ರದೇಶವನ್ನು ಅಭಿವೃದ್ಧಿಪಡಿಸುವುದು ಅಗತ್ಯವಾಗಿರುವುದಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಕರ್ನಾಟಕ ಕೊಳಚೆ ಪ್ರದೇಶಗಳ ನಿರ್ಮೂಲನಾ ಮತ್ತು ಅಭಿವೃದ್ಧಿ ಕಾಯ್ದೆ 1973 ಸೆಕ್ಷನ್ 3 ಅಡಿಯಲ್ಲಿ ಪ್ರಸ್ತಾವವಾಗಿರುವ ಅಧಿಕಾರದಂತೆ ಮೇಲ್ಕಂಡ ಕಾಯ್ದೆ ಸೆಕ್ಷನ್ 3 ಅಡಿ ಸರ್ವೆ ನಂಬರ್ 148ರಲ್ಲಿ 13 ಗುಂಟೆ ಜಮೀನನ್ನು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 1964 ಕಾಲಂ 68(1) ಮತ್ತು 68(5) ಅಡಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿರುವ ಷರತ್ತುಗೊಳಪಡಿಸಿ ಉಳಿದ ಸರ್ವೆ ನಂಬರ್ಗಳನ್ನು 136ರಲ್ಲಿ 11 ಗುಂಟೆ, 137ರಲ್ಲಿ 5 ಗುಂಟೆ ಮತ್ತು 141ರಲ್ಲಿ 2 ಗುಂಟೆ ಜಮೀನುಗಳನ್ನು ನಗರ ಮಾಪನ ಸಂಖ್ಯೆ 405 ಪೈಕಿ ಪ್ರದೇಶದ ಹಕ್ಕುದಾರಿಕೆ ಕುರಿತು ನಿರ್ಧಾರವಾಗಿಲ್ಲವಾಗುವುದರಿಂದ ಮತ್ತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಪಿಟಿಷನ್ 16576-16577 of 98 ದಿನಾಂಕ 29/1/2002 ಆದೇಶದಲ್ಲಿ ಮಾಲೀಕತ್ವದ ಬಗ್ಗೆ ಸಿವಿಲ್ ದಾವೆ ಆದೇಶಕ್ಕೆ ಒಳಪಟ್ಟಿದೆ ಎಂದು ಆದೇಶ ಇರುವುದರಿಂದ ಮುಂದೆ ಯಾವುದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆಗುವಂತಹ ಅಂತಿಮ ತೀರ್ಪಿಗೆ ಒಳಪಟ್ಟು 31 ಗುಂಟೆ ಪ್ರದೇಶವನ್ನು ಈ
OPS for the housing board.
Please, Mela.
IAP for the slum board, my lord. It is not that we acquire the land, my lord. It is that, my lord, if there is a slum is already existing, we receive a communication from the slum dwellers that such an area is not in habitual condition. Lords may kindly appreciate. As per section 3, what we does is, my lord, we collect entire information, including the photographs and everything. We forward it to the deputy commissioner. Deputy commissioner has to hold an inquiry. After holding an inquiry, deputy commissioner will declare that it is a notified slum. Once it is notified slum, then the picture of the slum clearance board will come, my lord. We will provide only the infrastructure, providing of lights, toilets, whatever that is necessary for the slum dwellers. Now, my lord, the question before your lordships is whether this deputy commissioner, while declaring this as a notified slum, has followed the procedure or not. For that, the government has to produce the documents, my lord, whatever the proceedings that has been taken place. It is immaterial, my lord, who is the owner. What is material is, my lord, whether there is a slum existing there or not. Once the slum is existing, my lord, kindly take section 3 of Slum Clearance Act, my lord.
Please read.
declaration of slum areas, where a government is satisfied that any area is or is likely to be a source of danger to health, safety or convenience to the of the public of that area or to its neighborhood by reason of they are being low-lying, insanitary, squid, or overcrowded or otherwise, or the building in any area used is intended to be used for human habitation or in any respect unfit for human habitation, or by any reasons of dilapidated or overcrowding, faulty arrangement and design of such building, narrows or a faulty arrangement of streets, lack of ventilation, light or sanitization facility, or any combination of these factors detrimental to satisfy health or morals, it may by notification declare such area to be a slum area. In determining whether the building is unfit or for human habitation for the purpose of this regard shall have to be a condition in respect of so and so. Let's now, what we receive a communication that such and such a area is not fit for human habitation.
Where is the concept of a preliminary notification and a final notification?
It is, once the, it has been sent to the Deputy Commissioner, he issues notice and he holds an inquiry.
No, the act does not contemplate a proposed slum area or a
No, we don't propose, once it is existing slum.
section 3 only says that you declare it to be a slum area.
Yes, sir.
Where is the question of a proposed slum area, hearing objections and then passing an order?
Section 3, my lord, declares it as a slum area, my lord. Thereafter, my lord, section 11.
And that is afterwards. We are now still only in section 3.
But then the power to declare the slum by area to be a section 11, my lord.
Section 11 is once you declare to be a slum area, then you decide to clear the slum. That is section 11. For declaring it as a slum area.
Power to declare any slum area to be a slum clearance area.
First declaration, it is a slum area, then a slum clearance area.
No, my lord, what we do is, my lord, once we receive a communication, we forward it to the.
What you do is not material. What does the law say?
My lord, law says, my lord, section 11, my lord. Power to declare any slum area to be a slum clearance area.
First it should
where
be a
the
slum.
government on a report.
First it should be a slum area. For you to declare it as a slum clearance area.
No, my lord, we don't declare it, my lord. We come to a conclusion that this is the the section 3. This is in compliance with section 3. That it is not habitual or human habitation.
We talks about a proposed slum area.
Proposed.
Then a declaration of a
Please,
slum
my lord.
area. I
Then-
want to know the procedure, which is
Lord,
the provision.
Once section 3 applies, then section 11 comes, my lord.
For section 3 to be applied, for a notification we should declaring a slum area.
No, my lord,
It
we
is-
don't, it is not, notification is not required, my lord. My lord, what it is required is that it is not in habitual condition. The condition parameters is required, my lord.
Please read section 3 subclause 2 once again.
In determining whether a building is unfit for human habitation for the
before
purpose
that.
of this act, regard shall be.
Before that, 3(1) sub-Roman 2. By
Two.
reason of dilapidation.
By reason of dilapidation, overcrowding, faulty arrangement and design of such buildings, narrows or faulty arrangement of streets, lack of ventilation, light or sanitation facility, or any combination of these factors detrimental to safety and the healthy morals, it may by notification declare such area to be a slum area.
There's only one notification declaring to a slum area. Annexure B says that it is declared to be a slum area.
Well, it is declared by the Deputy Commissioner.
That's what state government, Annexure B declares to be a slum area. Then what is the concept of issuing one more final notification under the Annexure A? That is nearly after how many years? 8 plus 14, 22 years.
Blood, they have to hold an inquiry and they.
Show me the provision where they have to
Section
hold
11,
inquiry.
section 11, blood.
11 is slum clearance area. We are not in that stage at all. We are still in the stage of section 3. Section 3 first requires it to be a slum area so that the slum board can enter into the picture and develop that slum area. See that that slum component is removed.
Blood, that is what, blood, we have declared it as under section 3 and we have forwarded every documents to the Deputy Commissioner. Now the state government has to produce those documents, what it has been.
Now I am unable to understand whether what is the concept of a preliminary notification and a final notification under section 3. There's only one declaration contemplated.
Blood, that is why section 11, blood.
Innocent section 11 ಓದಿ ನೀವೇ ಓದಿ.
Power to declare any slum area to be a slum clearance area. where a government on a report from the board or the prescribed authority or the local authority concerned or the state housing board or an officer authorized by the government for this purpose is satisfied as respects any slum area that the most satisfactory method of dealing with the conditions in the area is the clearance of such area and the demolition of all buildings in the area. It may by notification declare the area to be a slum clearance area, that is to say, an area to be cleared of all buildings in accordance with the provisions of this act. Provided that before issuing such notification, the government shall call upon the owners. Milord, this is what it is, Milord.
After you declare it to be a slum clearance area, section 12 says, on that notification being issued, the owner shall clear. If they don't clear, then you take steps. Then section 17 talks about acquisition of the land.
Acquisition, it is not the acquisition case, Milord. Before your all lordships, what the present case is, Milord, it is.
First ಕೇಳಬೇಕಿತ್ತಾನೆ ನೀವು.
What they are trying to say, my lord, is annexure A is the final notification. That is section 11 notification is what they are trying to say.
No, there should be a slum clearance area.
That's right. My ground is, there is no declaration that is a some clearance area.
They are not saying that. It is not. See, the notification does not talk about section 11.
Please, no mention of any section is there in that.
No, they seem to be thinking that this is a preliminary notification. Annexure B is a preliminary notification. Annexure A is a declaration. ಅದನ್ನ ಅವರು list. Resultantly, it is clear that there is no justification to grant any of the prayers made in the writ petition. I have thereafter directed the holding of an inquiry on your complaint and said, subject to the direction to the 13th respondent to pay cost to the Karnataka State Legal Services Authority to the tune of rupees 10 lakhs, and the direction to the High Court to hold an inquiry regarding the leakage of the inquiry report to the newspaper as stated in paragraph 1040. This writ petition is dismissed. Great.
I appear for respondent number 1 and 2.
The subject matter of the land, the survey number 184/3, my lord.
Revised enhanced compensation.
Yes, my lords. There was some, my lord, the rehabilitation scheme was introduced by the respondents, my lord. After the lapse of 7 years, my lord, the land has, they paid the compensation amount. While giving the indemnity bond itself, my lord, stated that subject to the government notification with regard to enhancement, my lord, I will accept this. He has given the indemnity bond. After that, my lord, he had made a representation, my lord, as per the government notification, my lord, he made an application for enhancement of the rate as per the prevailing rates, my lord. He made a representation before the KDB, my lord, annexure G may be kindly same, page number 21. They said that, my lord, they will consider it, my lord. Annexure G.
Annexure?
Annexure G, page 29, my lord.
Yes. Please read.
Annexure H, my lord, for that, my lord, 31. 31. UPCL ಉದ್ದೇಶಿತ so and so ಜಮೀನಿನ ಉಳಿಕೆ 632 ಎಕರೆ ಬಗ್ಗೆ ಈ ಭೂ ಪರಿಹಾರ ಪಾವತಿಸಲು ಹಣ ಬಿಡುಗಡೆ ಮಾಡುವ ಕುರಿತು ಸುಬೇದಾರ್ ಮೇಜರ್ ಪಿ ರಾಧಾಕೃಷ್ಣ ಶಣೈ ನಿವೃತ್ತ ಇವರ ಮನವಿ ದಿನಾಂಕ 7/3/2024 ಕ್ಯಾಪ್ಷನ್ ರೆಫರೆನ್ಸ್ ಮೇಲೆ ಉಡುಪಿ ಜಿಲ್ಲೆ so and so ಜಮೀನು 46 UPCL ಅವರ ಉದ್ದೇಶ ಭೂಸ್ವಾಧೀನಗೊಂಡಿರುತ್ತದೆ. ಸ್ವಾಧೀನಗೊಂಡ ಜಮೀನುಗಳ ಪೈಕಿ ಮೇಲಿನ ಜಮೀನು ಒಳಗೊಂಡಂತೆ 632 ಎಕರೆಗೆ ಪರಿಹಾರಧನ ಬಿಡುಗಡೆಯಾಗದ ಕಾರಣ ಭೂ ಪರಿಹಾರದ ಪಾವತಿಯಾಗಿರುವುದಿಲ್ಲ. ಈ ಜಮೀನನ್ನು ವಿಶೇಷ ಭೂಸ್ವಾಧೀನಕಾರಿ ಮತ್ತು ಅಧಿಕಾರಿ ಸೊಯೆನ್ಸೋ ಮಂಗಳೂರು ಇವರು ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿ ವಾಸ್ತವಾಂಶ ವರದಿ ಮಾಡಿ ಸೊಯೆನ್ಸೋ ಅಂತ ತಿಳಿಸಿರುತ್ತೀರಿ. ಅದರಂತೆ ದಿನಾಂಕ 7/3/2014 ಮತ್ತು ಕಂದಾಯ ನಿರೀಕ್ಷರು ಭೂ ಸೊಯೆನ್ಸೋ ಸುಬೇದಾರ್ ಮೇಜರ್ P ರಾಧಾಕೃಷ್ಣ ಸೈ ಮತ್ತು UPCL ಜೊತೆಗೆ ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆಯನ್ನು ನಡೆಸಲಾಗಿದೆ. ಭೂ ಸ್ವಾಧೀನ ಜಮೀನುಗೊಂಡ ಜಮೀನು ಸೊಯೆನ್ಸೋ 166 ಎಕರೆ ಸೇರಿ ಒಟ್ಟು 6.3 ಎಕರೆ ಜಮೀನು UPCL ಕಂಪನಿ ಆವರಣದ ಒಳಗಡೆ ಇದ್ದು ಅವರ ಸ್ವಾಧೀನದಲ್ಲಿ ಇರುತ್ತದೆ. ಜಮೀನು ನಿರ್ವಹಿತರಿಗೆ ಪುನರ್ವಸತಿ ಕಲ್ಪಿಸುವ ಜಮೀನಿಗೆ ತಾಗಿಕೊಂಡಿರುತ್ತದೆ. ಜಮೀನು ಸದ್ಯಕ್ಕೆ ನಮಗೆ ಅಗತ್ಯವಿಲ್ಲ ಎಂಬ ಅಭಿಪ್ರಾಯವನ್ನು ಕಂಪನಿಯವರು ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಭೂ ಮಾಲೀಕರು ಪ್ರತಿಕ್ರಿಯಿಸುತ್ತಾ, ನಾನು ಮಾಜಿ ಯೋಧನಾಗಿದ್ದು ಪಾಕಿಸ್ತಾನ ಯುದ್ಧದಲ್ಲಿ ಭಾಗವಹಿಸಿ ರಾಷ್ಟ್ರಪತಿ ಪದಕಗಳನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಅದೇ ನೆಲೆಯಲ್ಲಿ ಮೇಲಿನ ಜಮೀನು ನನಗೆ ಮಂಜೂರಾಗಿರುತ್ತದೆ. 72 ವರ್ಷವಾಗಿದ್ದು ಹಿರಿಯ ನಾಗರಿಕ ಆಗಿದ್ದೇನೆ. ಆರೋಗ್ಯವೂ ಸರಿ ಇಲ್ಲ. 1990 ಜಮೀನನ್ನು ಸ್ವಾಧೀನಪಡಿಸಿರುವುದರಿಂದ ಜಮೀನು ಅಭಿವೃದ್ಧಿಪಡಿಸಲು ಆಗಿರುವುದಿಲ್ಲ. ಜಮೀನು ಈಗ ವಾಪಸ್ಸು ಮಾಡಿದಲ್ಲಿ ಪರಿಸರ ಮಾಲಿನ್ಯದಿಂದ ಮತ್ತೆ ಈ ಜಮೀನಲ್ಲಿ ವಾಸಿಸುವಂತೆ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಈಗಾಗಲೇ ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿದ ಜಮೀನಿನ ಭೂ ಮೌಲ್ಯ ಪಾವತಿ ಮಾಡುವಂತೆ ವಿನಂತಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಸರ್ವೆ ನಂಬರ್ 84/3ರಲ್ಲಿರುವ ಸೊಯೆನ್ಸೋ 1 ಎಕರೆ ಜಮೀನುಗಳು ಮತ್ತು ಸೊಯೆನ್ಸೋರಂತೆ ಅಧಿಸೂಚನೆಯಾಗಿ ಸೊಯೆನ್ಸೋರಂತೆ ಅಧಿಸೂಚನೆಯಾಗಿರುತ್ತದೆ. ಜಮೀನು ಸುಮಾರು 18 ವರ್ಷಗಳಿಂದ NTPL UPCL ಕಂಪನಿಯ ಅಧೀನದಲ್ಲಿರುತ್ತದೆ. ಆದುದರಿಂದ ಜಮೀನನ್ನು ಮತ್ತು ಈ ಭೂಮಕ್ಕೆ ವಾಪಸ್ಸು ಮಾಡಿದರೂ ಕೃಷಿ ಅಭಿವೃದ್ಧಿ ಪಡಿಸಲು ಅಥವಾ ಮನೆ ಕಟ್ಟಲು ವಹಿಸಲು ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ. ಜಮೀನು UPCL ಘಟಕದ ಪಕ್ಕದಲ್ಲೇ ಇರುತ್ತದೆ. ಸದ್ರಿ ಜಮೀನಿಗೆ ಈ ತನಕ ಪರಿಹಾರ ಪಾವತಿ ಆಗದ ಕಾರಣ ಮಾಜಿ ಯೋಧರಾದ ಬಹುಮಾಲೀಕರು ಲೋಕಾಯುಕ್ತಕ್ಕೂ ದೂರು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ದೇಶಕ್ಕಾಗಿ ಹೋರಾಡಿದ ಹಿರಿಯ ನಾಗರಿಕರಾದ ಸುಬೇದಾರ್ ಮೇಜರ್ P ಸೊಯೆನ್ಸೋ ಜಮೀನಿಗೆ ಮಾನವೀಯತೆ ದೃಷ್ಟಿಯಿಂದ ಭೂ ಪರಿಹಾರ ಪಾವತಿ ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ. ಆದುದರಿಂದ UPCL ಪ್ರಧಾನ ವ್ಯವಸ್ಥಾಪಕರಿಗೆ ಮತ್ತೊಮ್ಮೆ ಪತ್ರ ಶೀಘ್ರ ಹಣವನ್ನು ಮಂಡಳಿಗೆ ಠೇವಣಿ ಮಾಡುವಂತೆ ತಿಳಿಸಬಹುದು ಎಂಬ ಅಭಿಪ್ರಾಯವನ್ನು ನೀಡಲಾಗಿದೆ. ಸ್ಥಳೀಯ ನಿವಾರಿಸಿದೆ. And subsequent order also annexed G my lord, there was a direction to my lord.
Have taken possession of this land?
Lord,
You have taken possession of
we
this
have
land?
taken possession, paid compensation, my lord.
When?
My lord, I have filed my statement of objection. It is an.
Compensation is
through-
paid
Because
1.66.
This communication gives an indication that no compensation was paid.
Well, compensation paid to the extent 1.66 acre, that is admitted. I have also taken. For that, my lord, your lordship may kindly see.
This is for the remaining 6 acres.
Yes, my lord, yes, my lord. No, your lordship may
That was notified?
no, notify 166, it's 166 only notified.
And what about 6 acres 32 gunters?
That is why I submitted, my lord, since if they have taken possession of the remaining land also, I'm not in a position to cultivate nor do any kind of
Is
improvement.
there to show that they have taken possession of 6 acres 32 gunters?
Well, that they admit, my lord, it is in their possession, it is in their
Where do they
possession.
admit?
Well, kindly see the RTC 166 acre, my lord, that is KDB, my lord, page number 20. And my lord, I have submitted the representation, page 24, my lord. Kindly see. There I have stated, page 24.
No,
ನೀವು ತಿಳಿಸಿದಂತೆ
no, here
ಎಲ್ಲಾ
also-
ದಾಖಲೆಗಳು ಮತ್ತೆ ಸ್ವೀಕರಿಸಿ, ಆದರೆ ಈ ಕಡೆ ಇದು ತಾತ್ಕಾಲಿಕ ಪರಿಹಾರವನ್ನು ಹೇಳ ಬಯಸುತ್ತೇನೆ. Immediately I stated, they have pressurized me.
Number 180, page number 20.
Please, my lord.
Police number 184 measuring 1 acre 66 cents.
Yes, my lord.
Where have they taken possession of 6 acres 32 cents?
Well, it is still there in possession. They have occupied it. It is in their compound only. That is why I submitted, you pay compensation to that extent also. That is
No,
not
where
considered.
do I get it that 6 acres 32 cents is within their compound?
Well, it is their admission only, my lord. It
Show
is
me the admission.
That is why it said, my lord. Well, kindly look at this one.
Which survey number are we concerned with?
Well,
now?
page 29, my lord. Same survey number, same survey number. It's a Janti survey has been done, my lord. Janti survey. Page 29. So and so illi tanaka,
Where is the notification?
well, with regard to this, no notification.
My lord, it's page number 19.
They, in the objection statement, they say with regard to my indemnity bond and the payment of voucher, the only 2 documents they produce.
My lord, the notified area is 1 acre 6.
7/3/2023 ಎಂದು
Here-
ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಲಾಗಿದೆ. 29 ಮೇಲೆ.
Here only 184/3.
Yes, my lord.
Measuring 1 acre 66 cents is notified.
Yes.
Then what is the 6 acres 32 gunters?
Well,
Which
it is the remaining land, my lord.
survey number? Which survey number?
Same survey number. Same survey number.
The RTC that you have produced.
Yes, my lord, that is the acquired area. The RTC has been notified in there.
Which is the area which is not notified, but standing in your name?
Well, that is the remaining extent in the same survey number.
If I accept your RTC, Only 1 acre 66 cents is the extent of 184.
Yes, my lord. After that, my lord, when the land, they have taken possession of the land, I made a representation that, all right, you take this.
Show me a document to show that 6 acres 32 cents belongs to you and they have taken possession of 6 acres 32 cents.
Survey report itself indicates.
Where is the survey?
My lord, kindly see, my lord. 13/3/24/29. There is a recital is there. They admit 29, my lord, page 29.
Yes.
ಮಿಡ್ಲ್ ಮೇಲೋ ಇವರಿಗೆ ತಿಳಿಸುವುದು ಬಂತು ಸದ್ರಿ ಜಮೀನಿನ ವಾಸ್ತವಾಂಶವನ್ನು ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿ ವರದಿ ಸಲ್ಲಿಸುವಂತ ಉಲ್ಲೇಖಿತ ಜಿಲ್ಲಾಧಿಕಾರಿಯವರು ತಿಳಿಸಿರುತ್ತಾರೆ.
29.
ಅದರ ಪೇಜ್ 29 ಮೇಲೋ.
Please read from the beginning.
ಆಮೇಲೆ ಉದ್ದೇಶಿತ ಯೋಜನೆಗಾಗಿ ಭೂಸ್ವಾಧೀನಗೊಂಡ ಉಡುಪಿ ಜಿಲ್ಲೆ 46.73 ಎಕರೆ ಜಮೀನಿನ ಪೈಕಿ ಉಳಿಕೆ 632 ಎಕರೆ ಜಮೀನಿಗೆ ಭೂ ಪರಿಹಾರ ಠೇವಣಿ ಹಣ ಮಾಡುವ ಕುರಿತು. The first itself. So it excludes 1.66.
Please read.
Please, my lord. ಉಡುಪಿ ತಾಲೂಕು ತೆಂಕ ಗ್ರಾಮದ ಸೊಯೆನ್ಸು 61 ಮತ್ತಿತರ ಒಟ್ಟು 6.32 ಎಕರೆ ತಮ್ಮ ಉದ್ದೇಶಿತ ಯೋಜನೆಗಾಗಿ 18/7/98 ಭೂಸ್ವಾಧೀನ 28/4 ಅಧಿಸೂಚನೆಯಾಗಿ ಭೂಸ್ವಾಧೀನಗೊಂಡಿರುತ್ತದೆ.
Stop here.
Please.
So in this 18/7/98.
Yes.
6 acres 32 cents were notified.
1 acre 66, my lord, they acquired and paid the compensation. 7,52,000.
There is this 28/4 notification annexure A alva. Only 184/3 measuring 1 acre
66 cents.
was notified. So what is the total extent of 184/3?
184 total RTC extent, well, no idea. I have to look it up.
Lord,
I can't
for a
blindly
minute,
say.
my lord, your lordship may have.
So your lordship may kindly permit me to continue this, well, there also they say.
Your lordship.
So ಉಳಿಕೆ ದನಕ್ಕೆ ಸದ್ರಿ ವಾಂಶವಂತ ಜಂಟಿ ಸ್ಥಳಕ್ಕೆ ಈ ಸಂದರ್ಭ ಭೂ ಮಾಲೀಕರೊಂದಿಗೆ ನೀವು ಕೂಡ ಹಾಜರಿರುತ್ತೀರಿ. ಜಮೀನಿನ ವಾಸ್ತವಾಂಶದ ಬಗ್ಗೆ ಸಮಾಲೋಚನೆ ನಡೆಸಿದ ತೆಂಕ ಗ್ರಾಮದ ಒಟ್ಟು ಎಕರೆ ಸೇರಿ 630 ಎಕರೆ ಜಿಮ್ಮಾ ಆವರಣದ ಒಳಗಡೆ ಇರುತ್ತದೆ. ಜಮೀನು ಉದ್ದೇಶಿಕ ಜೋನಿಯ ನಿರ್ವಹಿತರೆ ಹಂಚಬೇಕಾಗಿದ್ದು. This is made by the special land acquisition. It is the beneficiary Udupi Power Corporation. It has been written.
You are in possession of 6 acres 32 cents, including 1 acre 66 cents within your compound?
I'm not aware.
My lord, may I clarify, my lord? Page number 29. First para, my lord, Udupi Taluku Tenga Grama survey number.
Forget about the first paragraph. Read the contents. Udupi Taluku Tenka Grama.
That is what, my lord. Udupi Taluku Tenka Grama survey number 184/3 1.66 ಎಕರೆ ಮತಿತರ ಒಟ್ಟು ಮತಿತರ ಅಂದ್ರೆ ಬೇರೆ, my lord.
ಓದಿ ಪೂರ್ತಿ
6 ಎಕರೆ 6.32 ಎಕರೆ ಜಮೀನು ತಮ್ಮ ಉದ್ದೇಶಿತ ಯೋಜನೆಗಾಗಿ ದಿನಾಂಕ ಸೋನ್ಸೋರಂದು ಭೂ ಸ್ವಾಧೀನ ಕಾಯ್ದೆ ಸೋನ್ಸೋ ಅಧಿಸೂಚನೆಯಾಗಿ ಭೂ ಸ್ವಾಧೀನಗೊಂಡಿರುತ್ತದೆ. ಆದರೆ ಇಲ್ಲಿಯ ತನಕ ಪರಿಹಾರ ಧನ ಕೇಂದ್ರ ಕಚೇರಿಗೆ ಠೇವಣಿಯಾಗದೆ ಇರುವುದರಿಂದ ಭೂ ಮಾಲೀಕರಿಗೆ ಪರಿಹಾರ ಧನ ಪಾವತಿಸಿರುವುದಿಲ್ಲ. ಭೂ ಸ್ವಾಧೀನಗೊಂಡ ಜಮೀನು ಈ ಕಂಪನಿಗೆ ಅಗತ್ಯವಿಲ್ಲ ಎಂದು ನೀವು ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿ KDB ಬೆಂಗಳೂರು ಇವರಿಗೆ ತಿಳಿಸಿರುವುದು ಉಲ್ಲೇಖಿತ ಪತ್ರ 1ರಂತೆ ತಿಳಿದು ಬಂದು ಸದ್ರಿ ಜಮೀನಿನ ವಾಸ್ತವಾಂಶವನ್ನು ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿ ವರದಿ ಸಲ್ಲಿಸುವಂತೆ ಉದ್ದೇಶಿತ ಪತ್ರದಲ್ಲಿ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಯವರು ತಿಳಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ದಿನಾಂಕ ಸೋನ್ಸೋರಂದು ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಲಾಗಿದೆ. ಈ ಸಂದರ್ಭ ಭೂ ಮಾಲೀಕರೊಂದಿಗೆ ನೀವು ಸಹ ಹಾಜರಿರುತ್ತೀರಿ. ಜಮೀನಿನ ವಾಸ್ತವಾಂಶದ ಬಗ್ಗೆ ಸಮಾಲೋಚನೆ ನಡೆಸಲಾಗಿ ತೆಂಕ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 184/3 1.66 ಎಕರೆ ಸೇರಿ 6.32 ಎಕರೆ ಜಮೀನು ನಿಮ್ಮ ಆವರಣದ ಒಳಗೆ ಇರುತ್ತದೆ.
So
the survey number 180.
You are saying that you conducted a joint inspection in the presence of that company. Please found out that apart from this 1 acre 66 cents which was notified, a total extent of 6 acres 32 cents was within the compound of the company.
Correct, my lord, but 184/3 is contain only 1 acre 66.
Your letter says something.
Lord, ಮೇಲ್ಗಡೆ ಈ ತರ
ಕೆಳಗಡೆ ಓದಿ ಜಂಟಿ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ಜಮೀನ ವಾಸ್ತವಾಂಶಕ್ಕೆ ಸಮಾಲೋಚನೆ ನಡೆಸಲಾಗಿ ತೆಂಕ ಗ್ರಾಮದ 184/3
ಒಂದು 184/3 ಅಂದ್ರೆ 180/3 1.66 ಎಕರೆ ಅದು ಸೇರಿ ಟೋಟಲ್ ಇಷ್ಟಿದೆ ಅಂತ ಹೇಳಿದೀವಿ. ಅದ್ರಲ್ಲೇ ಇಷ್ಟಿದೆ ಅಂತ ಹೇಳಿಲ್ಲ ನಾವು.
ಪೂರ್ತಿ ಅದೇ ಓದ್ತಿಲ್ಲ ನೀವು.
Please, my lord.
1.66 ಎಕರೆ ಸೇರಿ 6.32 ಎಕರೆ ಜಮೀನ್ ನಿಮ್ಮ ಆವರಣದ ಒಳಗಡೆ
ಆವರಣದಲ್ಲಿ
ಇರುತ್ತದೆ.
ಇರುತ್ತದೆ.
Which is that extra land over and above?
Notified in other survey numbers. My lord,
Why did you ask him to pay compensation to this client?
my lord, we have paid him for 1 acre.
This is your letter.
My lord, we are saying that.
You are asking the company to pay for the remaining extent, which is their possession,
Please,
to
my
the
lord,
petitioner.
we are totally asking for them to pay 6 acre 32 guntas. In that he is entitled for 1 acre 66. We have paid him.
If you see the other contents,
Please,
you are asking him to be paid. Why would you say that? You would have said, I've already paid to this ex-serviceman.
my lord, ಇವ್ರಿಗೂ ಸೇರಿಸಿ ಬೇರೆಯವ್ರಿಗೂ ಪೇ
ದಯವಿಟ್ಟು
ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಓದಿ, ಪೂರ್ತಿ ಲೆಟರ್ ಓದಿ. ಬೇರೆ ಯಾರ ಬಗ್ಗೆನೂ ಮಾತಾಡ್ತಿಲ್ಲ, ಅವನ ಮೇಲೆ ಅಷ್ಟೇ ಮಾತಾಡ್ತಿರೋದು ನೀವು.
ಕರೆಕ್ಟ್. ಜಮೀನು ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
ಜಮೀನು ಉದ್ದೇಶಿತ ಯೋಜನೆಗೆ
ಜಮೀನು ಉದ್ದೇಶಿತ ಯೋಜನೆಗೆ ನಿರ್ವಹಿಸಿದ್ದಕ್ಕೆ ಹಂಚಬೇಕಾಗಿದ್ದು ವಿದ್ಯುತ್ ಸ್ಥಾವರ ಸನಿಹದಲ್ಲಿರುತ್ತದೆ. ಜಮೀನನ್ನು
ಡಿನೋಟಿಫೈ
ಮಾಡಿರುವುದರಿಂದ ಪರಿಸರ ಮಾಲಿನ್ಯದಿಂದ ಕೃಷಿ ಮಾಡಲು ಅಥವಾ ಮನೆ ಕಟ್ಟಿ ವಾಸಿಸಲು ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಜಮೀನನ್ನು ವಾಪಸ್ಸು ನೀಡದೆ ಮಾನವೀಯ ನೆಲೆಯಲ್ಲಿ ಪರಿಹಾರ ನೀಡುವಂತೆ ಭೂಮಾಲೀಕರಾದ ಸೋನ್ಸೋರವರು ವಿನಂತಿಸುತ್ತಾರೆ.
Is the petitioner.
Please, my lord.
He is seeking for that. ಉಲ್ಲೇಖಿತ 2ರಂತೆ ಈ ಕಚೇರಿಯನ್ನು ಕೋರಿರುತ್ತಾರೆ. ಮನವಿದಾರರ ಭೂಮಾಲೀಕರು ಮಾಜಿ ಯೋಧರಾಗಿದ್ದು ಹಿರಿಯ ನಾಗರಿಕರಾಗಿರುತ್ತಾರೆ. ಆದುದರಿಂದ ಮಾನವೀಯ ನೆಲೆಯಲ್ಲಿ ಭೂಮಾಲೀಕರಿಗೆ ಪರಿಹಾರ ಧನ ಪಾವತಿಸಲು ಹಣ ಠೇವಣಿ ಮಾಡುವ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ತಿಳಿಸಿದೆ.
My lord, he has sought for a compensation of 1.66 acres. My lord, your lordship
Then
may
why
have
did you write a letter to this
My lord,
company?
we are asking the company to deposit for entire land, including his land. We have not
You have already paid him compensation.
we have not
Why?
paid, my lord. Thereafter we paid. When we are writing this letter, we have not paid for 6 acre 32 guntas. We are entirely asking them to deposit.
Where is your objections?
My lord, before that, your lordship may have it page number 27 of the petition.
The
It is the
objection statement,
representation
they say
given by
they-
the-
I have
given
waived
by
my
the
right.
petitioner.
Objection statement, paragraph number 6 ಮೇಲೋ.
Page number 27, my lord.
Yes.
My lord, ದಿನಾಂಕ 7/3/2005.
Paragraph number 6, it is submitted that the petitioner himself has handed over the possession of the land under acquisition and has received the entire compensation due under section 2090.
Read page 27.
27 typed copy, my lord. ದಿನಾಂಕ ಸೋನ್ಸೋರುಂಡು ಉಡುಪಿ ಜಿಲ್ಲೆ ಉಡುಪಿ ತಾಲೂಕು ತೆಂಗಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 184.3ರಲ್ಲಿ 1.66 ಎಕರೆ ಜಮೀನಿಗೆ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿದ ಬಗ್ಗೆ. ನೋಡಿ, ಉಡುಪಿ ತಾಲೂಕು ಶಿವನಹಳ್ಳಿ ಗ್ರಾಮ ಗುಂಡೆಬೈಲು ನಿವಾಸಿ ರಾಧಾಕೃಷ್ಣ ಸೆನೈರವರನ್ನು ವಿಚಾರಿಸಿ ಬರೆಸಿಕೊಂಡ ಹೇಳಿಕೆ. ಉಡುಪಿ ತಾಲೂಕು ತೆಂಗಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 184/3ರಲ್ಲಿ 1.66 ಎಕರೆ ಜಮೀನನ್ನು ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಮತ್ತು ವಿಶೇಷ ಭೂಸ್ವಾಧೀನ ಅಧಿಕಾರಿಗಳು KEDB ಇವರು ಬಂದು ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿದ ಸಮಯ ನಾನು ಹಾಜರಿದ್ದು ನನ್ನ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 184/3ರಲ್ಲಿ 1.66 ಎಕರೆ ಜಮೀನು 2006ರಲ್ಲಿ ಭೂ ಸ್ವಾಧೀನಗೊಂಡಿರುತ್ತದೆ ಮತ್ತು ಪಹಣಿ KEDB ಬೈಕಂಪನಿ ಇವರ ಹೆಸರಿನಲ್ಲಿ ವರ್ಗಾವಣೆಯಾಗಿರುತ್ತದೆ. ಈ ಜಮೀನಿಗೆ ಭೂ ಪರಿಹಾರ ನನಗೆ ಇಲ್ಲಿಯವರೆಗೂ ಪಾವತಿಸಿರುವುದಿಲ್ಲ. ಸದರಿ ಜಮೀನನ್ನು ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳು ಈ ದಿನ ತನಿಖೆ ನಡೆಸಿದ್ದು ನೋಡಿ, ಸ್ವಲ್ಪ 2 ಲೈನ್ ಸ್ಕಿಪ್ ಆದ್ಮೇಲೆ ನಾನು ಒಬ್ಬ ಮಾಜಿ ಸೈನಿಕನಾಗಿದ್ದು ಇದೇ ನೆಲೆಯ ಸರ್ವೆ ನಂಬರ್
ಸದರಿ ಜಮೀನು ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳು ಈ ದಿನ ತನಿಖೆ ನಡೆಸಿದ್ದು EPCDL ಕಂಪನಿಯ ಪರವಾಗಿ ಸಂದರ್ಶನ ಕೂಡ ಹಾಜರಿದ್ದು ಜಮೀನನ್ನು ಡಿನೋಟಿಫೈ
ಮಾಡುವ ಬಗ್ಗೆ ಅಭಿಪ್ರಾಯ ಪಟ್ಟಿದ್ದು ನನಗೆ ತಿಳಿದು ಬಂತು.
ಕಂಪನಿಯ ಪರವಾಗಿ ಸುದರ್ಶನ್
ಒಬ್ಬ ಮಾಜಿ ಸೈನಿಕನಾಗಿದ್ದು ಇದೇ ನೆಲೆಯ ನನಗೆ ಸರ್ವೆ ನಂಬರ್ 184/3ರಲ್ಲಿ 1.6 ಎಕರೆ ಜಮೀನು ಮಂಜೂರಾಗಿರುತ್ತದೆ. ಈಗ ನನಗೆ 72 ವರ್ಷ ಪ್ರಾಯವಾಗಿದ್ದು ಹಿರಿಯ ನಾಗರಿಕನಾಗಿರುತ್ತೇನೆ. ಈಗ ನನ್ನ ಜಮೀನು ಸರಿ ಉಳಿದ ಪ್ರದೇಶ ಸೋ ಕಂಪನಿಗೆ ಭೂ ಸ್ವಾಧೀನಗೊಂಡಿರುತ್ತದೆ. ಈಗ ಮತ್ತೆ ಇದೇ ಜಮೀನನ್ನು ವಾಪಸ್ ಪಡೆದು ಅಲ್ಲಿ ಕೃಷಿ ಮಾಡಲು ಅಥವಾ ಪರಿಸರ ಮಾಲಿನ್ಯದಿಂದ ಮನೆ ಕಟ್ಟಿ ವಾಸಿಸಲು ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ.
ಅಸಾಧ್ಯವಾಗಿರುತ್ತದೆ.
It is only for 1 acre 66 cents.
66, sir.
Only for 1 acre 66 cents.
My lord,
Well, it's a land, my lord.
that
1 acre 66 cents.
which is acquired. And
You have got-
remaining also found to be in their possession. That is why joint survey was conducted.
Where do I get in page 27? You are admitting in your statement that you lost only 1 acre 66 cents.
Kindly see, my lord.
And your claim was that you
ಉಳಿದ
had not,
ಉಳಿದ ಪ್ರದೇಶ ಅವರ ಸ್ವಾಧೀನವಿರುತ್ತದೆ.
ಎಲ್ಲಿದೆ?
ಈಗ ನನ್ನ ಜಮೀನು ಸೇರಿ ಉಳಿದ ಪ್ರದೇಶ UPICL ಕಂಪನಿಗಾಗಿ ಭೂ ಸ್ವಾಧೀನ ಕೊಂಡಿರುತ್ತದೆ.
ಸಲ ನೋಡಿ, ನಾನು ಒಬ್ಬ ಮಾಜಿ ಸೈನಿಕನಾಗಿದ್ದು
ಅಲ್ಲ, ನಾನು ಒಬ್ಬ
ಇದೇ
ಮಾಜಿ ಸೈನಿಕ.
ನಂಬರ್ 184/3 ಒಂದು ಎಕರೆ 66 ಎಕರೆ ಜಮೀನು ಮಂಜೂರಾಗಿರುತ್ತದೆ.
ಈಗ ನನಗೆ
72 ವರ್ಷ ವಯಸ್ಸಾಗಿದ್ದು
ಹಿರಿಯ ನಾಗರಿಕನಾಗಿರುತ್ತೇನೆ.
ಈಗ ನನ್ನ ಜಮೀನು ಸೇರಿ
ಸೇರಿ
ಉಳಿದ
ಉಳಿದ ಪ್ರದೇಶ UPCL ಕಂಪನಿಗಾಗಿ. That is means the remaining 6 acres, my lord.
What is there to show that you own the remaining 6 acres 32 guntas?
My lord, that is there produced. I'll look into the matter.
ಏನ್ ಬೇಡ ನೀವು.
My lord, I have to look into this matter. If this kind of ambiguity is there, my lord, I will.
Show me from your writ petition that you own 6 acres 32
My
cents.
lord, in the survey itself,
Show me in your writ petition the averment that you own 6 acres 32 cents.
Lord, the government says he is the owner of 1 acre 66.
my lord, with regard to the acquired land, I have submitted, my lord.
Show me that you own 6 acres 32 cents, out of which you have paid common only for 1 acre 66 cents and remaining has to be paid. This is why I said in the morning. This is why I said in the morning. You will fix a rate. If they don't accept it, they are damned. If they accept it, they are damned.
No, my lord, they have
Should have
accepted.
simply passed an award and referred it to the civil court.
My lord, as there was no dispute, we have offered them the consent award, my lord.
You
lord,
offered them what you think was right, not what they thought was right.
That is the procedure under KD Act, my lord. We have
Please
to,
read the procedure.
my lord, section 29(2).
Please read.
My lord, section 29(2), where the amount of compensation has been determined by the agreement between the state and the person to be compensated. It shall be paid in accordance with such agreement.
Who is the state government?
Is the SLO, my lord. He is the delegative of
There should be an agreement between the land acquisition officer and the,
land loser.
if they don't agree on compensation, what is to be done?
General award has to be passed and
Read section 29(2) again. Thereafter, what should be done?
section 29(2), my lord.
After they fail to agree, then next.
Section 29(3), where no such agreement can be reached, the state government shall refer the case to the deputy commissioner for determination of the amount of compensation to be paid for such acquisition and also the person or persons to whom the such compensation has been paid.
Where is the provision for you to have a committee headed by the special deputy commissioner to determine the price?
My lord, this is a,
If both of you don't agree, it will go to the DC.
please,
If the DC himself heads the committee and fixes the price,
no, my lord. That is for general award. Before passing general award,
show me the provision under which you can form a committee under the statute.
the
And after he passes the award under section 29(2), then the matter will go to civil court if they are not satisfied.
my lord, the section 29(2) is not award, my lord. It is an offer under consent. If they don't agree, then only we pass general award.
Please read section 29(2) once again. The deputy commissioner is to determine the compensation if there is no agreement between the
That is
SLAO.
under section 29(3).
If there is no agreement between the SLAO and the
Land
loser, deputy commissioner is to determine the compensation.
Please, my lord, that is general award. 29(3) is general award.
If the agreement is by on the base of the rate fixed by the very deputy commissioner,
No, my lord, that is before referring to deputy commissioner.
How can the deputy commissioner then be the head of the committee before he decides?
My lord, that is when the passing in general award, not for consent award.
If he himself is the person to decide the compensation rate before passing an award, what is the point in him again passing an award? He's already decided what is the amount.
That will be, my lord, consent award will be decided by the HLA or not by the deputy.
If they don't decide, then only then DC comes into picture.
Please, my lord.
Here DC is the head of
No,
the.
no, my lord, before the DC comes into picture, HLA will offer an consent award.
ನೋಡಿಲ್ಲ committee ನೋಡಿ ಯಾರು head ಮಾಡ್ತಾರೆ ಅಂತ.
That is headed by.
Every committee that has been constituted for price determination is headed by the deputy commissioner.
Correct, my lord. That is to pass consent, general award. Consent award is offered by HLO, my lord.
Please look it up and come.
Please, my lord, in this case, there is an agreement between HLO and land loser.
ಇಲ್ಲ.
I have produced it, my lord.
You have taken that 4 acres, 4 lakhs in something.
7 lakhs.
Sir, even for that matter also, my lord, since there was a delay period with regard 7 years after the acquisition.
That is not your prayer.
Well, I have annexed one requisition or copy also, my lord, annexure. L, my lord, page 38. Similarly, personal place, they have been paid with the enhanced rate, my lord, on the same set of project by the UPCL only. ಇದರಲ್ಲಿ ಕನ್ಸಿಡರೇಷನ್ ಮಾಡಿ ಎಲ್ರಿಗೂ ಎನ್ಹಾನ್ಸ್ ರೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಈ ರಿಪಿಟಿಷನ್. Similarly placed, same project, but different village. 38, my lord. So there was a batch of petition, there was a compromise entered into between the KDB and, my lord, the same power project company. So saying that on account of the delayed process, they have enhanced the rate, my lord, because 7 years they did not pay anything. There was a last part, by that, my lord, the market value has been enhanced by this agreed rate of enhancement they paid to all the landowners.
What is the amount that they paid to others?
That ex gratia and sell per acre ಇಷ್ಟು ಅಂತ enhancement ಮಾಡಿದೆ.
This is the amount, my lord.
My lords, I have produced the minutes of meeting, my lords, wherein it shows that with respect to the compensation paid, my lords, it includes ex gratia amount also.
Where? Where have you said so?
In my statement of objections, my lords, annexure R1, my lords. Page number 8, my lords.
When did you file your objections?
Objections is filed on 11/6/2018.
Yes.
Annex
Where have you said?
R1, my lords,
This is
page
a joint
number
memo.
8, my lords.
May I pass on, my lord? On this resolution, they enhanced the compensation.
Please read.
My lords, last but one paragraph, my lord, ಮೇಲಿನ ಲೆಕ್ಕಾಚಾರದಂತೆ ಬರುವ ವ್ಯತ್ಯಾಸದ ಹಣವನ್ನು ಹೆಚ್ಚುವರಿ
R1.
ಪರಿಹಾರ ಎಕ್ಸ್ಗ್ರೇಷಿಯಾ ರೂಪದಲ್ಲಿ ಪಾವತಿಸಲು ಸಭೆಯಲ್ಲಿ ನಿರ್ಧರಿಸಲಾಯಿತು.
ಎಲ್ಲಿ ಓದ್ತಿದ್ರ annexure?
Annexure R1, my lords, page number 8. Respondent number 3 statement of
ಇಲ್ಲಿನ
objections.
ಲೆಕ್ಕಾಚಾರದಂತೆ ಬರುವ ವ್ಯತ್ಯಾಸದ ಹಣವನ್ನು
ಹೆಚ್ಚುವರಿ ಪರಿಹಾರ ಎಕ್ಸ್ಗ್ರೇಷಿಯಾ ರೂಪದಲ್ಲಿ ಪಾವತಿಸಲು ಸಭೆಯಲ್ಲಿ ನಿರ್ಧರಿಸಲಾಯಿತು. ಆದ್ದರಿಂದ
that
ಉಡುಪಿ
was 5 acres, 16
5 lakhs,
5 lakhs
16,000, my lord, per acre.
and what is the amount that you have paid him
7 lakhs 56,960.
at this rate?
Please, my lord.
No, not at that rate, my lord.
Then-
There is no calculation by them. Well, it has
Now
been-
will you get?
Well, because of the in the joint meeting, my lord, they have conducted a further meeting and they submitted a joint memo. By virtue of that meeting held between the KDB and the company, my lord, the ex gratia compensation amount enhanced to be paid to the landowner.
What is the amount?
Well, that is in their joint memo, they have to produce, my lord. So this some order is on the basis of it, this court so my lord, interfere in the matter and directed the KDB to pay the ex gratia compensation.
No, this particular annexure R1 is dated when?
2006, my lords. 21/12/2006.
And when was that joint memo?
4/11/2006, 21/12/2006.
It's a board resolution, my lord, 21/12/2006.
Same.
That is
So
what
they-
5 lakhs
5
16,000.
lakhs 16,000.
Annexure R2.
Well, they let them produce the
They
calculation.
produced it annexure R2.
Well, that's not, copy is not served on me.
I can't help it if you say now that copy is
ನನಗೆ
not
ಕೊಡ್ಲಿಲ್ಲ,
produced.
ನನಗೆ copy ಕೊಡ್ಲಿಲ್ಲ. I have to.
Receive ಮಾಡಿದ್ರು.
And my lord, and this, the Justice Byrareddy's judgment, my lord.
Received the copy.
So that they have, my lord, there is no calculation as such, my lord, with regard to the enhanced compensation amount, and my lord, pursuant to the direction given by themselves only, my lord, as per annexure page 21, they have not conducted any kind of procedures, my lord, nor called upon me with regard to this compensation issue is concerned. Because there is a direction, that is why I am before this court, this was not complied, this 2016 onwards. They have to notify me stating that by in pursuant to this compensation is paid. 13/3/2014 ನಂತರದಿಂದ ನನಗೇನು ಮತ್ತೆ ಕರೆಸ್ಪಾಂಡೆನ್ಸ್ ಇಲ್ಲ. They have to produce.
Paid to him?
Lord,
When was this money paid to him?
My lord, money was paid on 2nd May
13/5/14.
2014.
Second,
May 2014.
that is after Annex H.
Even after this order, my lord, this order is in 2012.
That, my
And
lord,
this is the,
my
they
lord,
have
kindly
entered
say-
into
my lord,
agreement.
to that, my lord, I have submitted the protest petition. My lord, I stated the reason, page 24. I have stated for what reason I have stated.
Once you take money by consent, no question of
No
reference.
question of.
Well, I have stated there, ಮೇಲೆ because
You may say so many things.
ಅಲ್ಲ ಮುಂದಿನ ಗವರ್ಮೆಂಟ್ಗಳ ಯಾವುದೇ ತಿದ್ದುಪಡಿ ಯಾವ್ದು ನಿಬಂಧನೆ ಒಳಪಟ್ಟು because there was pressure ಮೇಲೆ because I had been gone to the secretary of the government. There was a direction to implement their direction. They did it ಮೇಲೆ on protest. I accepted. Immediately.
Where have you accepted under protest?
Well, kindly see my page 24. I stated so.
Page?
Page 24. ತಾವು ತಿಳಿಸಿದಂತೆ ಈ ಎಲ್ಲ ಮೂಲ ಕೊಟ್ಟಿದ್ದು ನನಗೆ ಪರಿಹಾರವಾಗಿ ಸೊ ಬ್ಯಾಂಕಿನ ಪ್ರಕಾರ ಹೊಂದಿದೆ. ಆದರೆ ಈ ಕೆಳಗಿನ ಕಾರಣಕ್ಕಾಗಿ ಇದು ತಾತ್ಕಾಲಿಕವಾದ ಪರಿಹಾರವೆಂದು ತಿಳಿಯಬಯಸುತ್ತೇನೆ. ಈಗಿನ ಚಾಲ್ತಿಯಲ್ಲಿ ನಡೆಯಿರುವ ದರಕ್ಕಿಂತ ಕೊಟ್ಟ ಪರಿಹಾರ ಕಡಿಮೆ ಆಗಿರುತ್ತದೆ. ಕಳೆದ 7 ವರ್ಷಗಳಿಂದ ಜಾಗ ತಮ್ಮ ಹೆಸರಲ್ಲಿ ವರ್ಗಾವಣೆಯಾಗಿದ್ದು ಹಣದ ಬಡ್ಡಿ ಕೊಡಬೇಕಾದ ಪ್ರಮೇಯ ಇದೆ. ಜಾಗದಲ್ಲಿ ಮರಮಟ್ಟುಗಳು ಅದರ ಲೆಕ್ಕ ಪರಿಹಾರ ಮಾಡಿಲ್ಲವೆಂದು ಕಾಣುತ್ತದೆ. ಇನ್ನು ಮುಂದೆ ಮಂಡಳಿ ಹಾಗೂ ಸರ್ಕಾರವು ಭೂಮಿಯ ದರದ ಕುರಿತು ಮಾಡಬಹುದಾದ ಬದಲಾವಣೆಗಳಿಗೆ ಹಾಗೂ 1/1/2014 ಜಾರಿಯಾದ ಭೂ ಸ್ವಾಧೀನ ಕಾಯ್ದೆ ಪ್ರಕಾರ ಹೆಚ್ಚಿನ ಪರಿಹಾರಕ್ಕೆ ಅರ್ಹನಾಗಿರುತ್ತೇನೆ. ಆದರೆ ಪರಿಹಾರ ಮೊತ್ತವು ಬಹಳಷ್ಟು ತಡವಾಗಿ, ಅಂದರೆ ಸರ್ಕಾರವು ಸ್ವಾಧೀನ ಪಡೆದಿದ್ದರಿಂದ 7 ವರ್ಷಗಳ ನಂತರ ಪಾವತಿಸುವುದರಿಂದ ಸದೃಢ ಭಾರತ ಸರ್ಕಾರವು ಇತ್ತೀಚೆಗೆ ಜಾರಿಗೊಳಿಸಿದ ಹೊಸ ಭೂ ಸ್ವಾಧೀನ ಕಾಯ್ದೆಗೆ ಅನುಗುಣವಾಗಿರುವುದಿಲ್ಲ ಹಾಗೂ ಈ ಹೊಸದ ಕಾಯ್ದೆ ಪ್ರಕಾರ ನಾನು ಇದಕ್ಕಿಂತ ಹೆಚ್ಚಿನ ಪರಿಹಾರಕ್ಕೆ ಅರ್ಹನಾಗಿರುವುದರಿಂದ ಈ ಹೊಸ ಕಾಯ್ದೆಯ ಅನುಸಾರ ನನಗೆ ನ್ಯಾಯಯುತ ಪರಿಹಾರ ವಿನಂತಿಸುತ್ತೇನೆ.
After accepting the consent award.
My lord, because of the protest, my lord, I say I accepted, my lord. Then immediately I submitted. Because of the protest, I am accepting it because there was some pressure to receive this amount. I am not so, my lord, I have not stated so because that is why I immediately submitted the protest. And subsequent to this.
One thing, you give back the amount. I'll ask him to give the land back to you because either way the company didn't want the land. You can sell it for good price now. They didn't want the land.
I have stated.
They did not want the land
No,
only because
because the entire land in the.
you were a senior citizen.
Yes, my
Even
lord.
though they didn't require the
No, my
land.
lord, because he has categorically stated now that, my lord, the remaining entire extent it is in their compound. My lord, I am not in a position
Ask
to
him
do
to give it
anything.
back.
It's a
Don't
company, it's a chemical company. I cannot do anything, my lord. See, even if it is a de-notify and give it back to me, I cannot even sell the land because the factory area, industrial area is a power corporation.
You should not have accepted that 5,16,000.
That-
You should have said, I will not receive 1 paisa of yours, send it to the civil court.
Well, that should have been done, my lord, because he is a retired person, my lord. So they have stated that, well, they will consider the issue. Let them consider, my lord. That is my, I want the order from your lordship to that extent. Let them consider
Where?
that issue.
You tell me where they said they'll consider. This
Well,
is after you see.
Well, they say that, my lord, the remaining entire extent of area, my lord, it remains to be in their possession.
Concern you. You're only considered 1 acre 66 cents.
Well, 1 acre 66 ಅದಕ್ಕೂ ಮಾಡಿದ್ರು ಕೂಡ ಅದಕ್ಕೂ ಕೂಡ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ದೇನೆ.
You have anything to show that this more than 5,16,000 was paid to anybody else under the same notification?
Well, that is not my case. Well, more than my claim amount, it is not paid to others. It's not a issue before them. My issue is, my lord, since apart from 166 acres of land, now if they go and denotify stating that it is not beneficial to us,
Show me.
I'm not in a position to enjoy it.
Suppose something in your writ petition that apart from 1 acre 66 cents, you own some more land, 184/3, and that is in their possession. I will consider.
Well, that is why joint survey was conducted and they themselves have
The joint
admitted.
survey, it is indicated only 1 acre 66 cents. Show me from your petition. Even in this letter of page 24, there's nothing indicating there was something more than 1 acre 66 cents.
Well, even your lordship taking into consideration 1 acre 66 cents, my lord. So even as per their own guidelines, after the subsequent developments, I am entitled for better compensation amount. That is
Show
also
me-
not considered.
Show me from which guidelines?
Well, that is their scheme is there. That's why this honorable court passed a similar type of orders may have produced in this writ petition. It's Justice Bhaira Reddy's order. Same notification, the different villages.
What has he said?
Well, kindly see, the learned counsel for the KDB would submit that the petitioners have never approved the KDB insofar their compensation is concerned.
You have been
Mal-
paid compensation. That
No,
was
no,
the
no.
case in
Mal-
which
It
compensation
was the case of the petition, paragraph number, page number 42, my lord. It was also the case of petition in WP so and so that their land had been acquired by the for the benefit of KDB and has been transferred to Udupi Power Corporation, formerly Nagarjuna. Several other lands apart from the same had been acquired by the state for similar purpose in the same area under very same notification, and compensation had also been determined by the KB by negotiation with the landowners, and the same has been paid to them. The KDB has passed a resolution to make certain ex gratia payment to the petitioners and also similarly placed other persons whose land have been acquired, and though the ex gratia payment was to be paid by the Udupi Power Corporation was initially denied on the ground that there was financial difficulty. Pursuant to an interim order of this court dated so and so, the matter was further negotiated and a joint memo was filed by the KDB as well as Udupi Power Corporation undertaking to make such payments.
That was the resolution that they referred to.
By
From 4 lakh and not the increase to 5,16,000. That is the resolution that is passed. And that is what you accepted.
well, one acre 66 cents per acre ತಕೊಂಡು ಸಮೇತ ಈಗ ಅವರು 4 ಇಂದ ತೆಗೆದುದನ್ನು 7 lakh ಮಾಡಿದ್ನಲ್ಲ. I will produce that resolution. They are meeting also subsequent convened meeting DC. They have referring to the old joint memo. There was a meeting convened by the deputy commissioner in respect of very same project with regard to the dry lands, with regard to the fertile lands. He has been NSML. I have produced in some other connected petitions. I will secure that. If you may go through that document, if I am entitled to under that notification and meeting.
Resolution?
No.
Yes, I will produce that.
It's only one.
I will produce that. I will produce the subsequent.
Impose cost
Well,
on that day.
my effort.
No,
My effort.
You are being very casual. I have something, you go through it, then let us see.
My lord, the retired army person, he is making his endeavor
I'm
before
listening
the
to him.
court, my lord.
Therefore, I am listening to this so patiently. Day after tomorrow.
Well, day after tomorrow, next week, papers there, ನೋಡುತ್ತದೆ 22 my lord, 22nd.
Lord, in the similarly placed petition, my lord, this another court has dismissed the petition.
ನೋಡ್ಯಾರ ಅದೇನೋ
Same set of facts. my lord.
senior citizen ಅಂತಾರ.
Please, please.
Serial number 14.
22nd, my lord. 22nd.
Monday ಯಾವತ್ ಬೇಕು? Next week.
After Monday.
Date ಕೊಡಿ.
Serial number 49.
ಯಾವ್ದು? Serial number?
Serial number 49, my lord. 49, it could be disposed of, my lord, is covered by judgment of this court.
49 of? Monday first list.
List 1, my lord, 49.
ಕೊಟ್ಟಿಲ್ಲ, date ಕೊಡ್ತಾರೆ.
Lordship kindly, my lord, serial number 47 in first list, there is some serious urgency, my lord, it could be taken tomorrow, my lord.
Date is already given. You should mention it at 1:30.
Just have a look at the operative portion. Operative portion only.
No, the entire judgment is here, but and it needs to be digitally signed. Therefore, if you want, the original is in the chambers, but this is a copy.
I'll come and
Give
have
you
a
the
look
same.
at the operative.
Just 49.